right. We will get underway. Good afternoon. This is the House Judiciary Committee. It's the 11th of February, 2025, a little after 1. We're going to start with the Attorney General here in House Bill 604. Tammy Bresnahan. Okay, some people are coming up. That'll be fine. And Robert Doyle is on, or was on a moment ago from NARFE. I wasn't supposed to say it that way, but okay. Mr. Attorney General, you get 3 minutes to speak.
And that was my question, whether I'm on the clock. Okay.
We got everybody on the clock today.
Excellent. Thank you, Mr. Chairman, members of the committee. I will breeze through my testimony. I want to thank you for the opportunity to testify in support of House Bill 604. This is a priority bill for the OAG. I thank you because certainly during the 2 years as Attorney General, you have given the Office of Attorney General, the Medicaid, fraud, and vulnerable victim units more tools to do our job. Our job is to protect vulnerable Marylanders, as well as defending against fraud against Medicaid program. Today, we're talking about vulnerable victims. House Bill 604, it is about trust and accountability. I've got written testimony that I've provided, so I'm going to sort of just speak off the top of my head. I'm not even going to refer to my notes. This is what we've got here. Under Maryland law, under Maryland law, if I'm a caregiver, okay, of a vulnerable adult, and those are defined in law, for me to be held liable for depriving that vulnerable adult of their property, my Medicaid fraud team would have to show deception, threat, or manipulation. Now imagine the scenario where, as the caregiver, I'm in a trusting relationship with a relative, and my relative has a bank account that I have access to. And I then use those funds not for the purposes of my relative who is a vulnerable adult as defined in law, but I siphon it off for my own purposes. And I deprive that relative who trusts me of their property. Under the law today, I have to prove deception or threat, but there is none there. It's a trusting relationship. Our bill, using the definitions in law for caregiver, the definitions in law for vulnerable adults, the definition in law for what it means to deprive someone of property, this bill says you don't have to demonstrate fraud or deception. You just have to demonstrate that the caregiver deprived the person of their property. It's a term that's defined in the law. It's a term that has been interpreted and applied by courts for years in Maryland and other contexts. And what this bill does, it reflects the General Assembly's already efforts to make sure we do that much more for vulnerable adults. Where have we done that? In the case of threats. There is a separate crime. In the case of theft, there is a separate crime for abuse or neglect of a vulnerable adult. There is a separate crime for financial crimes against vulnerable adults, because these separate laws reflect your understanding that crimes against vulnerable adults are distinct from ordinary theft or assault. And I'll end with this note and why this is so important. When I take that caregiver to court today and I get a conviction or a plea for theft or assault, that person can continue to practice as a caregiver in a nursing home or another facility. Under this bill, when you pass it, when I get that conviction, not only do they get the penalties under the law, but they are now going to be barred from practicing as a caregiver, and we're going to remove that. So with that, Mr. Chair, members of the committee, I urge a favorable report on House Bill 604 with amendment.
Thank you, Mr. Attorney General. My homage during your remarks was, of course, to my predecessor as chair, who used to tell people to just speak from the heart. And I thought you'd appreciate that as the Attorney General used to sit in this room.
You don't say in the committee what your predecessor also said was, that's a good bill, and I think it needs a little bit of work.
I would never do that. Who would like to go next?
Good afternoon, Mr. Chairman and distinguished members of the committee. My name is Zach Shirley, and I'm the Chief of the Medicaid Fraud and Vulnerable Victims Unit in the Office of the Attorney General. This afternoon, I'm going to focus on the importance of the proposed amendments to House Bill 604. These amendments are essential to achieving the goal of the Attorney General just described, to recognize and protect the inviolable trust relationship that exists between a caretaker and a vulnerable adult. The most important distinction between House Bill 604 as written and as amended is this. As written, House Bill 604 creates a new form of the crime of theft. As amended, House Bill 604 simply alters the requirements for the existing crime, financial crimes against vulnerable adults, which is a crime of fraud, or in this case, exploitation. That's important because in the example the Attorney General provided, the theft is complete when he obtains the funds from his relative. We don't need a charge that's more complicated to punish that action. What we want to do is charge a theft crime and an exploitation crime. This allows us to charge two crimes because two wrongs were committed. It's wrong to steal, so we charge theft. It's also wrong to exploit the trust of a vulnerable adult in your care, so we charge financial crimes against vulnerable adults. Second, broadening the net for financial crimes against vulnerable adults makes excluding offenders from the healthcare system in this state more efficient. The U.S. Department of Health and Human Services maintains a database of individuals who have been convicted of certain crimes, and those individuals are excluded from participation in state and federally funded health care programs like Medicare, Medicaid, TRICARE, and the VA. And just to point out, in long-term care, that is the primary source of funding. So a person convicted of one of these crimes will have a very difficult time finding employment in the long-term care system. A conviction for the crime of exploitation carries a mandatory exclusion of 5 years. So to summarize, as written, we're only able to address one wrong. As amended, we can address two. House Bill 604 allows the state to prosecute both theft and the violation of a trust relationship, and that's the goal of this bill. For that reason, I urge a favorable report on House Bill 604 as amended.
Mr. Chairman and distinguished members of the committee, my name is Kelly Casper, and I'm an Assistant Attorney General in the Medicaid Fraud and Vulnerable Victims Unit of the Office of the Attorney General. I want to discuss how House Bill 604, as amended, can assist the prosecution of caregivers who steal from the elderly and the vulnerable people that they care for. Recently, I prosecuted a case of State of Maryland versus Brittany Payne. Ms. Payne was a licensed geriatric nursing assistant, and while working at an assisted living facility, stole the debit card of one of her patients from the nightstand of her room. The victim was 78 years old, had had a stroke, and had mobility issues. Ms. Payne used the card to make thousands of dollars worth of online purchases over a 2-week period. Unfortunately, I was unable to charge Ms. Payne with financial exploitation of a vulnerable adult, as no deception, intimidation, or undue influence was used. Ms. Payne was ultimately charged and pled guilty to a theft charge against her. Sadly, a simple theft on Ms. Payne's record will not prohibit her from acting as a caregiver. In fact, at the time this offense was committed, she already had a theft on her record and was hired anyway. House Bill 604, as amended, would permit prosecutors to seek financial exploitation offense in addition to a theft offense, thereby punishing the stealing and recognizing the significance of exploiting the caregiver relationship. Therefore, for these reasons, we would request a favorable report of House Bill 604 as amended.
Good afternoon, Mr. Chair and members of the House Judiciary Committee. My name is Tammy Bresnahan. I serve as the Senior Director of Advocacy for AARP Maryland. As you may know, AARP Maryland is the largest membership-based organization. We carry over 850,000 members, and I'm pleased to be here today on their behalf. AARP has long advocated for policies that safeguard the financial security and well-being of our older adults. Our policy calls for strengthened protections against financial exploitation and abuse, including holding those who take advantage of vulnerable adults accountable under consumer protection laws and under the Maryland state law. AARP believes that individuals should be able to age with dignity and without fear of being taken advantage of by those who they trust the most. As you know, vulnerable adults, whether elderly, disabled, or otherwise unable to advocate for themselves, faced heightened risk of abuse and neglect and financial exploitation. It's very sad. Research consistently shows that financial exploitation can lead to severe consequences, including destitution. The provisions of House Bill 604 will give the Attorney General's office another tool in the toolbox. This came to our attention a couple of years ago out of Montgomery County when we visited the state's attorney's office, and they had a wall full of people who were caregivers, a wall of caregivers who had taken debit cards, who gotten a hold of checking accounts, who'd taken credit cards, who charged their daughter's wedding at a very exclusive hotel, who had bought cars, houses. I mean, this is incredible that we couldn't charge theft for that. So we applaud the Attorney General for bringing this bill forward, and we ask you for a favorable report on House Bill 604. Thank you.
Thank you very much. We have two other people who are going to testify on these bills, including one person who's virtually. So I'm just going to take questions for this panel first, and then we'll bring in the next panel after that. We'll start with Delegate Erica and make our way around.
Thank you very much, Mr. Chair and panel, for being here. Just a clarifying question. I think the substance of the bill is really laudable, and thanks for addressing it. I saw down on page 7, you guys have a carve out kind of for family. My concern was what happens if, you know, that's the child of the person, they're the caregiver. Mom says, sell my car. We sell the car. Mom says, I don't remember telling you to sell my car. You know what I mean? How are we protecting against, because some of these people really have dementia. They are quite forgetful. I mean, it's really sad. So how do we protect the family members who are really doing the best they can to navigate these situations, make sure they don't fall into this sort of criminal web?
You want to answer that?
Certainly. So in that situation, this is not just an on-off switch, right? We investigate a case extensively before we would ever bring charges. So in the situation that you described, we're going to recognize that we don't have all the facts, and we're going to talk to people. We're going to figure out what happened. Then, if charges are appropriate, we'll bring them. If not, we won't.
Okay, so it's up to sort of your discretion whether or not, because some of these things, as you know, can get super contentious where the child that's named the caregiver, there's a lot of animosity towards that person from the additional siblings, family members. They're very bothered by who the parent chose ultimately to care for them. So I just have a nightmare scenario where other siblings are like, oh, she's stealing mom's car, even though the child is trying to use the money to pay for care, et cetera. I just wouldn't want to see that is already a civil situation that's going to end up in court. I wouldn't want to see criminal charges tacked onto this caregiver because everyone in the family is angry that that was the person that mom chose to care for her, essentially. So you feel your office would be able to really discern a case like that and be able to bring charges only in situations where there was true fraud going on.
Delegate, I can assure you of that. The situation that you're describing is one that we experience on a regular basis. We get a lot of complaints where it's one family member talking about another family member.
Yeah.
Like I said, we're aware of it. We see that.
Okay.
And it's not unfamiliar to us, and we pretty quickly figure out what's happening.
Okay, all right, I appreciate you. Thanks for bringing the bill.
Delegate Taylor.
Thank you, Mr. Chair. And thank you, Mr. State's Attorney. I'm a home care owner. I'm sorry, did I say State's Attorney? I'm sorry, that was a long time.
Thanks for the promotion.
My apologies. My husband and I own a home care company. I've been in the business for about 30 years. And, you know, thank you for this bill. We've seen some really, over the years, the workforce has really changed. And we've seen we still have some great, you know, caregivers, but there are some bad apples. I'm concerned, though, about my agency that's 85% Medicaid. And are there any protections built in here, or should there be, for the employer of that employee that's being held liable for fraud or stealing or whatever?
So the exclusion only applies to the convicted individual. So once we obtain a guilty verdict or a plea by that provider, that home health aide, he or she will be reported to HHS for exclusion. It doesn't come back to the company unless the company is somehow involved in fraud or exploitation.
Sure, and our companies, thank you for that. And, you know, all of us are mandated by the state, if you're a Medicaid provider, to provide abuse and neglect in services once or twice a year. So thank you for this. Appreciate it.
Delegate Williams.
Okay. Thank you, Mr. Chair, and thank you, Attorney General, for being here today, for bringing forth this really important bill. I don't know if you had a chance, the Judiciary submitted a letter in opposition. They had a concern about the classification of a vulnerable adult as being someone of the age of, think of 68. I don't know if you've had a chance to review the letter, if you have any comments with regards to that, but they felt like it would be hard for them or be in a position to determine the mental and physical fitness of every witness based solely on their age and not based on the facts.
Let me just answer that by saying we're certainly willing to work with the committee, but vulnerable adult is already defined in statute. That age is already in statute, so we're not making it. I assume that when the General Assembly considered the definition, you took into consideration all factors. But if the committee wants to revisit the definition of vulnerable adult, particularly as it pertains to age, we're more than happy to work with the committee on that.
Okay. I'm just playing the role of my good friend, Delegate Kaufman, who normally would ask these questions, but is waiting for his bill hearing, so thank you.
Delegate Conway.
Thank you, Mr. Chairman. Thank you, panel, for coming in and testifying. In reference to caregiver that was hired, that was your record. If the company knew that, the company would also be partially responsible. Isn't that correct?
I don't believe so. As a matter of fact, I think that having a theft conviction that isn't, in this case, no, we did not go after the company, if that's what you're asking.
But then that was your choice, right?
Yes, but it wouldn't be a criminal offense to hire someone with a theft conviction. It wouldn't be a separate criminal offense to do that. In fact, it happens quite often that we see caregivers with just simple thefts on their record, shoplifting.
No, my question was, if a company knows that they're hiring someone that has theft on their record in this sensitive kind of situation, they take on partial liability for something that happens. Would that be correct or not?
No, I don't think that's accurate.
don't think that's-
Delegate, no, I don't think that's accurate.
Okay, send you a letter on it. Thank you.
You want a letter?
I'm gonna send you a letter.
Oh, okay, send me a letter, okay.
No further questions for this panel. Thank you very much.
Thank you very much, Mr. Chairman. Thank you.
Going to go down to Anson, come to the table. Mr. Doyle is virtual. We'll hear first from Mr. Enton for 2 minutes, and then we'll hear from Mr. Doyle, okay? So,
Thank you,
Mr. Enton,
Chair.
please, go ahead.
Thank you very much. Mr. Robert Enton, on behalf of the Maryland Bankers Association, we are signed up favorable with amendments. We've reviewed the amendments from the Attorney General's office, and we're fine with the bill with those amendments. We think it's a very good bill, and we're fully supportive of the amended version.
Mr. Doyle, if you'd like to go forward for 2 minutes. You have to take yourself off mute, though. There we go.
There you go. Sorry, I thought that was at the person at your end did it. Thank you very much.
Sadly, not a service we provide. Sorry about that.
Okay. That's right.
Go ahead.
I'm Bob Doyle. I'm the chairman of the State Legislative Committee of Maryland Federation of NARF, but NARFE is fine. It's National Active and Retired Federal Employees, representing about 317,000 employees and annuitants in Maryland. And we very much thank Attorney General for requesting the bill and Speaker Jones introducing it. And we, with our partners of ARP, we are asking for a favorable report on 604. I looked back at some data on this problem to help me research this bill, and I got some fairly recent data from the FinCEN, the Financial Crimes Enforcement Network, some staggering numbers which were staggering to me. In the year period ending June 24, there are over 31,000 elder theft reports and about almost $100,000 per incident. And I'm very struck by the Attorney General's characterization of the trusted relationship. This is not an elder scam where there's no relationship between the scammer and the victim, but this is a elder theft. It is a personal, trusted relationship between the person doing this and the person who gets victimized. I also found, not surprising, but it's mostly adult children of older parents who do these things. Even makes it even more terrible. Anyway, the elder theft is done fairly straightforward. It's not the sophisticated schemes of the scammer, so very tough for people to evade sometimes. But we certainly appreciate all the amendments and the strong penalties here. And as a powerful weapon against elder theft, we applaud the introduction of HB 604 and again ask for a favorable report. Thank you very much. Also appreciate the chance to change my testimony to virtual. I guess it's not snowing yet, though.
Not snowing yet. Delegate Phillips with a question, please.
Thank you, Mr. Chair, and thank you to our panelists. Mr. Enton, you mentioned amendments, but I don't know, did we hear what those amendments were?
I don't know. The amendments were presented. The bill was heard in the Senate. And the bill, I forget how many pages long it is. It's basically now been limited to increasing and addressing the criminal side. The original bill is drafted, and I know the Attorney General, he and I discussed this at length. The bill as drafted was not what they presented. For some reason, the bill drafting went way beyond it. The bill that you have, the amended version, is just straightforward. It makes it a broader crime. And with that, we're totally supportive of that. And if you don't have a copy, I'll be glad to email it to the committee. But I would assume you would have had a copy by now.
We'll certainly make the copies of the AG's amendments available to the committee. Any further questions? All right. Seeing none, thank you very much. That concludes the testimony on House Bill 604. And now we're going to have two bills from Delegate Kaufman, including House Bill 674. And we have some people, I think, who are here. Come on up. Some people who are here, some people who are virtual. Jamie Sterling is virtual. I think Debbie Feinstein is virtual. I see Mr. Schellenberger. I think Ms. Braveboy is virtual.
I believe so, Mr. Chair.
And Sergeant Schwab is here.
No,
right.
I'm missing Mr.
So we're going to try and get the state's attorney from Prince George's County. And there is Mr. Sterling from St. Mary's County.
Colleagues, while we're waiting for Ms. Braveboy, take your pictures. State's Attorney Schellenberger and I agree on something.
That's the third time this year that I've surprised everyone.
Yeah, full of surprises.
All right, we have everyone. Mr. Kaufman, Delegate Kaufman, whenever you're ready to go, you have 3 minutes.
Thank you, Mr. Chair. Thank you, colleagues. For the record, my name is Delegate Aaron Kaufman, representing District 18 in Montgomery County. I'm asking for a favor report on HB 674, criminal law, concealment of death, and disturbing and dismembering human remains. This bill is cross-filed with Senator Jack Bailey from St. Mary's County. This bill was brought forth to me because of 6 cases of dismemberment and cover-up in St. Mary's County, but it really is a statewide issue, as evidenced by the fact that Jamie Sterling of St. Mary's County, she's the state's attorney, she supports it. My state's attorney, Mr. McCarthy, supports it. State's attorney Braveboy from Prince George's County supports it, and Mr. Schellenberger also supports it. I also appreciate the bipartisan support of the bill, as Delegates Chris Tomlinson, Todd Morgan, and Susan McComas have signed on as co-sponsors. I would introduce this bill as the dismemberment of bodies, as deplorable as it is a growing problem, and these crimes are very heinous. HB 674 would provide for criminal penalties for individuals who intentionally conceal the death of another and willfully dismember, destroy, remove, or otherwise obliterate by any means a portion of human remains. The bill also prohibits an individual from disposing of a dead body or failing to report or contact lawmakers when they see a dead body, as it is deemed an attempt to conceal the death. This bill also prohibits a person from aiding or abetting in the dismemberment of someone. Section 5-514 of the Health General Article prevents an individual from burying or disposing a body except in certain locations, for example, a family burial plot or a cemetery. The current maximum penalty is a paltry $5,000 fine and a year in prison. This is not a sufficient penalty for such a serious crime. Violent criminals need to be held responsible for their actions. This bill, once passed, would increase the penalty to 10 years in prison should a person be found guilty of the crime. HB 674 addresses the murderer, what the murderer does with the body, and any accessory, and it also deals with what happens when a murder from out of state a body is dumped in one of our jurisdictions. Dismembering a body destroys evidence and makes recovering a body more difficult, and it also makes it more challenging to identify the perpetrator. When bodies are dismembered, the cause of death can be indeterminate, and it is a deterrent to holding violent criminals responsible for their actions to the fullest extent of the law. Again, I ask for a favorable report on HB 674. Thank you very much, Mr. Chair.
Thank you. Good afternoon, Mr. Chair, committee. Scott Schellenberger, State's Attorney for Baltimore County, in favor of HB 674. So please take a look at my written testimony. But in July of 2021, a police officer pulled over a car and began to search the car lawfully. And eventually he smelled a very strong odor coming from the trunk of the car. When he was able to move some blankets around, he discovered the bodies of a child, a female who was 7 years old, deceased, and a second deceased child who was 5 years old. They had been there so long, unfortunately, there were maggots on the bodies. They were severely decomposed, and while the medical examiner was able to say homicide, they weren't able to say much more than that. And therefore, we ended up using a very specific statute that exists for children, and that's 2 counts of child abuse resulting in death. You'll be pleased, I believe, to know that yesterday the individual was sentenced to 50 years in jail for having done this. Had these 2 been adults, we would have had a much more difficult time, because the adult's crime, we might not have been able to prove the nature of the murder, and therefore we kind of had a hole in the statutes. So that's why we want HB 674, is to fill that hole, is to say, look, if you dismember or dispose of a body improperly, it needs to be, and you were involved in their death, then it needs to be something more than a 1-year penalty, as Delegate Kaufman indicated before. As I indicated today, making it a 10-year felony makes it more appropriate for the type of people that we are taking a look at. We had a very good hearing in the Senate last week, and I urge you to vote favorably on this.
Good afternoon, Mr. Chairman and members of the House Judiciary Committee. I am Sergeant Roger Schwar with the Maryland State Police Homicide Unit. I'm here today to talk to you about a case that I investigated that led up to the introduction of this legislation. The case began on December 21st, 2022, when 50-year-old James Dvorak was reported missing by his family at the Leonardtown Barrack. The suspect, Michelina Goodwin, was his on-off girlfriend, but they were having issues. They lived together at Goodwin's residence along with another male roommate, Larry Murphy. Over 2 weeks of investigations included multiple search warrants, and interviews by MSP investigators yielded a confession by Ms. Goodwin. During the interview, Ms. Goodwin claimed that on December 11th, Dvorak was beating Murphy up, and she grabbed the shotgun she claimed she did not know was loaded. She tripped over her dog and accidentally shot Dvorak in the back. Mr. Murphy claimed he was outside the residence when the shooting occurred. Goodwin confessed to dragging Dvorak downstairs and keeping him in the laundry room for several days until he started smelling. She got nervous as people were looking for the victim. She purchased a chainsaw, and with the assistance of Murphy, a chainsaw was used to dismember Dvorak. Parts of his body were loaded into multiple bags and chests for easier transportation. Portions of the body were dumped and burned in Charles County, and the remaining parts of the body were buried in St. Mary's County. Sadly, the only charge in reference to the hiding, dismembering, burning, and moving the body was a one-year misdemeanor for disposal of a body in an unauthorized location meant more for cemeteries. Dismembering a body destroys evidence and makes recovering all the body more difficult. The dismemberment and treatment of the body was horrific and created tremendous heartbreak and emotions for the family as the body was scavenged by animals. MSP has handled several cases, 3 just in 2024 alone, spanning across the state that would fall under this proposed bill. Thank you for your time.
All right, State's Attorney Braveboy, please.
Thank you very much. Good afternoon, Mr. Chair, Madam Vice Chair, and esteemed members of the House Judiciary Committee. For the record, I'm Aisha Braveboy, State's Attorney for Prince George's County, here to speak in favor of House Bill 674. On July 29th of 2023, a horrific crime occurred in Prince George's County. A teacher went missing. And I know that date so well because it happens to be my birthday, and I got a call. That teacher went missing, and about a week or so later, her body was discovered dismembered in the southern part of Prince George's County. It was a horrific sight and scene. This is someone who was beloved by her community and beloved in our county and amongst our children. I'm personally prosecuting that case later this year, and we are I hear something in the background. Okay. We are prosecuting this case later this year, and we are really focused on getting justice. But as we've gone through this case, some of the challenges obviously have been, cause and manner of death, especially because the body was dismembered. And oftentimes, those who want to conceal their crimes will dismember a body. It's not necessarily common, but it's not uncommon either that people will want to do that, which makes it very difficult oftentimes to get an autopsy that has the evidence that we need in it to prosecute cases. And so we are very interested in this bill because we want there to be a deterrent for dismembering bodies. We also recently won another conviction against an individual who dismembered her mother's corpse, and it was very, very sad. So thank you very much.
Thank you. State's Attorney Sterling, please.
Thank you for the opportunity, and thank you for Detective Schwarb, who outlined the case that really became the idea for bringing this bill together. We have some other new cases. Currently, I have a pending investigation where we located a teenager deceased in a trash can. I can't talk too much about that because it has just occurred. But the example that Detective Schwarb just gave, one of the things that the victim, the daughter of the decedent, had told us is that the area in which a portion of her father's body was discarded, she has to drive by that area every day. And it's just a horrible thing when someone is murdered, but in addition to dismember portions of a body so that it can conceal the death, it does make the homicide trial much more difficult to prove the motive. In a lot of these cases, the best that we can do is get a second-degree murder. And really, the punishment is not just for the murderer, it's for the person who assists in the concealment. So this will affect prosecutions for the murderer, who is also the concealer of the death, but also the person who we believe might have been an accomplice to the murderer, but we can only prove that that person helped conceal the death. And of course, there are instances like in this case where there was the non-murderer who we believe is only the concealer of death. The reason why the felony is critical is because in these cases, it's very difficult to locate the body or to have that person identified, but usually we can't do that within an appropriate statute of limitations because of the way that the bodies are found. St. Mary's has certainly multiple other examples. I have reached out to my colleagues, and I have examples from Baltimore City, Baltimore County, Prince George's, Montgomery, Carroll, Calvert, Somerset, Dorchester, Wycomico, Worcester, as well as Talbot. And those are just the ones that responded. Thank you.
Ms. Feinstein?
Good afternoon, Chair Clippinger and members of the committee. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I am also co-chair of the Maryland State's Attorneys Association's subcommittee on special victims cases, which elder abuse cases, vulnerable adult abuse cases are included. The example that I want to highlight today relates to the neglect of a vulnerable adult by his adult son. In that case, police were called after relatives had not heard from this individual for many months, and they were getting increasingly concerned. This was early days of the pandemic. They hadn't seen him, they hadn't heard from him, and ultimately a search warrant was authorized, and detectives went into the home and discovered the body of the deceased in a very advanced state of decay. I had the opportunity to go and to describe to you what I saw and smelled on that occasion is really, frankly, indescribable. And the decedent was actually located partially under a dresser in his bedroom. And when the autopsy was performed on the decedent, it was very difficult to know the exact cause of death because of the delay in time in the police discovering the body. What was particularly disturbing about this case was that the defendant was still living in the house with his father's deceased body. There's clearly some other issues going on, but he was lying about the whereabouts of his father. So no one knew. The body decayed. We were unable to get the best evidence we wanted to get. Fortunately, because, and there's really nothing fortunate about the situation, but as Mr. Schellenberger described, because the son was a caregiver and a relative, we were able to proceed under the neglect of a vulnerable adult statute. We also charged under the 1-year concealment of death charge, or the not disposing of a body properly charge. But at the end of the day, our evidence was weak. This charge would make a direct path to hold the offender accountable in circumstances like I described. Thank you. I urge a favorable report.
All right. Are there any questions for this panel? Delegate Moon.
Thanks, Mr. Chair. I almost was going to skip this question because the last comment maybe kind of answers it, but I guess I'm just trying to understand in practice with the actual cases you're seeing, what the actual effect of the bill would be. Is the likely impact for most of these cases that it's an additional charge, an additional crime that you would be able to win? Or as to the last example here, do we actually have a lot of people where we have a suspect for a murder and we have a body that's clearly been mutilated or what have you, allowed to decompose, and those people are not actually getting convicted for that more serious offense? Is that a common occurrence?
The answer to that is yes. Because the more that the body is decomposed, the less likely it is that we can prove manner and cause of death. And because of that, this will give us an extra tool to fill a gap. I don't foresee it as being an additional count. I wouldn't see murder 1, murder 2, manslaughter. Oh, and by the way, we're going to add concealment of death and disturbing. I see this count happening by itself when we can't prove the murders and the other ones. And that's why I feel like it fills a rather large gap. A gap that in ways you all have filled with the child and some others, but this one needs to be more general.
I understand what you think is going on in the real world here. There are people who are found, suspects for murder, found with the body dismembered, and you're having to come up with middling other charges because you can't prove the murder. And this is happening not just as an outlier case in whatever, Montgomery County.
Well, I think you heard Ms. Sterling mentioned a number of counties, and I'd be happy to defer to her to let her remind us of what other jurisdictions had this problem.
Thank you.
Sterling, if you want to respond.
Thank you. There are some instances, I'll give you an example from a neighboring county where there was a child located probably 20 years later in the freezer. And what the lady had indicated was that her husband, who was now deceased, was the one who murdered the child, and that she had just not told anyone. And so in that instance, the only proof you would have is just her own confession. And based upon her confession, she was not the murderer. Her deceased husband was, but she was the one who continued to keep the body hidden in the freezer. So that's one of the examples. But we have examples. I was actually shocked. I had 5 cases in St. Mary's that spanned in the last 30 years or so. I was shocked to see the response from my colleagues all over the state. And a lot of these are much more recent. And so there are a lot of examples. It's not just an outlier case.
Williams?
Thank you, Mr. Chair, and thank you, Delegate Kaufman, for bringing this bill. Sort of piggybacking a little bit on what Delegate Moon was stating, I was looking at the letter from the Office of the Public Defender, and it seems that they have concerns with this bill, one of which is that this would create a new felony conviction, sort of equivalent to, and I guess State's Attorney Schellenberger, you might have sort of answered this question with your response as to one, why does this need to be a felony subject to a 10-year statutory maximum penalty? It just seems a lot.
Sure. So the reason that it's important to be a felony is because the statute of limitation on misdemeanors is 1 year. And if someone is purposely trying to hide a body, it may be several years, and as Ms. Sterling indicated, one of hers was 20, or one that she knew about was 20. The fact that a misdemeanor has a statute of limitations of 1 year would prevent us from even prosecuting the case. So that's the reason why it's a felony. And again, it's the maximum penalty is 10. It would certainly be in the judge's discretion as to how much of that should be given, and actually, it could be suspended down to 6 months if the judge saw fit under the facts and circumstances of the case. But it needs to stay a felony so we don't lose statute of limitations.
Thank you.
And
Delegate Kaufman.
Yeah, can I add something just real briefly? I have great respect for the Public Defender's Office. I've done bills for Ms. Hilliard. But I think it's also very important to know that in the 3 years I've been here, the Public Defender's Office has almost always come out against a penalty enhancement. And that's their policy, and I respect that. But to me, I would take their testimony with a grain of salt because they always oppose penalty enhancements. But I would also just like to say that, to channel our old friend Mr. Kroll, that well, of course we have to worry about constitutional rights. I would just say we also have to focus on the victims, as he used to say. And I just think 10 years is a lot, but I think the crime is so heinous that the people who are convicted by a jury of their peers for doing this deserve the lengthy sentence. And as Mr. Schellenberger indicated, it would be at the discretion of a judge. And also the Public Defender's Office seems to indicate that they are concerned about the job prospects of the felon. But I think my principal concern would be justice for the family, and I don't think that a year is sufficient.
Thank you. I see my state's attorney. She has her hand up.
State's Attorney Braveboy.
Thank you. Yes, and just piggybacking on Delegate Kaufman's point at the end, which is I wanted to bring up, is the victims. The next of kin to these victims, oftentimes, I mean, it's very difficult to lose a loved one, but to not really be able to bury them because their bodies aren't intact. You know, as you recall, because I believe this was in your district, Madam Sela, her body was dismembered, and her head was not found and other limbs were not found. And so if you think about the trauma that families have to go through either not knowing whether their loved one is dead or alive because their body has been concealed, or when they find their body, they can't even recognize them. They can't even properly bury them. I mean, this is, I just think that the seriousness of this type of offense should be reflected in the amount of time people are subject to. We hope that it does serve as a deterrent because killing someone is horrible. Dismembering their body is just unimaginable and unthinkable. And for the families, it's just completely heartbreaking.
Thank you. And I attended the funeral for Madam Seela, who was a very beloved teacher in my district at Robert Goddard. So thank you so much.
All right, seeing no further questions for this panel. Oh, I'm sorry, Delegate Tolles, I can't see because your water bottle's in the way.
Trying to
Go
stay
ahead.
hydrated. Thank you so much. Thank you, Mr. Chair. So, Mr. Schellenberger, my question was also on the lines of Delegate Moon, and you indicated, which let me just say, this is horrible. I'm grossed out. It sounds like this bill is definitely needed and something I could be in support of. I just had a question, and it's just a point of clarification. You indicated that this bill would be, because I was trying to figure out like the 10-year felony thing. So you indicated that this could be, you need a tool. So this tool could be in lieu of you actually having to, having the evidence to charge someone with some crime.
Yes.
However, D says that this sentence can be imposed under this section shall be consecutive to and not concurrent. And so it could be other crimes. If it's consecutive, it could be other crimes on top of that. So you could also charge this crime as well as another crime because you're saying it could be consecutive.
That's correct. But the other crime that I would envision would be murder. And therefore, if we're able to prove the murder, I doubt very often that the prosecutor would proceed with this crime because obviously, depending on the degree of murder, it could be a life sentence, it could be 40 years. So my vision is that this bill would typically, this statute would typically be used in a standalone where we weren't able to prove the mechanism or the ability to prove a murder. But the statute does allow that if we have other crimes, we could add to that.
So D would be like a safety net because otherwise you would not need D. Or you could be charged with murder, and this could be in addition to that if it's saying this shall be consecutive. So you could add the 10 years on top of a murder charge. Let's say they got 30 years. You can add this 10 years on top of that. Is that correct?
Correct. I can envision a judge overseeing a case who the jury comes back with second-degree murder, which now carries 40 years, but because of what the person did after they killed him, the judge could be outraged at that behavior. Right. Not only did you kill this person, I can hear the judge saying, but then you had to, the example we heard, take a chainsaw to the body and take the body parts and put them in different parts of the county. Right. Because of that, it's amplified, and therefore we're going to give you additional time on that.
Okay, so you do need D, it sounds like.
I think so.
Okay. Thank you.
Ms. Feinstein and Ms. Sterling also have something they'd like to say. Ms. Feinstein
I just want
first.
to briefly add that I can certainly see a situation where we do charge this crime in addition to murder or in addition to manslaughter or whatever other crime we're doing. I don't know that it's always going to be a standalone because it's really its own crime in terms of this, in terms of the dismemberment. It's an additional act or concealment. It's an additional act after the murder. And we have criminal statutes that do that in all sorts of different forms. And it really, in a lot of ways, is a horrible aggravator on top of the murder itself. I mean, I had another case years ago where the defendant concealed the victim's body in, like, literally over the river and through the woods in Montgomery County, in PG County, in this dark bend of the road. Not only did he conceal the body in the woods, he also cut off all her fingers, believing that that would minimize the ability to identify her later. Horrible. And that brought additional grief to the family that their young, daughter, she was in her 20s, body was mutilated in that way. And I am very comfortable with the idea that this should, in certain circumstances, be an additional charge that we are considering. Whether the judge adds on a sentence or not, that's going to depend on the nature of the circumstances, as is the case in any sentencing hearing. Thank you.
You're welcome.
State's Attorney Sterling, please.
Thank you. There are other instances as well, like let's say there was an elder abuse or child abuse or child neglect that leads to a death, and let's say it wasn't an intentional murder, and then subsequently there's a dismembering or improper disposal of a body. The other example I can think of is a case that we had in St. Mary's County. It was the Stephanie Roper case where she was abducted from Prince George's County. She was kidnapped, raped, and then murdered, and her hands were removed from her body and she was burned and left. The allegations were that which defendant did what. And so there's a possibility that a jury could have found one of the defendants guilty of the murder and the other not. And you want to make sure you have those charges intact just in case, because you don't know where a jury is going to go. In the case that we had in St. Mary's County, the gentleman was shot in the back. Had we not found that portion of the body, we may not have gotten a homicide conviction. It would be hard to say that the defendant shot himself with a shotgun in the back, but there was a possibility that we could have not found that one portion because there were so many different portions of his body. And as the detective stated, parts of the body were just rummaged through by animals, and we could have lost that piece, and that would have been the part where we couldn't have proved the murder. So we need it for both parts. I just wanted to address one other thing. As far as it being a felony in 10 years, remember that if it's not considered a violent crime, they would be parole eligible at 2.5. So even if they received all 10 years, they'd be out in 2.5 years as well. So I just wanted to kind of bring that up as well. Thank you.
And so, I'm sorry, Mr. Chair, just a quick follow-up. Thank you, Mr. Chair. And so you would, in prosecuting these cases, you would use both, like you would use it, say you, or like a hate crime, you would bring the crime and then like the additional charge. You would use this, so you would use both of this tool in addition to, another charge. You would just say, I'm going to do this by itself. Do this.
Sure. We would be able to do both. So you can always charge multiple because you don't know if a jury is going to say not guilty to one or the other, or you could do a plea deal to the other, or when you charge, remember when we're charging, we're dealing with the probable cause standard. And so we may have just enough probable cause to charge, but as we get through the investigation, which is what happened in the case that the detective indicated, we actually charged with murder and we had enough probable cause for it. But as we got through right before trial, we realized we weren't going to be able to prove it beyond a reasonable doubt. So in that case, we could only get the 1-year misdemeanor charge. Even though we did believe that he was a part of the murder, we had no other evidence beyond a reasonable doubt, just enough for probable cause.
Okay, thank you. Just wanted to clarify based off what Mr. Schellenberger said. So thank you, Mr. Chair.
Thank you. Any other questions? All right, seeing none, thank you very much. I didn't see Mr. Hill, and we didn't have Mr. Hill. Is he? No, okay. So that concludes the testimony on House Bill 674. We thank you all very much. We're going to go now to House Bill 703. Again, Delegate Kaufman, Melissa Rosenberg, Randy Ames, Brian Kelmar, Melissa Scales Hamilton, and Rachel London. Some of whom, Mr. Kelmar is virtual, Hamilton is virtual, Ms. Rosenberg's virtual, and Randy Ames is virtual. So everybody's virtual, except for Delegate Kaufman, who is very much not virtual. So whenever you're ready, we'll go ahead for 3 minutes.
Yes, I'm here, Mr. Chair, keeping you company. I want to just say at the outset, I'm unlikely to get through all my testimony in 3 minutes, so I do appreciate you reading it Good afternoon, Chair Clippinger, Vice Chair Bartlett, and esteemed judiciary colleagues. I'm Delegate Aaron Kaufman, representing District 18. I am asking for a favor report on HB 703, criminal procedure, diagnosis of developmental or intellectual disability evidence. I'm introducing this bill at the request of the Autism Society of America. I'm pleased that the bill has bipartisan support, as Delegate Susan McComas has signed on as a co-sponsor of the bill. The bill is supported by the ARC of Maryland, the Maryland Development and Disabilities Council, and Disability Rights Maryland. The bill authorizes in a criminal proceeding the admissibility of evidence, including expert testimony concerning a diagnosis for the defendant of autism spectrum disorder or developmental or intellectual disabilities such as cerebral palsy, Williams syndrome, Down syndrome, etc. If the evidence shows that the defendant at the time of the alleged offense did not have the mental state required for the offense charged, a judge or district court commissioner must consider any diagnosis for the defendant of a developmental or intellectual disability when making a pre-release trial determination. A former student of mine from my teaching days, who I'll call Dan, he has Williams syndrome and was charged with stalking in Rehoboth Beach at the time, as he was 30 at the time, and was talking to a group of 15-year-old girls and was walking with them down the boardwalk. Having Williams syndrome, he did not understand that he was making the girls uncomfortable since he was twice their age. Once one of the girls went to police and he was charged with stalking. He thought he was being friendly, but he made them feel threatened. Another former student of mine, John, was with a group of his peers at camp. It was bonfire night. Another kid said something mean to John, and he lost control and started to strangle the kid who said mean things. Fortunately, camp counselors intervened and no charges were filed. After the incident, as often happens, John realized what he did was wrong and admitted that he did it because of impulse control issues, which is very common in the autistic community, and immediately expressed remorse. And more people with autism will be showing up in our courts, friends, because 1 in 36 children have autism, according to the Center for Disease Control. More and more, as I said, more and more adults with autism will be showing up in our courts. The goal of the bill is to ensure that autism or other intellectual disabilities are considered in the court of law. This is not a get-out-of-jail-free card. There still be punishments, but sometimes it's a manifestation of their disability. So all we're asking for is that that be considered. The one other thing that I want to just say, if I can, Mr. Chair, just to finish my thought, is that when I had a private conversation with one of you who actually practices law and is in court frequently, the assertion, and I'm sure it's accurate, was made that some of these accommodations are already provided to a defendant, and defense attorneys can already raise this. And so I went back to my expert panel after that private conversation with a learned lawyer, and they are going to address why they think the bill is still necessary. So thank you.
So we're going to people who should be on virtually now. Randy Ames.
Good afternoon, Chair. I can't turn on my camera. It says that I don't have.
We can hear you.
Okay.
So go ahead. Go ahead, and we'll hear from you and go from there.
Great, thank you. Thank you, Chair, and other committee members for the opportunity to testify in support of House Bill 703. People with intellectual and developmental disabilities, unfortunately, are overrepresented in our criminal system, both as victims, survivors, and offenders. In our work with people with disabilities, DRM assists and works with the Public Defender's Office often to explore opportunities for diversion, whether that's additional supports in the community or services that are not in place. We work with clients who, unfortunately, due to the lack of services sometimes, or the lack of behavioral supports to meet their needs, there may be incidents of assault that we frequently see, as Delegate Kaufman had indicated. And these situations, there needs to be another alternative for these folks. The lack of supports and services and the limitation of the Medicaid programs, unfortunately, lead to unfortunate outcomes for people with disability. This bill, I think, is also important in that it ensures statewide consistency in the language, as well as giving an opportunity outside of somebody being found not criminally responsible. So, for those reasons, we hope this committee finds votes favorably in support of House Bill 703. We think that this will be a much needed protection and in line with other states like Virginia, who have implemented similar diversion programs. And I will keep the rest of my time.
All right. Thank you. We'll go to Brian Kelmar, please. He's not there. Melissa Hamilton? No.
Here's Ms. Hamilton.
Okay, go ahead. Ms. Hamilton for 2 minutes, please.
Thank you for your time. For years, I've advocated for individuals living with autism, ensuring that they live in a community that will support them. But on August, this became personal. I became a mother of a child with an autism diagnosis. The autism child who is being caught up in the travesty of injustice that does not take into account his autism. Today, I'm living my worst nightmare. My child is suffering because the criminal court system and the jail does not understand autism. It does not see the overwhelming weight of the sensory overload of loud noises, sensitivity to light, the terror of separation, and the devastation of isolation. I do not want them to, he said, I don't want them to know that I am the R word because I will get in trouble. Instead of support, my child is met with punishment. The jail is not equipped to deal with my child's disability. Already, the conditions there have required him to be placed on suicide watch twice. My child is worsened and is not receiving the service or the treatments despite of the several requests for treatment by my family and my child's lawyer. We have all asked for it, but it is not, jail is not simply equipped to handle it. And it is cruel subject. The cruelty is subject to someone who is living such a disability in those conditions. Since my child has been removed from my home, I have been drowning in the valley of shadow and death with eternal earthquakes and volcanoes in my body all day long. So what I am asking you to do is to help reduce the pain of families that are going through this, because autism cannot be cured. And the failure for the basic rights of a person with a disability over and over again is not being heard. Please take action so that no other family has to endure this. Please understand, we need support and understanding and be met with consideration of the diagnosis with the passing of this bill. Please stand with me and other children and other families who have been punished for just being born differently. Thank you for your time.
Rachel London? No? Okay, just doubling back on Brian Kelmar, no? All right. We'll take questions then. We'll start with Delegate Congolo, please.
Thank you, Mr. Chair. Thank you, Delegate Kaufman, for bringing this piece of legislation.
My mic's not on. Oh, yeah.
There it is. Okay, thank you. Thank you, Mr. Chair. So I just want to make sure that I'm clear. So one would have to have this diagnosis prior to the criminal offense. Is that correct?
Yes, they can't just say, give me a lesser sentence because I'm all of a sudden autistic.
Okay.
It has to be established. And I assume, based on my limited knowledge of court, the child's defense or the person's defense attorney would have to, prove whether it was a report from Kennedy Krieger or something else. They'd have to demonstrate proof that the child was in fact disabled, autistic or intellectually disabled.
Okay, and the reason why I'm asking is because there have been instances where people would request a retrospective diagnosis, obviously after the fact, to, to use that in a court of law to help them, obtain a lesser sentence. So just wanted to make sure that this had to be a documented diagnosis prior to the event, some historical information to back up the claim to make sure that the diagnosis is in fact legitimate.
That's my understanding, Delegate, but to be candid with you, the chair would probably know more than I would about that because of his day job, but that's my understanding.
Thank you.
Thank you, Mr. Chair. Unfortunately, my question could end up landing on your desk as well. I'm actually trying to think if there's any potential negative cascade that could bleed into civil court. So I'm imagining a scenario where a young autistic child has gotten caught up in the justice system, has been charged, has been given a lesser sentence because of their diagnosis, and then years later has a family going through the divorce process. And I wonder in my mind, could the fact that they were diagnosed and then received some kind of lesser sentence then be used against them to say, claim that they are ineligible to care for their own children or something like that? I'm just trying to make sure we're not potentially setting somebody up to be further penalized later in their life because they had some sort of benefit essentially when facing a criminal charge.
I think that a good divorce attorney would challenge any efforts to make that assertion, but it just comes down to, in my mind, good lawyering. What I do know, because of my expertise, and my friend from 11A probably has more experience as a principal, is sometimes it is the criminal act is a direct manifestation of their disability.
Okay. And so you think that would likely not be able to be used against them in a later civil trials?
I mean, people try everything in court, but I think they're unlikely to succeed.
I would hope so. That would be really sad.
Yes, thank you, Mr. Chair, and thank you, Delegate Kaufman, for bringing this bill. There were a couple of letters, they're labeled informational, from the Maryland States Attorneys Association, as well as the Judiciary. I guess some points of concern. I just wanted to, if you hadn't read them yet, wanted to bring them to your attention. You might want to reach out to them about maybe some possible amendments, but I don't know if you have any comments with regards to their concern.
I did read Mr. Moran's testimony. I did not get a chance to read the Judiciary's testimony, but they're concerned about most bills that we do, so.
Yeah, I mean, they're simply stated, the Judiciary's concern is that the way it's drafted, it will require a judge or district court commissioner to have information regarding the defendant's diagnosis, which you're saying typically they would not have that information at that stage of the trial. And so it's saying shall. I think maybe they're just looking for a may. And so that's the gist of it.
Well, now that I've presented the bill is the committee's work product now, so I think there are many excellent lawyers on the committee, such as yourself, that can massage the bill appropriately.
Okay, thank you, Delegate.
Vice Chair.
Thank you, Mr. Chair, and thank you, Delegate Kaufman, for bringing this bill. So there are ways that an attorney can get this information in with respect to disabilities or developmental disabilities. Is there a situation that led you to bring this bill? Are we finding that judges are not necessarily utilizing it, or attorneys are not necessarily utilizing it?
Yes, there are some situations that caused me to bring the bill. First of all, I think I forget what her name is, but the gentle lady, the woman who testified virtually and talked about the nightmare situation that her son is encountering to the point where he's been placed on suicide watch, to me, tells me the current procedures are not working. And then I'm not sure why Mr. Bryan didn't testify, so I'll tell his story. He said to me that when his son was charged with a crime, his son asked him a question, and the son said, Dad, if I get convicted tomorrow, will they take away the Eagle badge that I won at Eagle Scouts? And so I think it's clear that, and I understand that in some judges' minds, that would make them incompetent to stand trial from talking to some of my lawyer friends, but I think that it's clear from the woman's testimony who testified and Mr. Kilme, who told me that story. And lastly, I did it at the request of the Autism Society of America, and I don't think the ASA would ask a delegate to put in a bill for stuff that they were already doing.
Thank you.
I don't see any further questions. And seeing no further questions for this panel, we'll thank you very much, but there's another panel. And we'll hear now Rosenberg. All right, Kimberly Watts, Melissa Rosenberg, and Sherry Heck-Shriver.
Can I stay here just for a minute because it's easier?
This is Kimber Watts. I'm present virtually, although I can't turn my camera on.
Ms. Watts, why don't you go? Okay. We're having difficulty with the cameras for people, so we're just going to hear, oh, there she is. We'll hear from Ms. Watts first for 2 minutes. Please go ahead.
Thank you. I'm Kimber Watts, the head of the Forensic Mental Health Division for the Office of the Public Defender. A good number of people with intellectual disabilities are ultimately found to be competent to stand trial because they can understand the proceedings and assist their defense, even if it's in a diminished capacity as compared to other people. That being said, the ability to understand and the quality of understanding are separate things. Some of the characteristics of all intellectual disabilities include deficits in reasoning, problem solving, planning, and abstract thinking, and of course, judgment and learning from past experiences. These deficits impact people at all phases of a court case. For example, judges and juries often confuse someone with a blank look who is confused for someone who doesn't care. They are vulnerable to assault and other harms in pretrial detention facilities and in prisons. They often aren't able to comply with corrections officers' orders quickly enough because of processing speed and anxiety issues in high-stress situations. When thinking about judicial release, the judicial officers are required by rule to consider a number of factors, but intellectual disability is not listed among those. I don't believe that this bill would require the judiciary to seek out evidence of a disability, but rather to consider it when it is presented to them and note on the record that they have considered it. It doesn't require them to do anything differently than they would already do other than to consider that evidence. This bill would also require intellectual disability to be considered as a way of empowering judicial officers to craft specific conditions of release to meet their needs and abilities. In terms of the trial, at a trial, a judge or jury may infer that a person ordinarily intends the natural and probable consequences of their conduct. But for people with intellectual disabilities, it's not always fair to assume that they have intended the consequences of their actions. And while the defense is entitled to put forth evidence that the required mens rea or mental state did not exist in specific intent crimes, the law is less clear as to the general intent crimes, such as second-degree assault and the possession of contraband like controlled dangerous substances or even malicious destruction of property. This bill would clarify that evidence of intellectual disability can be introduced by the defense and considered at all stages of a case, and for that reason, we ask you for a favorable report. Thank you.
Ms. Heck-Shriver, please.
I think she's on mute.
But you have to take yourself off mute.
Can you hear me now?
Go ahead.
Hi, thank you for having me join. This is my first experience, so bear with me. I have an adult son with multiple diagnoses, one of which is autism. And last June, he was unlawfully arrested based on, I think, some of his behaviors manifested because of the autism, his anxiety disorder, his ADHD, and so forth. He was subsequently detained at the Maryland State Police Barracks. I had tried to present information which was not really well heard. I reached out to multiple people to make them aware of his diagnoses. No one seemed to be concerned. Reached out to Wes Moore, superintendent of the State Police. No one seemed to be interested in what had happened. I feel like this bill would really help represent people like my son in order to avoid things going to trial. Subsequently, we did go to trial and the charges were dropped for one of the three, actually two of the three charges were dropped. But I feel like there needs to be a lot of consideration on people's disabilities, if you will, and be able to provide them a fair trial. And in this case, it wasn't even necessary to go to trial had they asked me for his medical documentation of his diagnosis. Thank you in advance, and thank you for speak.
Ms. Rosenberg, please.
Thank you, Chair Clippinger and Vice Chair Bartlett, for the opportunity to testify here in support of HB 703. I'm with the Autism Society of Maryland, but I'm also here representing the Autism Society Baltimore Chesapeake and the Autism Society of America in supporting this bill. And as you already heard, this bill addresses sort of a gap in our criminal justice system, permitting the introduction of this evidence of autism or IDD diagnosis and ensuring these conditions are considered when making pretrial release decisions. It will also allow expert testimony on autism and its potential impact on the crime in question. And I'm not an attorney either, but I can tell you I'm the voice on the phone when people like Sherry or Melissa call. And it's amazing how quickly a life unravels in these circumstances, where you lose your job, you lose your life. And that's what we want, just the consideration so that these things can be dealt with in other ways. We know autistic individuals are overrepresented in our criminal legal system, 7 times more likely to be victims of crime, 12 times more likely to be involved in the criminal justice without intent, which is what we're talking about a lot of times, 5 times more likely to be incarcerated, and everything just escalates in marginalized communities for persons who are also autistic. We'd appreciate a favorable report on HB 703, and thank you to Delegate Kaufman for stepping up to support this bill. Thank you.
Are there questions for this panel? All right, seeing none, thank you all very much, and that concludes the testimony on House Bill 703. All right, we're going to keep going now. Delegate Guyton has been patiently waiting. It is here on House Bill 613. Sarah David is virtual. Lauren Pruitt is virtual. Scott Schellenberger. Mary Setzer is virtual. C. Lisa Jordan.
For your indulgence, Mr. Chair.
My goodness. Oh, not at all. Well, there are quite a few more people here. We may try to go through the virtual people first and see how many people we can get through. All right, so I see Ms. Jordan.
Mr. Chair.
Thank you very much. That was a great bill, by the way, that I just heard. Would it be possible for me to have Mary give her testimony first and then go to the virtual folks? Would that be
fine. Okay.
Thank you.
All right, we'll figure out the rest in a minute. Is this Mary Smith?
Yes.
All right, thank you very much. Go ahead, please.
Right.
So delegate, you're going to present, okay, 3 minutes
Yes, sir.
to the
Thank
delegate.
you. Thank you so much, Mr. Chair, Madam Vice Chair, members of the really highly respected Judiciary Committee. I wish I had come in one bill later than I did. I don't know how you all do this work every day, but thank you for it. I am here to ask for your thoughtful consideration of House Bill 613. It protects the privacy of sexual assault victims by redacting their names from easy access on public-facing kiosks. And indeed, they are easy to find. Last year, this body, thanks to our fabulous Delegate Phillips, worked on a bill very similar to what I'm presenting to you now to protect the identity of minors. So thank you so much for that important legislation. This bill actually just adds sexual assault victims to that piece of legislation with a few other changes that we worked out with Chief Judge Morrissey. You all know that sexual assault has a stigma associated with it that makes it very difficult sometimes to actually go and report and prosecute these cases. And you're actually going to hear that there have been some victims who have been discouraged to prosecute based on their fear of having their privacy revealed and their name revealed. So currently, the name of any adult victim is easily accessible. When this was first brought to my attention, I spoke to a lot of folks on this committee and outside this committee, and we all sort of went, really? We thought that that was private. Indeed, after spending an afternoon going down a very dark and deep rabbit hole at the court building, we found that indeed it's not. The sexual assault victims' names and sometimes other identifying factors are easily accessible from all of your jurisdictions. So this legislation doesn't restrict any party to the case from having the information. It truly just makes it more comfortable, more private, and have more respect for those who are going through this when they don't have to worry constantly that anyone can find out their name. So I ask you for your support of House Bill 613 to support victims and encourage reporting of sexually assaulted behaviors. We do have some amendments and an interlineated version in front of you right now, or at least we sent it to the committee because we didn't get our final amendment back before this hearing. The amendment actually changes it back to be closer to your bill last year with a few changes that we made to make it different, but we put it back in that form because it was great work. So thank you so much. I'm happy to answer any questions, but first I'd like to turn it over to Mary. Thanks.
Good afternoon. I'm a 17-year-old advocate for sexual assault prevention and survivor protections. I brought this bill. Okay. Sorry. Good afternoon. I'm a 17-year-old advocate for sexual assault prevention and survivor protections. I brought this bill to Delegate Guyton and have worked very hard on this bill. Protection of sexual assault survivors is an issue that's very close to my heart. When I was 14, I was sexually assaulted by a boy who I knew was involved in serious criminal activity. My parents immediately began an investigation to build a case against the perpetrator, but I was scared out of my mind, so I made them drop the case. I knew if we pursued legal action, my name would be out there, and if not him, then one of his associates would come after me. I am so grateful that this committee helped to pass SB 111 last year to protect minor victims' privacy. However, this law only applies to those under 18. If I were just 4 years older when I'd been sexually assaulted, I would be denied of these privacy protections, and my identity could have easily been discovered because of these easily accessible courthouse kiosks. Sexual assault cases differ from many other criminal cases in that they are extremely sensitive at any age. Adult survivors may request anonymity, but it is a cumbersome process for most people without a law degree would have no idea how. Furthermore, in cases of sex crimes, the victim's name is actually required under Criminal Law Statute 3317. Due to the sensitivity and frequent retaliation associated with sexual assault cases, regardless of the victim's age, adult survivors should be granted these same protections. This is my first time publicly sharing my story. It's terrible and it's tragic, but I want to use my experience to help other survivors like me. The government has a duty to ensure the safety of sexual assault survivors, and a part of that is protecting the identities to support those who come forward and prosecute their offenders. It should be standard policy, not discretionary, that court filings redact identifying information of sexual assault survivors, both children and adults. Thank you for your time.
Scott Schellenberger, State's Attorney for Baltimore County, here in favor of House Bill 613. If that doesn't convince you, then certainly I don't know that I will. Thank you so much for coming. Several years ago, we enacted this statute in order to protect minor victims. And when we said it, it was like, oh yeah, of course we should be able to redact minor victims from any public records. And then all of a sudden, last year we thought, oh, well, what about sexual assault victims? And we realized that there was really no specific statute that dealt with it. So the concept here is to take the statute that was passed before that deals with minors and allow the sexual assault victim to ask the state's attorney to make a motion that their name and identifying information be kept out. Remember, the courts can decide not to do this. Now, they would have to decide by clear and convincing evidence that there's good cause that the person should be disclosed. But it does require that on written request of the victim of a sexual assault, that the court take it out. And remember, this does not affect a defendant's rights. The defendant's lawyer and the defendant will still know who the victim is, and therefore we think this is a very good bill and ask for a favorable report. Is that my delight?
No, you have 30 more seconds if you want.
That's all right. We have good people coming along. We'll defer to them.
All right, Ms. Setzer, please, for 2 minutes.
Thank you. Good afternoon, Mr. Chairman and members of the Judiciary Committee. My name is Mary Setzer, and I'm the head of the Special Victims Unit at the Maryland Office of the State Prosecutor, asking for a favorable report on House Bill 613. The Office of the State Prosecutor handles political corruption, police misconduct, and election law cases throughout the state of Maryland. Our office, after noticing a significant influx in cases involving sexual impropriety alleged against people in positions of trust, started this unit to ensure that justice is served to those who victimize individuals using their public position of power. I personally have served as a prosecutor at the local, state, and federal levels, leading prosecutions of domestic violence, human trafficking, and sexual assault. One of the challenges in public corruption cases where there are victims, especially victims of sexual assault, is the attention these cases receive from the public, a force that often dissuades victims from coming forward. Our specific office already anonymizes victims' identities during the charging process, but we currently must always advise victims of the possibility of their identity becoming public in filings after the initial charge is prepared and filed by our office. This legislation would help preserve a sexual assault victim's anonymity in all paper filings that accompany the case. The victims who make these allegations understand that they may still have to appear in court, but it is extremely important that at the charging stage and in filings, their names are not known. This legislation helps ensure that this is a standard practice throughout the state and will be a meaningful way to ensure that victims of these sensitive crimes are not dissuaded from reporting them due to their fear of their identities becoming public. It also ensures that these victims are not further victimized and subjected to additional suffering beyond the assault they've already endured by their identities becoming public after prosecutors have made the decision to initiate charges. We would like to thank Delegate Guyton for her leadership on this issue, and we encourage a favorable report.
Ms. Jordan, please, for 2 minutes.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of House Bill 613 with the sponsor amendments. Thank you so much for your courage bringing this bill forward. I did want to just focus on a couple of details in the amendments and echo what the witnesses before me have said. There's no motion actually needed to protect a current case. However, this bill very wisely allows victims in past cases to file a motion. So it's not requiring the court to go back to every single case that's ever been filed, but it says in those old cases, if you come forward and ask for redaction, then that will be that will be protected. Anything going forward that is a sex crime will be protected. Some key parts of the amendments that you have in front of you include that the victim or the victim's representative will have access to the file, and we want to make sure that that's true, because remember, victims are not parties to the case, so we need to make sure that they have access. And then finally, there's a technical correction. The bill that Delegate Phillips sponsored and championed last year about minors wisely said we have to tell the court that someone's a minor, because you can tell if something is a sex crime just by the nature of the charge, but you need to tell the court if a witness is a minor, or if someone is a minor, otherwise they might not know. So we encourage the committee to adopt those amendments and ask for a favorable report on House Bill 613.
Ms. Feinstein, please, for 2 minutes.
Thank you, Chairman Clippinger. Debbie Feinstein, and with the Montgomery County State's Attorney's Office, Chief of the Special Victims Division. I'm testifying on behalf of my office and the Maryland State's Attorneys Association, as Joyce King and I co-chair a Special Victims Subcommittee. My office currently anonymizes sexual assault victims' names in our indictments and our charging and any public-facing document. However, what we can't control and what we teach is, in terms of law enforcement getting a statement of charges, the name may end up there, or they may be asked to add it by the commissioner if the commissioner has concerns. We've had both of those things happen. This would prevent that name from getting out. We're a member of the public to seek those documents. Currently, it also doesn't prohibit opposing counsel from including the victim's name in their filings, which often comes up in sexual assault cases because we have all sorts of filings related to other acts, other sexual assaults, other prior bad acts. And those filings are routine in sexual assault cases. So really what this does is protect the victim of the sexual assault across the board in any public-facing filing, regardless of who files it. And I would urge support and echo what my colleagues have said already in support.
Questions for the panel? All right, seeing none, thank you all very much for your testimony. And we'll go on, we'll hear from, there are more people, I think, virtually. Lauren Pruitt, Sarah David. Yes, the women's, right. Catherine O'Malley, Kurt Wolfgang. Here, sir. Okay, come on up, Kurt. Cecilia Plant? No? Oh, I'm sorry, I went to that part. Okay, that's fine. We'll hear from Mr. Wolfgang here in the room first, and then we'll go to our two virtual people. Mr. Wolfgang, for 2 minutes, please.
Yes, sir, thank you. My name is Kurt Wolfgang. I am the Executive Director of the Maryland Crime Victims Resource Center and have appeared before you on many occasions. I thank Delegate Guyton for this bill. It is a very important subject. She actually called and asked for my help, and I'm afraid I wasn't much help in the process of coming up with this. My apologies. I see what we were overlooking when I spoke to her. The important reasons for this have somewhat been mentioned, but protection from re-traumatization of the individual involved. More importantly, I think, is the encouragement of people to seek charges in sexual assault cases. It's sometimes reported that as many as 60% of sexual assaults go unreported. And obviously, this is another one of the reasons that people don't want to report to seek charges in sexual assault cases. Forgive me, I guess I'm speaking twice. Of sexual assaults. I wanted to emphasize to the committee that the issue comes up. There are some First Amendment concerns whenever something like this happens. It has been litigated on many occasions in many different types of cases that there is no First Amendment bar to this. It's considered a compelling state interest to protect the identity of sexual assault victims for the reasons stated above, and and primarily to encourage them to participate in the criminal justice system. So with that, I ask that you report favorably on this bill, and we appreciate the opportunity to be heard before you.
So Malley, please, for 2 minutes.
Thank you, Chair Clippinger and Vice Chair Bartlett, and thank you, Delegate Guyton, for bringing this bill forward. It's a very, very important bill. I am Katie O'Malley from the Women's Law Center of Maryland, and we strongly support and urge a favorable finding on the bill. You know, it extends privacy protections for minor victims of sexual assault to the alleged victims of any age, including the right to have their identifying information redacted from an existing filing. We support this bill in order to protect survivors from further re-victimization, just as your last witness had talked about. This also helps survivors protect their privacy, their dignity, and their security. So many times when survivors come forward, they are re-victimized in the press. Sometimes their abuser then takes their information and, as they call it, doxing, sends it out through the internet and then re-victimizes them so many different ways. So we definitely support this bill and thank Delegate Guyton and your young witness for coming forward today and sharing her traumatizing story. And I'm here to answer any questions. So thank you again for allowing me this important opportunity.
Lauren Pruitt, please, for 2 minutes.
Good afternoon. My name is Lauren Pruitt, and I'm the legal director at Free State Justice, a nonprofit organization dedicated to serving LGBTQ+ Marylanders. As was stated, more than 50% of victims of sexual assault did not report the crime to police. And this is confirmed by Bureau of Justice statistics. This alarming statistic underscores the urgent need for HB 613, which addresses the fear that many victims have of reporting the crime due to privacy concerns. This issue is of utmost importance to the LGBTQ+ community. As research indicates, the community is 4 times more likely to experience violent victimization, including sexual assault, than non-LGBTQ+ individuals. The rates of victimization are even higher when additional factors affecting that individual, such as race, immigration status, homelessness, and poverty, are taken into account. HB 613 is a crucial step towards addressing these disparities and providing much needed protection to the LGBTQ+ community. As an advocate, I've witnessed firsthand the challenges that experiencing sexual assault and reporting it imposes on the community. Fear of personal information such as sexual orientation, gender identity, and details of the assault being shared keeps many from reporting the assaults and seeking support. By protecting all victims of sexual assault, Maryland will ensure a safeguard for the LGBTQ+ community as well. By safeguarding folks' identities, we create a safer space that encourages individuals to report their victimization. This step not only demonstrates compassion and understanding, but also empowers more survivors to come forward and seek justice in the courtroom for the crimes inflicted upon them. In doing so, we foster a community where voices can be heard and healing can begin. I hope this results in significantly lower incidences of sexual assault, creating a safer environment in Maryland for everyone. I urge the committee to issue a favorable report for HB 613. Thank you.
Delegate Cardin with a question.
Thank you all very much for coming and testifying, and I'll preface this with I'm a co-sponsor of the bill. I hope it passes. This is actually for Ms. O'Malley. Can you put on your judge hat for a minute? It's always good to see you. If you can put on your judge hat for a second. There's no issues with the right of confrontation or anything in the actual court experience that would be problematic with this legislation. Is that correct?
You're 100% correct. Just as Ms. Jordan had testified when she had her 2 minutes. This does not take away the right to confrontation, and all that information is given to the defense.
Okay, thank you. Thank you, Mr. Chair.
Seeing no other questions, we thank you all very much, and that concludes the testimony for House Bill 613. Thank you.
Thank you, Mr. Chair.
Thank you. We'll go now Delegate Rosenberg and House Bill 305. We have virtual, Meredith Weisel, Howard Libet, Deborah Miller. All 3 are virtual, and all 3 are there. So Delegate Rosenberg, when you're settled, we'll let you speak for 3 minutes here. Then we will hear from them.
Thank you, Mr. Chairman and members of the committee. Some 20 years ago, when there was a spate of criminal acts seeking to block entrances to clinics providing abortion care, reproductive health care, we passed legislation, passed the law, making it a crime, an enhanced penalty. It was already a crime, but enhanced penalty to block access to a medical facility. House Bill 305, in a similar way, would enhance the penalty for blocking access to a religious facility. The definition of religious facility is taken in this bill, is taken from existing law. That existing law is in the bill. And the language of our clinic medical facility law is also in the bill, so that you can see that this bill is a replication, if you will, of existing law regarding criminal acts blocking access to a medical facility and extending that principle to religious facilities, which the law defines to include not only a religious, the facility itself, not only a church or synagogue or imam, but also a community center or a school. But it's there just as it is in existing law in the hate crime statute, I believe, is where we derive this from. This is not a theoretical problem. The Baltimore Jewish community is building a new, or is renovating the JCC on Park Heights Avenue, just above Northern Parkway, in the heart of the Jewish community in Northwest Baltimore, in the city. And they're renovating it to make it both a JCC and a new headquarters for the Associated Jewish Charities. The cost for the protective glass at the entrance is $500,000. $500,000 that could go for teenagers who have mental health issues. They could go for the elderly. They could go for the developmentally disabled. But it's going for glass, protective glass, costing $500,000. This is not an isolated instance. In our state budget for the current fiscal year, there's $5 million that was appropriated for safety and security for religious facilities, $5 million. And the governor, in his budget now before us, has proposed to double that to $10 million.
If you want
I
to
urge
finish
a
up your last
favorable
thought.
report.
Okay.
Thank you.
Ms. Weisel, please.
Thank you, Mr. Chairman, and thank you for allowing us to testify virtually, as it did just start snowing here in Montgomery County. For the record, Meredith Weisel with the Anti-Defamation League, a leading anti-hate organization, and we really appreciate and support House Bill 305, introduced by Delegate Rosenberg. It's important to remember that our faith communities right now across the country and here in Maryland are increasingly seeing levels of hate-based incidents. And just to look at the FBI statistics from 2023, it reported that faith-based hate incidents surged from 2,042 in 2022 to close to 2,700 incidents in 2023. And so this is something that is impacting all faith communities. And in Maryland in particular, religion-based hate incidents saw a significant increase from 316 incidents reported in 2023. Back in 2022, it was only 105. That's according to the Maryland Department of State Police's Hate and Bias report. And so nationwide, we have been seeing instances where individuals of faith have felt afraid to attend their houses of worship. And so it's really important for House Bill 305, which helps amplify the urgency that we need for the legal protections. It's really crucial to understand that individuals must have access both exiting and entering without fear of physical interference going into their religious facilities. This is a fundamental right to religious freedom, and we would strongly urge the Judiciary Committee to give House Bill 305 a favorable report. Thank you.
Mr. Libet, please, for 2 minutes.
Hi. Thank you, Mr. Chair and members of the committee. Howard Libet, Executive Director of the Baltimore Jewish Council.
We represent the agencies of the associated system as well as the broader Baltimore area Jewish community. And I want to try and put this bill in terms of an actual real-world example that happened in our community within the past year. Among the agencies we work with is the Hillel at Johns Hopkins University. This fall, they had a young man who had from the Baltimore area who had served in the Israeli military coming to do a brunch conversation with Hopkins Hillel students to talk about his experiences, talk about what Israel was like since the October 7th attacks. What was encountered by the students there were protests blocking the access, actively trying to prevent any of the students who wanted to go into Hillel and hear from being able to enter the Hillel. Fortunately, we called security, and an entrance was, the students were escorted inside. But it's one thing, this isn't intended to infringe on anyone's First Amendment rights. It's fine for them to be outside protesting. What's not fine is for them to be in a position to block access, to not let students into a facility like a Hillel, like a synagogue. And for that reason, we support House Bill 305 and urge a favorable report.
All right. I forgot the name. Ms. Miller, please.
Good afternoon, Chairman Clippinger and members of the Judiciary Committee. I'm Deborah Miller, the Director of Government and Community Relations for the JCRC of Greater Washington. The JCRC represents over 100 social service agencies, synagogues, and schools, and we are committed to a society based on justice and tolerance and advocate for our nonprofits that serve the most vulnerable in Maryland on a non-sectarian basis. And I, too, am here today in support of House Bill 305 to prohibit someone from blocking access to or from a religious facility. One of our top priorities at the JCRC has been protecting the safety and the security of the Jewish community. According to a recent report from the ADL Center on Extremism, hatred toward Jews not only spiked after the October 7th, 2023 attacks in Israel, but the level of violent anti-Semitism has yet to return to the pre-October levels, indicating a new, higher and more dangerous baseline. Violent, strident anti-Semitic tactics underscore the importance of this bill to ensure that our community is safe, whether it be at a synagogue, at a hillel, at a religious school, or a community center. We have all seen protesters across the country aggressively block entrances to Jewish facilities, instilling fear and intimidation. Students have also been attacked on their way to Shabbat services, and outside of synagogues, police have had to step up patrols when protests have turned physical. The JCRC has been on the front lines of condemning this kind of violent intimidation and harassment. We will continue to work to ensure not only the safety of our community, but also the right to religious freedom, including access to all our Jewish institutions. So for these reasons, we also urge a favorable report for House Bill 305.
All right, questions, Delegate Kaufman.
Can I have two as long as they're brief, Mr. Chair? Two questions, yes. I have two questions for the sponsor, if I may, and that is, Delegate Rosenberg, have you seen the letter from Secular Maryland where they say this protection should apply to all nonprofit facilities and not just places of worship, and what are your thoughts on that? And my second question is, I want to, because of all of your witnesses represented Jewish organizations, do I read the bill correctly that this would also benefit churches, mosques, and Buddhist temples as well?
If I can answer the second question first, it would protect any religious group, any religious group in the state. It would be a First Amendment violation if it only, I would assume, if it only protected Jewish groups.
I just wanted to put that on the record.
Certainly, certainly. And your first question?
Secular Maryland, which is an organization in our state, is testifying favorable with amendment because they say they want these protections applied to all nonprofit facilities. And so my question is, what do you think of the amendment, and are you amenable to broadening the protections to all nonprofit facilities, not just religious ones?
I would.
And your aide, I think, just brought you the testimony.
Okay, I would defer to the committee on that. I don't know that I think for me at least, the burden would be is there the level of violence against other secular facilities that we do have evidence that is being perpetrated against religious facilities? I think that would be the test for me if I were a member of this committee.
Thank you, Delegate Rosenberg. Thank you, Mr. Chair.
Delegate Carter.
Thank you, Mr. Chair. Thank you very much, Delegate Rosenberg, for bringing the bill. We're hopefully getting this passed. The definition of religious facility is it refers also to leased facilities. The ones that you're talking about and that we know we're very familiar with are often owned and they've been institutions, but there are a lot of synagogues, churches, religious facilities that are leased, but they're only leased part-time.
Mm-hmm.
So maybe what can work with you with the committee, but we can make sure that we figure out how to juxtapose if it's only part-time lease to make sure that it's still protected properly. Does that sound fair?
Absolutely.
Okay.
Other questions? I have one. In the bill, on page 3 of the bill, it says, it's the meat of the bill, a person may not intentionally act alone or with others to prevent another from entering or exiting a religious facility by physically detaining the other or obstructing, impeding, or hindering the other's passage. And you say that you indicate a 90-day penalty. I'm reading in the criminal law article 10303, which reads, a person may not, by force or threat of force, obstruct or attempt to obstruct another in the free exercise of that person's religious beliefs, which I would presume would also extend to blocking a doorway. That is a penalty that's actually 3 years. So does your bill actually undercut the penalty in the other part of the law?
Well, it's meant to complement, supplement, say, the hate crimes provision. So, and in my testimony, I referred to it as an enhanced penalty. So it would be in addition, because that's, I believe, also the case with the existing law for medical facilities, that it's a crime. It was a crime before this law of 20 years ago, I would think.
Well, I think there's an existing law in the books that already addresses the issue, I guess, that you could also use the hate crime enhancement on as well, but we can talk more offline, and I would just say you should take a look at 10303 of the criminal law article. All right, are there other questions? All right, seeing none, we thank you very much, and that'll be the hearing on House Bill 305. I'm going to go now to Delegate Hutchinson. House Bill 616. Oh boy, Tammy Doring is on virtually. And those are the only two people who are going to testify. So we have Doring on there. Delegate, if you'd like to go ahead for 3 minutes.
Sounds great. Thank you, Mr. Chair, members of the Judiciary Committee. For the record, I'm Delegate Tom Hutchinson from the beautiful Eastern Shore. I'm here today to present House Bill 616, destroying funerary objects, statute of limitations with. So I presented this bill in a slightly different format last year, but it was amended to the advice of Subcommittee Chair Williams to change it from 5 years to 3 years statute of limitation, and as a result, it passed out of this committee and it passed out of the House unanimously. Unfortunately, I didn't have a cross-file, and it just sort of got held up in judicial proceedings. However, this year I have a cross-file by Senator McKay. So joining me today is Tammy Doring, who brought the need for this bill to my attention last year, and I've dedicated this bill to her great-grandfather, Wayland Truitt, who was born in 1891. He was a World War I and a World War II veteran, and he was buried in their family cemetery when he died in 1972. Laid to rest next to 18 family members of the Truitt and Talls family, along with children and infants. It was located in a family cemetery in South Dorchester in Wingate. So after the home was no longer owned by the family, they would still come down and take care of their family cemetery. The new owner of the house was very accommodating to them and welcomed them every time. Subsequently, the house was sold to an interested individual who used it as a rental property, Airbnb, for hunting. Then unfortunately COVID hit and the family missed their annual visits to Dorchester County. So finally in 2021, after a period that 2 years had passed from their prior visits, Ms. Doring, along with her 80-year-old mother, traveled to the family cemetery, and that's when they discovered the tragedy. When they pulled into the driveway, they initially thought they drove into the wrong house. The graveyard was no longer there. Gone were the tombstones and burial vaults of their loved ones. When they got out of the car, they discovered a pile of rubble and gravesite that consisted of broken vaults and tombstones. There were broken pieces of the tombstone that outlined the gardens and flower beds around the house. And then they found that they were just bulldozed and pushed into the neighboring marshes. I've uploaded pictures of this in committee testimony. So the family confronted the new owner, who was very careful not to incriminate himself. They pursued assistance from the local law enforcement and state's attorney, but unfortunately, because the law is a misdemeanor, there's a statute of limitation of 1 year. And because they could not determine the actual date of the destruction that had occurred based upon the last time of their visit, a time frame couldn't be determined, and they could not pursue any legal action. So there was nothing the law enforcement could do. The statute of limitation had passed. So considering, as in this case, a family may not visit a gravesite annually, this bill simply extends the statute of limitation to 3 years for destroying funerary objects. We feel this is a reasonable amount of time, and it does not help the Doring family, but we do hope it will help others who've experienced this future. I ask for your support of House Bill 616. Thank you.
Ms. Doring, please, for 2 minutes.
Good afternoon, Chairman Clippinger and members of the committee. My name is Tammy Doring, and I'd like to thank you for giving me this opportunity to speak in support of House Bill 616. You just heard Delegate Hutchinson describe some of the events that led me to contact him regarding the destruction of our family cemetery in Dorchester County. As he told you, in August of 2021, my mother's sister and I went to the property to visit it and found it completely demolished. It was covered with weeds, vaults destroyed, filled with water, and the tombstones were scattered into the marsh. And it was shocking, to say the least. My mother was inconsolable. We immediately reported this to the Dorchester County Sheriff's Department and to the state's attorney, only to be told that the statute of limitations had been exceeded and there was nothing to be done. And hearing there was nothing to be done when 22 souls' final resting place, in their final resting place, had been treated no better than garbage in a landfill was just horrifying. To give you a little background on that family cemetery, it's known as the Truett Home Place Cemetery and the Tall Truett Cemetery. It's located in a small community of Watermen, and it's very remote. And it's not unusual for homes here to have cemeteries on their properties. This was my mother's childhood home, where she lived with her parents and grandparents. First burial site dates back to 1857. And my grandfather was the last to be buried there in 1972. This was his home. He was a World War I vet in the Army. And I remember going to his funeral. It's the first funeral I ever attended as a child. And I went to that burial site and visited there many times over the years. The cemetery was also a resting place for 6 children and infants. Families who are buried in this cemetery are not historically notable. They're not famous, but they're family. And they are loved ones who are laid to rest in a place that was important to them, and they deserve the respect and honor that we can give them. I would ask you, on behalf of my family, the Truett and Tall families, to vote favorably in support of 616. Your support will protect the sanctity and honor of all family cemeteries and ensure that they remain places of peace and remembrance.
Thank you very much. Delegate Schmidt with the question.
Thank you, Chair, and thank you, Ms. Doring, for coming in to testify. I know we had discussed this bill a little bit last year. Is the posture the same? I know we're just extending the statute of limitations.
It really is the same bill now that passed out of the House. It was my original bill. It came up 5 years, but after talking to the sub-chair, we said that 3 years was more reasonable and consistent with other statute of limitations.
Okay, thank you, Delegate. And we did pass it out of the House last year.
Yes, we did.
Okay.
139 to nothing.
Okay, excellent. Thank you.
All right. Any other questions? Seeing none, we thank you very much. That concludes the testimony on House Bill 616. Thank you very much. We'll go to Delegate T. Morgan, who is here, and Mary Ann Thompson should be virtual and will be coming up on the screen right now. We'll hear from Delegate Morgan for 3 minutes and everybody else for 2. Go right ahead.
Thank you, Mr. Chair. I am Delegate Todd B. Morgan, so there's no confusion here. Rest of the committee, I'm here to ask your support for House Bill 485. This delegation bill would better empower the St. Mary's County Sheriff and courts to order programs which serve as alternatives to prison sentences, excuse me, for nonviolent offenders in the county. The day reporting program in St. Mary's County was introduced 3 years ago with federal grant funding and has proven successful in enhancing the existing home detention program. This program gives offenders access to job training, mental health, substance abuse treatment, parenting, anger management courses, among others. This legislation modifies language regarding the existing home detention program and inpatient treatment program to authorize the courts to order participation in pretrial. The bill grants additional oversight and enforcement authority by mandating that participants in these programs require financial contribution from the individual, ensuring accountability. The bill improves the strengths and those existing, proven, and successful programs, and enhance the ability of the courts to order rehabilitation rather than further punish those stuck in cycles of poverty or addiction. I respectfully ask you your favorable report on House Bill 45, and there is an amendment to the bill, and it basically just changes the 3 delegates' names to St. Mary's County bill. Thank you very much for your time.
Any questions? Oh, not yet. We have to hear from Ms. Thompson. Let's go ahead and hear from Ms. Thompson, please, for 2 minutes.
Good afternoon. I'm Mary Ann Thompson. I'm the warden of the St. Mary's County Detention and Rehabilitation Center. The legislative proposal is requested to update the annotated code of Maryland 11720 individual county provisions to reflect the current community programs at our detention center, adding day reporting and inpatient treatment. The legislation already includes pretrial supervision, work release, pretrial release, and home detention. The court authorizes participation in these programs. Day reporting, a program added 3 years ago with federal grant funding, has proven to be a success in enhancing the home detention program. The program closely mirrors the St. Mary's pretrial supervision program with its intense case management and holistic approach to advancing equity in public safety, health, and education. Offenders are aligned to behavioral health evaluation and treatment, including mental health and substance abuse disorders. In addition to behavioral health, offenders are aligned with life skills, job training, anger management, parenting courses, to name a few. The inpatient treatment program is again court authorized to allow the offender to attend intensive substance and mental health treatment. The program has been structured to implement rules and regulations governing compliance, including a 45 to 60-day wait to be placed on the program to ensure the right mindset, stabilization of the justice-involved individual's mental health, and placement on the medicated assisted treatment program. This has enhanced public safety and reduced the number of walk-offs from community programs while ensuring the individual receives the court-authorized inpatient treatment. The legislation further updates the language from sentence to court order, as individuals may be convicted or pretrial. Moreover, the language is modified from sheriff collecting funds to ensuring the individual pays court-ordered restitution by making the collection of the monies a stipulation of the program participation, ensuring accountability. Community-based programs are alternatives to incarceration, reducing the incarcerated population while successfully reintegrating justice-involved individuals back into the community. I respectfully request favorable consideration of this bill. I'm available for any questions, and most importantly, I appreciate your time.
All right. Are there questions for this panel? Delegate Morgan, is this your first time in front of the Judiciary Committee?
Yes, it is.
Oh.
3 years. I did pretty good, didn't I?
You did very well. Did very well avoiding us for that long, but we make you stop.
I'd like to be the biggest guy besides you, so it's okay to do avoidance.
Thanks. Very much.
Thank you, guys.
All right. Any real questions?
Any real questions?
Okay. No
it's not
real.
snowing yet, okay? We're okay.
All right. Thank you. Thank you to Ms. Thompson. Thank you very much. That concludes the testimony for House Bill 485. We're going to Delegate Schmidt, who might be a little surprised. Next, 462, we're looking and sent out a search party for Delegate Grammer. Good luck. 460, oh, he's an ENT?
Yeah, it is a big problem.
He may never return. Who knows? Delegate Schmitz.
Do I have time to put on my sports tie?
Sure. Here, let me talk slowly and see how long it will take you to do that. We're going to hear from Michael Schlip, correct? And Marquez Dent. I didn't say your first name right, but I apologize. We'll let you correct me. Yeah, I apologize. But we'll hear from the delegate for 3 minutes. He didn't really change his tie. Everybody else for 2 minutes. So go ahead.
Here we go. Good afternoon, committee, Chair, Vice Chair, Chair Klippinger, Vice Chair Bartlett, esteemed members of my favorite committee. I bring this bill before you as a call for help for sports officials. This bill has been in the Senate for many, many, many years, and now it comes to the House. The purpose of this bill is to prohibit a person from intentionally causing physical harm to another if the person knows or has reason to know that the other is an official, an umpire, a referee, or a judge officiating a sporting event. It authorizes a police officer to arrest said person without a warrant if the police officer has probable cause to believe that the person has committed a certain assault, generally relating to second-degree assault. Over 50% of officials have reported that harassment made them feel unsafe while officiating, while almost 12% who've responded have been physically assaulted. This is not just for adult officials. There are junior officials included in this as well. Just this morning, today, Good Morning America reported about a dad in Washington State who was charged with assault on Sunday for shoving two child referees at his son's hockey game. He went onto the ice, shoved the referees, which led to them falling on the ice and getting hurt. According to the National Association of Sporting Officials, close to 90% of all sports officials report being harassed during, before, or after a sporting event. 18 other states have already enacted this law. While it is already illegal for an individual to commit assault, sports officials are not included in Criminal Law 3-203 article, which authorizes police officers to make a warrantless arrest with probable cause under this criminal law. HB 462 specifies that assault against a sports official can lead to an immediate arrest with probable cause. You can look at page 2, paragraph 2, line 6. You will see a current group of individuals that are protected. This adds sports officials to the law. I request a favorable report from the committee on House Bill 462. Thank you.
Oh, good afternoon, Mr. Chairman, members of the committee. My name is Michael Schilp. I'm the president of Baltimore's Best Umpires, and I'm representing the 37,000 sports officials in the state of Maryland. Today, I'm testifying in front of the committee as sports officials are quitting at a rapid pace. Today, my testimony will direct you to look at the harm that these officials quitting is doing not only to high school athletics, but to youth sports. High school sporting events are being canceled at an alarming rate because of lack of officials. The same with youth sports. When these events are being played, they are sometimes officiated by crews shorthanded. That creates an environment that becomes very challenging and can become dangerous for players and officials alike. 37,000 sports officials in Maryland are not looking for more people to be arrested. We just want to be safe. House Bill 462 will give us that safety net. The individuals that create these unsafe conditions know they are safe in Maryland because the law protects them. Let me say that again. The law protects them. It is important that we show them the state of Maryland will protect us and not allow these types of assaults to continue without repercussions. Maryland is one of few states that does not have a law that protects sports officials. This bill that will become a law will allow law enforcement to make an arrest based on probable cause. Before this bill, they cannot unless they witness the event firsthand. There are many vacant fields, courts in Baltimore City, Baltimore County, and surrounding areas. These fields should be full of young players and adults alike. Lack of sports officials are keeping this from happening. In closing, there are numerous written testimonies sent in by many officials all over the state of Maryland, with several of them contacting members of this committee personally and their own state delegates and asking for the same request. A favorable report and moving one step closer to protecting those that allow these children to enjoy participating in these events. Without sports officials, there are no sporting events. We ask you for a favorable report on 462.
Thank you, sir.
Good afternoon, Mr. Chair, Madam Vice Chair, and members of the Judiciary Committee. I am Marcus Dent. I'm the president of the Baltimore Orioles Board of Trustees, RBI. We're directly responsible for many of the young people that will be participating in baseball in and around the state. We've had to augment and really fill those gaps with our lack of officials with young people. It's a great opportunity for our 14 and older participants to still be involved in the game, still participate as an official. However, safety is of utmost concern right now. In past years, particularly in 2023, we've had an official who was followed to his car and a knife was brandished and result to a 9-year-old call, right? More recently, even last year, down at Carroll Park, we had another individual not affiliated with any other team as a spectator literally throwing things not only at the players, but at the officials protesting calls. None of these resulted in any prosecution, arrest, or anything of the sort other than a pause in the action. Explaining to a 9 or 10-year-old why these things are happening is very difficult as a coach. I do coach 9, 10, 11-year-olds, and ultimately we're trying to provide a safe opportunity for them to learn, play, and grow. And this goes even beyond baseball. This is basketball, football, wrestling. Anywhere we're providing an opportunity for our young people to engage in sporting events, we want to protect those who are there to protect our young people. That's what we're talking about this afternoon. I thank you so much, and I ask for a favorable report.
The Vice Chair.
Thank you, Mr. Chair. This question is for the bill sponsor. Thank you for bringing the bill. Should we just get rid of sports altogether?
Absolutely not.
Okay, I just was wondering. Thank you very much. Thank you, Mr. Chair.
I appreciate the question.
Sure.
Mr. Chair, my question is for the good-looking gentleman on the right. What area do you live in?
I'm sorry?
What area do you live in?
I actually am a resident of the Commonwealth of Pennsylvania, but I run the Baltimore-based umpires, which is a business owned here in the state of Maryland. I moved there because my stepdaughter at the time was in high school, and she just made the varsity softball team as a freshman, and I had no plan to ever tell her that she had to move to Maryland and sleep with 2 eyes open.
So one of the most impactful speeches I've heard since my time in office was from a wrestling coach who talked about the fact that someone got him involved in wrestling and it got him off the streets, and he did that for his kids and the surrounding community. It was really touching. Can you talk about how the youth sports benefits kids and gets them involved in a capacity that helps them grow?
Oh, I'd be glad to. 4 years ago, when we started this shortage with umpires, I was the first one in the country to come up with a umpiring program for 14 to 17-year-olds. Kids who may not be good enough to play on a travel team, kids who just want to stay involved in the sport. And we started this program, and we have a lot of really good kids in the program, and it keeps them in touch with the game. We train them just as if Senator or Delegate Schmidt would come to a class, we teach just that. We teach them how to have their first job. And on several occasions, I've written letters to high schools for them to be part of their admission package So it's very impactful for them young men.
All right, thanks so much.
We're giving promotions. We're giving promotions here today.
Thank you, Mr. Chair. Just real quick. So if we don't change the law the way it presently stands, I guess you could go to a commissioner and the commissioner could give you, issue an arrest warrant, couldn't they?
And that's an interesting
this
story.
This is really for the sponsor. This is for the sponsor, I think.
Oh.
Isn't that true?
I would defer to my counterpart here that probably has some better knowledge on this. He's been through the process.
I've been advocating for 4 years for this, and what started this was in 2019, an official by the name of David Collier, and I have the video. If anybody would like to see the video, I still have it. He was officiating a game in Baltimore City, and a parent did not like a call, charged onto the field, pushed him into a brick wall. Again, we have the video. We have 15 parents who were willing to tell the officer that this happened. When the police officer showed up, nothing I can do because I did not physically firsthand see it. He wouldn't even look at the video. We spent the next 6 months because now the person who's running the program said, well, if the officer can't do anything, we're not giving up the name of the father. So we spent the next 6 months trying to figure out who the father was. And we went to the commissioner's office. We had a detective involved. They would not file an arrest warrant.
So are you saying that a officer who comes to the scene would do a better job of finding the perpetrator than a commissioner would? Is that my understanding? I'm just trying to figure out.
I think it would. And again, what I think the bill will do for us is it's going to protect us because it's only going to take one time for someone to know that there's a bill out there that we now are protected. The Commonwealth, we actually have 2 bills. If you physically touch me in the state of Pennsylvania, that's a second-degree felony assault. And I know we don't like to use the word felony over the last 3 years in the state of Maryland, so that's why we changed it to a misdemeanor. But if you touch me, second-degree felony assault. If you tell me you're going to meet me in my car and do physical harm to me, that's a third-degree misdemeanor. Okay. So it does work because just in Lancaster County, just on December the 20th, a coach headbutted a basketball referee, broke his nose.
But how often is a police officer coming and the defendant or the potential defendant is still there? Is that the situation you're talking about, or is the person already gone?
They're gone.
Okay, thank you, Mr. Chair.
I have a question. So, the person who headbutts a referee is not getting charged for first-degree assault?
Not in Maryland, no. If they leave,
which police officer? I hope you'll provide the committee with which police officer failed to do that. And going over here, the person who brandished a knife is absolutely a first-degree assault. Absolutely no question that a police officer could have charged it. I'd be interested in the police officer who failed to do that. So going to the bill, what I understand, and I'm going to go back to Delegate Cardin's question and ask for an answer. How many times has a referee or an umpire or an official at a sporting event gone to the commissioner and taken out charges?
So if I can speak, what's happening right now, these incidents are happening and they're not even being reported because there is no standing and there's no legs to stand on right now with it. So ultimately, it's never getting to the commissioner. If we call the police, they come out, and since 2019, we had a video and we couldn't get anything done. So now we're in pretty much a no-win situation where we're trying to, in effect, police ourselves. And it's very, very hard to do to make sure, number one, our kids stay in the dugout, get those officials, especially umpires, right? On a basketball court, you can get to the locker room. The umpire's got to go straight from home plate to the car. That is a long walk if you had a very, very hostile environment. And it's really unsafe, especially when we talk about our junior umpires. Because now I'm not going to a car, I'm going on a bike, walking to the bus stop. And if a mom or dad or a spectator didn't like my call, they're going to come after me? That's what we're talking about here.
I guess my questions, there are a couple. One, and something that that I will get further information on. First, if there is video of the event happening, I believe that's sufficient under the law for the officer to charge, but I'm going to double check that. Second, again, the first degree assaults are absolutely within the ambit of the police officer to charge and should have been charged if the situations were as they were put out there. But it sounds like to me that umpires and sports officials also are not aware that they can avail themselves of the commissioner and go to the commissioner and take out charges themselves. As we had another bill here earlier this year that can result in somebody getting a warrant for their arrest. That's a separate issue. But you could conceivably go and get charges yourself if a police officer for whatever reason did it, and if it rose to the level of a second-degree assault. So I guess that goes, so the answer I'm assuming to my question of how many times they've gone to a commissioner is never. Okay. Delegate Kaufman.
Yes, thank you very much, Mr. Chair. And I thank Delegate Williams for the legal education she just gave me. But I wanted to ask either one of these two umpires. You mentioned a bunch of times, because that's where you live, sir, Pennsylvania, but how many states, and if I missed it somehow, I'm sorry, but how many states currently have similar statutes? I'm trying to figure out how much of an outlier Maryland is in not protecting the officials, not protecting officials.
Maryland is one of 23 states that currently does not have a law on the books.
So that means that 27 states do, I think.
That is correct.
Okay, thank you. My math worked. All right, thank you very much.
Yeah, I think one thing that I've noticed in 10 years coaching high school baseball here in the state of Maryland, it's high school typically has some protection. There's sometimes an officer there, whether they're there to do crowd control, they're there as a physical presence. It's the youth organizations that we seem to have the biggest issue with. And typically it's somewhere in that 10 to 12 year age range where kids are either starting to become better at sports or their parents believe that they're starting to become better at sports, right? And so unfortunately, we see a lot of parents that live vicariously through their children, and they think that every play is their son or daughter's scholarship. And so we're starting to see some placards around the state that say, your son or daughter is not going to get a scholarship today. You know, players play, coaches coach, parents parent. And we're working on some measures to prevent some of this, but it ends up being the one play that ended the game or determined the game that creates such commotion during these sporting events. And I witness it, still coaching high school sports today.
I'll go to Delegate Phillips here in a second. But that reminded me, I went to we had a team in South Baltimore that went to the Little League World Series this year, and they have a sign there, and I'm going to read it. We are here to have fun. These are kids. This is a game. The coaches are volunteers. The umpires are human. If you're looking for professional baseball, Camden Yards is about a mile behind you. I think that, maybe we change this bill just to require that sign at places, but I understand it's far more serious than that. Delegate Phillips.
I actually wish you would have included coaches in that. I can remember coaching my girls in basketball and people coming off the bench because they didn't like who I put in. But anyway, that's a different story. But you said something that I was curious about, because I do think there are, various laws that are already on the books that would deal with this, and reasons why the police ought to enforce the laws that are on the books. However, when you talked about Pennsylvania, do you see a law of this nature, if we educate parents, as having a deterrent effect as opposed to just relying on the laws we have on the books today? Would that be the reason to go to do something like this? You can speak to it.
I believe it is necessary because right now, if you sign up your children in rec programs, most of the time you are signing a piece of paper with parent code of conduct. Well, apparently that piece of paper is not working. And because they think it's a right to, again, as Delegate Schmidt said, you know, a bad call gives them the right to attack us. And again, as I said earlier, we're not looking to arrest a lot of people. We're just looking to be able to walk off the field and know we're safe. Because right now, we're not.
And Delegate Phillips, to your point, and we thank Delegate Embry, she helped out at Northwood Baseball League, securing us fencing for the entire league, where one of these incidents actually happened. In lieu of this law coming out, but every league doesn't have that opportunity to really fence themselves in. We do, because of our leadership in the 43rd A. But some of our places like Carroll Park, they're open to everyone. And it may not even be a parent that's under that code of conduct. It's a passerby. It's just a regular fan who can't afford those Orioles tickets. So they try to watch a good brand of baseball, but sometimes, you know, things happen and they may be under influence, whatever the case may be, and that filters into the youthfulness and the spirit of the game.
Yeah, Delegate Phillips, that question was asked in the Senate as well at our hearing 2 weeks ago about the deterrent effect. I think it's hard sometimes, the lack of reporting, to know what those exact numbers are, whether it decreases from 50% to 30 to 20. You know, the ultimate goal is 0%, right, at the end of the day. You know, when I coach my high school team, they say, what do you coach, infield or outfield? And I say, I coach the heart and the mind, because those two things are the most important things that these kids have. And so when we have people on the sidelines that take away from that, that's a problem. And we're working to correct that. Thank you for your question.
All right, seeing no further questions, thank you all very much. That concludes the testimony for House Bill 462. Delegate Grammer, you've got two, starting with House Bill 589.
With your permission, I'll get started.
You go right ahead for 3 minutes.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 589. House Bill 589 puts in place civil and criminal liability for creating artificial intelligence with the capability of causing personal injury or death. Local newspapers described how a Texas juvenile was poisoned against his family. A mother described her son, who we will call JF, as a sweet kid who liked going for walks and attending church with his family. JF unexpectedly started cutting himself. He lost 20 pounds and withdrew from his family. Looking for answers, his mother searched his phone while he slept. She found screenshots of conversations with an array of artificial chatbots. Some of these chatbots were based on characters from popular media. One chatbot suggested self-harm and cutting as a way to deal with sadness. When his parents limited the time he could spend on his phone, and JF reported this to the chatbots, one bot suggested his parents didn't deserve to have children. Other bots suggested he fight his parents' rules. One chatbot even suggested murder. This is one of the many new realities of artificial intelligence, the formulation of realistic personalities that create new types of influence. For young people, this influence can be very formative and in some cases very harmful. Most states do not have a way to deal with this new impact of artificial intelligence. What HB 589 does to attempt to handle this problem is it puts in place a framework for civil and criminal liability. Consumers need some level of protection, and producers need some level of accountability and duty to protect. This bill attempts to do that by putting in place a framework for damages for individuals or families that occur injury or death due to the design of artificial intelligence. With that, I'd be happy to take questions and ask for a favorable on House Bill 589.
Questions? Vice Chair.
Thank you, Mr. Chair. So did you get a chance to talk to any prosecutor about the bill?
No.
Okay, that's fine. I was just wondering a couple of steps along the way, but that's fine.
Okay.
Thanks.
Further questions? Thank you. You have two people testifying in opposition, I think. Aiden Hiskias is coming right up. Margaret Durkin, coming right up. Whoever would like to begin is welcome to do so. You have 2 minutes. Whoever would like to go first.
Thank you. Good afternoon, Chair Klimpinger and members of the committee. My name is Aiden Skass, and I serve as policy analyst for Chamber of Progress. On behalf of Chamber of Progress, a tech industry association supporting public policies to build a more inclusive society in which all people benefit from technological advances, I respectfully urge you for an unfavorable report for HB 589. AI has tremendous potential for improving healthcare, enabling creative expression, and creating new business opportunities. So it is critically important that public policy promotes the broad and equitable distribution of these innovations. HB 589 introduces stringent liabilities for anyone involved in designing or creating AI software, which will have a chilling effect on innovation. By imposing strict liability, regardless of intent, knowledge, or negligence, this bill creates an environment where tech professionals, particularly smaller companies and startups, will be discouraged from pursuing new and transformative ideas due to the constant fear of legal repercussions. Take, for instance, a small AI startup working on groundbreaking healthcare applications designed to streamline diagnostics. Despite the company's best practices, the looming threat of being held strictly liable for unintended issues could prevent it from launching a new, life-changing product. Instead of driving progress, this could result in a culture of caution where developers hesitate to explore new possibilities. This risk could stifle creativity and lead to a slower pace of technological advancement, ultimately hindering progress in fields that could benefit society, such as healthcare, transportation, and environment sustainability. Additionally, the definitions included in HB 589 are overly broad, creating further confusion that will severely hinder progress. The terms design, create, and capability of causing personal injury or death are not clearly defined, leaving developers unsure of their legal responsibilities and how to navigate the law. Rather than fostering a culture of accountability and innovation, HB 589 would create an atmosphere of fear and actively hinder the progress of technology that could have the potential to benefit all Marylanders. For these reasons, we urge you for an unfavorable report for HB 589. Thank you.
Good afternoon, Chair Klimpinger and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director at TechNet, a technology trade association. Thank you for the opportunity for allowing me to speak today on House Bill 589. We understand that artificial intelligence has garnered significant policymaker interest, and our members are committed to the responsible development and use of AI. However, we are concerned about House Bill 589 as drafted. This bill creates a novel liability framework, and components of the bill are vague and unclear, and our members are concerned that this bill could lead to unintended consequences in the AI space. For example, the term capable of or capability in the bill is open to broad interpretation. AI tools have intended uses, but they are also a technology that can be modernized and customized. Given the liability in this bill, ensuring that the correct bad actor is held accountable is critical. However, House Bill 589 creates a scenario where a developer could be held responsible for the actions of a different developer or a deployer. The knowledge standard in this bill does not conform to legal standards. Negligence can result in strict liability in the bill. However, negligence requires the demonstration of causation, yet strict liability does not require causation. We believe that the knowledge standard should be a knowingly and intentionally standard. We're concerned that House Bill 589 will stifle innovation in Maryland and disincentivize businesses from investing here in the state. We believe that House Bill 589 leaves a lot of questions unanswered, and for the reasons stated previously and in my written remarks, TechNet is opposed to this bill. Thank you.
Delegate Pasteur.
Thank you. Thank you, Mr. Chair. This says, for the purpose of establishing that a person who intentionally, et cetera, et cetera, et cetera. And I hear what you're saying. With all of the flourishing interventions, technical and all of that mumbo jumbo that is like mumbo jumbo to me is happening, isn't it important for those who are developing to at least intentionally to mitigate some of the unintentional consequences, to process ways that whatever they're developing can be used. And I just very honestly process Baltimore County and that poor principal who was a victim of that, and how his child was tormented, family. And so though that AI and whatever that person used to create all of that, and the flurry that it created in the system for people, for that person, a whole life change. So whatever he used, shouldn't whoever created that, whatever he used and his ability to do what he did, have processed some intentional uses of it? And this is what I see in the bill, unless I'm confusing it, but I'm really good with adverbs, and I'm looking at the adverbs that are here. It's those little ly words. And so, and so that's what I'm having problems with. So I would like for you, please, to address that, because this is new. So what is the responsibility of the developer and all of these people about whom you're speaking, who are coming forward to do these interesting things?
So we definitely want to hold bad actors accountable, and that is an unfortunate situation that happened in Maryland. However, we believe that this bill isn't the way to do it, but there are other ways to hold bad actors accountable. We recognize that our developers and deployers should have responsibilities, but we think that this language as drafted, it's too vague, which will open them up to really serious liability and not hold in the situation you're referring to, which I'm not familiar with. Our members want to make sure that that person who took those actions is ultimately held accountable, and not the tools that they may have used to create the situation that was occurring.
May I? Yes. Okay. All right. So going with what you're saying, if this is not the answer, what would you suggest as the answer to pour out on folks who are developing whatever it is they're developing, to make them process before there's an incident or while they are in the development phase? What kinds of unintentional uses or consequences they could be as they're in the development mode? So if this isn't it, to have something that says, but if you are knowingly and intentionally, what do they do so that they don't, if they're not knowingly or intentionally, but it's going to be marketed or developed and somebody else might, what do you suggest?
So I would have to take anything back to members. We are a trade association, so I represent many voices. However, as I mentioned, AI, it's constantly developing, so we would want that knowingly and intentionally standard in the bill. There's other issues with this bill besides that, but that is something, if it's knowingly and intentionally, that is something I could take back to my members to double check with. But in terms of the specifics you're getting to, I don't have those answers right now, but I could get back to the committee.
Well, I'd appreciate that, because if we're not liking this, I would certainly like to hear what it is you like, so we could see if we like it and if he could amend it. Thank you.
Thank you, Madam Chair, Mr. Chair, sorry about that. I think I'll pitch my question to Ms. Durkin because I'm familiar with you. So if we have a circumstance where an artificial intelligence chatbot suggests cutting as a way to deal with your personal problems or mentions murder in dealing with your parents, do you think that's an issue we should probably have some sort of liability for?
Speaking on behalf of TechNet,
Generally. From a humanistic kind of protecting society standpoint, consumer protection, let's even call it.
From a humanistic perspective, yes, there should be some liability. However, done responsibly and narrowly tailored so that there is not significant liability that could put these companies in a position where they might not want to continue investing in Maryland.
if we have a circumstance where a chat bot suggests cutting or any other self-harm or murder in any case, do you think that would demonstrate negligence on behalf of the producer, that they could produce a product where a chatbot could suggest that to a child? Generally.
Generally speaking, I'm not an attorney, so I'm not familiar with these legal terms. I will say that in my letter and what I talk about now with negligence and strict liability, I did reach out to one of my members for some guidance because they were an attorney and they had guidance for me, but I can't speak to that right now because I'm not an attorney.
So, and the reason I bring these up is this bill's actually pretty tight. I mean, recognizing that I'm the person who wrote it, but it's, if you read it, the culpability is actually highly defined. And the only case in which there's strict liability is the civil liability. And what we're seeing currently, you know, is a bit of a situation where like some fairly egregious things are happening with artificial intelligence. Texas was lucky that it had, the company who got prosecuted under a fairly broad fraud provision in statute. We don't have that. So which specific portions of the bill do you really have a problem with here? Because it's fairly tightly defined.
I would say our main issue with the bill is in the bill, it's references capability. In my letter, I say capable of, interchangeable. I would say that we believe that that is broad and that an AI tool doesn't necessarily start as a bad thing, but as it goes downstream, some of our members can't control what the user is going to do with that. And so therefore, they're concerned that the phrase capable of or the capability is too broad and would sweep in more companies or products than intended.
Can you offer alternative language?
I can ask our members and get back to you. I did start the conversation based on your email from last Friday, and I brought it up with some of the members that were concerned. I just have to finalize it as it's only been a couple days.
Thank you so much.
Thank you, Mr. Chair. I was chuckling at some of the testimony here. I certainly would say we're in a place where we want Maryland to be bringing tech jobs and tech investment to the state. I certainly have questions about some of the policy implications of this, but by and large, I'd say that. Nevertheless, I think some of the recent cases we've seen that you've heard referenced here do indicate some need to do something more. And I guess you keep using the word, because I know the delegate here is focused on the actual creator of the software and what their intent was, but you use the term deployer several times in your testimony. And I guess I'm curious, if we can't get at what the delegate is trying to do, which is to constrain what the developer of the software has done, I do wonder if we should be asking more of the deployers who know, in fact, how this software is being used. And the generative AI examples, I guess, are the ones that are coming immediately to mind. The Pikesville principal case where it was generative audio AI, and then the other one we've had a lot of legislative discussion on is fake porn or pasting someone's head onto something. And I guess I'm just curious, if you would agree or disagree that we could do something more on mandating the deployers, as you call them, to constrain deployment of this software, knowing what it's being used for. And I get that there are totally ordinary use cases for this stuff. And that in the old world of the internet, we would have said, oh, you don't want to stifle innovation, don't put that on Google or YouTube or whatever. But again, where we are today and how the software is being used, is that not a simpler way of getting at this than perhaps, shutting down the software altogether or going after the intent of the creators?
TechNet represents both the developers and deployers. So if you may have heard that word more than developer, that was not my intent. We represent both of them. And as such, the majority of our members had some concerns about this bill, those who reached out. So again, that would be something specific to your question on the deployer side that I would have to take back to members.
All right, sorry, let me just very briefly then. Is there any state right now that has enacted or is looking at a policy model that the industry is supportive of that actually gets at constraining some of this negative use of generative AI that we're encountering?
To my knowledge, we have not supported a bill in terms of bills that have passed some sort of regulation on developers and deployers specific to bias and discrimination. Colorado passed a bill, but they are revisiting it because it was quite a rushed process. Texas has introduced a bill as well as Connecticut, and then in neighboring Virginia, House Bill 2094 on high-risk artificial intelligence is currently moving through the process. Its final outcome is still to be determined, but those are the main states that I am aware of. There was also a California bill on AI that was sent to the governor, which he did veto because he was concerned about how it would impact the business community in California.
But say the Virginia one you reference, is that one you also are not supportive of?
We do not support that one.
Got it, thank you.
Delegate Phillips.
So this is a real challenging area that is developing. One of the questions that I would have from a developer or deployer is today, as the technology is being developed, are there any controls over use cases of the technology that's being developed specifically for generative AI? Are there any controls that the deployers or developers have placed on their software today?
I don't have specific examples of that I know of, but I can ask our members and get back to you.
Then let me, and this is space age, but the concept of generative AI in and of itself is that it will learn based on the contributors. Is that a fair statement?
That's fair.
And so if contributors include concepts of cutting, include concepts of murdering, then those will eventually make their way into what comes out on the other side. Is that a fair statement?
That's possible.
Yeah, and I know that's really scary to a lot of folks, but unfortunately, that's the concept of AI, particularly generative AI. Is that a fair statement?
That's fair.
Yeah, I just want my colleagues to understand what we're working with. Thank you.
Yes, and I will add, if I may, that it's ever evolving and it's always learning. And so because it's modernizing and changing, our members, like I said, are committed to the responsible use of it. So specific to the suggestions of cutting and murder, that's obviously not something that they would advocate for. But to your question on the controls, I can see what procedures are in place for some of our companies if they're willing to share.
Thank you.
Thank you. Seeing no further question, that ends the testimony for House Bill 589. We're going to move to Delegate Grammer's second bill, which is House Bill 706.
Thank you, Madam Chair. For the record, Delegate Robin Grammer here to present House Bill 706. House Bill 706 alters the penalties for wiretapping. So when we've tried to tackle this issue over the past several years, a lot of folks from the abuse community have taken a real interest in finding a version that everybody can agree on so we can put this issue to rest. And I think we found a version that not only the Senate will agree to, but Delegate Simpson would also agree to. Ironically, she's not here today. This bill changes the penalty of wiretapping from a felony to a misdemeanor, but it also does two other things. It changes the statute of limitations to 5 years, and it allows for restitution to be beyond the limit set in the statute that governs restitution. So it would allow for higher levels of restitution to be obtained in these types of cases. And the idea behind this is that we want to think really hard about the nature of the charge, the criminal charge, and if we're going to lower the kind of penalty it is, but we want to make these folks whole. The damage that a person receives when they've been recorded, frankly, is either personal or monetary. And in allowing for restitution to be at higher levels, we think that version is a version everybody can agree on while moving forward some of the underlying premises that we've been trying to accomplish here for years. So with that, ask for a favorable on House Bill 706.
Thank you, Delegate Grammer. Are there any questions? Delegate Conaway.
Chair, thank you, Delegate, for the bill. So does this bill include public interception of communication?
Public interception?
Uh-huh.
Yes. So between several parties, that would be defined as a wiretap, yes.
Between several parties?
Correct.
Would it include having your cell phone on covertly, I guess you would say?
Yes.
Would it include wearing spy glasses?
Yes.
I guess you could say. Okay, thank you so very much.
Thank you.
Thank you, Delegate Conaway. Thank you, Delegate Grammer.
Thank you.
That concludes our testimony on House Bill 706. We're going to move to Delegate Holmes. Delegate Holmes, House Bill 560. And Delegate Holmes, it's just you on the favorable panel.
Just me.
Just you. And you are enough, so that's good. Whenever you're ready. We don't normally see you in this committee, so we have to give you a hard time.
That is exactly correct, Madam Chair, and such a pleasure to be here with all of these smiling faces.
It's good to see you.
For the record, my name is Delegate Marvin Holmes, and I'm here this afternoon to present you with House Bill 560. I'm not going to be here very long. Because I am understanding now that you have multiple pieces of legislation addressing this very same issue. And let me explain to you first off why I came to put this together. Most of you know that I have a very active real estate career. And part of that is that I am a property manager and I have multiple clients that I manage their properties for, townhomes and single families, for example. On one occasion, one of my clients asked me to get their single family home renovated in preparation for finding a new tenant. I approached the house, which was supposed to have been vacant. I opened the door with my key, and greeting me, rushing towards me, was a Rottweiler, seemingly to be very hungry. To tell you that I was scared is a true understatement. As I looked over the Rottweiler's ears, I saw a family sitting in the kitchen at the kitchen table, which had to have been their own kitchen table that they brought into the home, eating lunch. I immediately slammed that door to prohibit me from becoming lunch, and went around the corner and called the police department. And I just sat and waited for the police to arrive, for them to take action next. Now, as I indicated at the top, you all in this committee have a lot of legislation on this very same topic. If it is your decision to take the language from 560 and to put it into another bill, or to take some language from other bills and put it into 560, I will leave that totally up to this committee. All I'm requesting is that something be done so that this issue of squatters can be addressed properly. That's all I'm asking. And the means by which you do so, you have several bills, I think maybe 4 or 5 in front of you. I'm just suggesting that something needs to be done because I don't taste that good.
Whoa, the lights are on. I'm gonna, I saw Delegate Schmidt first, please.
Thank you, Madam Chair. You know, every time they say it's a simple bill, the lights go on, right? It just seems to be a trigger mechanism. Delegate, I appreciate you bringing this bill. You know, my wife and I also have a successful real estate operation, and my wife was assaulted by someone in a very similar situation. It was not a hungry Rottweiler. It was a person that was squatting in the home. I see the bill talks about the sworn affidavit, and that's been a question that's come up a number of times. And then we also have the question about the police control versus the sheriff control. Can you help us maybe bridge the gap there?
Well, in the situation that I was in, I called the police because that was my first reaction. The sheriff is typically the one that, you know, takes the people out of the home. And I don't really want to have a judicial discussion in terms of which is better or how, or even in the discussion of removing some of the wrongful detainer statutes. I am not a lawyer, and I don't play one on TV on purpose. So I'm going to leave that part of this whole process up to this committee, which knows this subject matter a whole lot more than I do.
Yeah, I appreciate you sharing that. I mean, some people might believe down here that some of your legislation might be more pro-tenant, but this situation is really to protect landlord and property management in this situation.
And me.
And you. Well, you have a partial opinion to that, right? Partiality. Thank you.
Thank you, Delegate Schmidt. Just a quick question. Did you finish your story? What happened after you called the police?
The police came by, and they did not remove them from the house. They did not remove them from the house. They interviewed the persons that were there, the remaining persons that were there. The others had scattered out of the back door and over the fence once they recognized that I had come through the front door. Apparently, there were other persons in the bedrooms that did not hear me knock on the door to come in, so they did not escape as fast as the others. So it took quite a while to get them out before I got the house back on the market.
Through court means, it took them quite a while. Took quite a while to get them out.
It took quite a while to get them out, right?
Mm-hmm. Thank you, Delegate Williams and Delegate Kaufman.
Yeah, so I just want to follow up on the story, though. So define, like, what was quite a while? Like, how long did it take? And by which action did you all use to get them out?
Quite a while was about a month, about 2 months it took to get them out of there and to secure the place again, because I had to go through a process of paperwork with the police department and the court system to explain to both police and the court systems that I was a legal representative of the homeowner with signed paperwork from the homeowner that I was representing them. And it took that a couple of months for me to be able to begin to restore the house again. Hope that answers the question.
Got it. And I have a follow-up question. So did the individuals in the home, did they voluntarily leave, or did you have to use court action in order to get them out of the home?
They voluntarily left, and they scattered throughout the neighborhood. But I was informed that I should not begin to renovate or rent the house out until we go through some type of court process.
Okay. And I know you mentioned wrongful detainer in your testimony, because that was actually one of my questions I had written down beforehand about how the wrongful detainer process, but if you don't want to get into that, that's perfectly fine. But how this would be different than doing the wrongful detainer process.
Yeah, and I appreciate the opportunity not to get into a legal discussion of which I am not qualified. But I do know that there has been a suggestion about the wrongful detainer portions of this, and I am in no way qualified to make any discussions, intelligent discussions about that particular provision.
Okay, those are my questions.
Thank you. Delegate Kaufman?
Yes, thank you, Madam Chair, and welcome to the Judiciary Committee, Delegate Holmes.
Thank you, sir.
I am very fond of you. However, CASA, an immigrants' rights group, is not very fond of the bill. And they say that I wanted to give you a chance to respond because they say they're opposed strongly to it. And they say that your legislation makes the sheriff, the judge, and the jury. And they cite an example of how this harms the immigrant community and how in one particular instance, somebody could not access her husband's insulin because they were rushed out of the house. And so I just wanted to give you an opportunity to, and they suggest a summer study in lieu of your bill. So I just wanted to, can you tell us why you think CASA's wrong? And I wanted to give you a chance to respond to their criticisms.
I do appreciate it. I do appreciate that. And I did read some of the testimony, and it appeared to me that a lot of the testimony that was provided was not based upon someone being in the house illegally. A lot of the testimony that they had was based upon someone having a legal right to be in the home. And some of as an example about someone not having access to their insulin and those kinds of things, that would be the kind of tenant that you would have that had a signed lease and had the real legal right to be there. Now, I think what they may be referring to, which is not the focus of this legislation, what they might be referring to are those persons that prepare fake and fraudulent leases. And those fake and fraudulent leases, because some may not understand the correct process to go through, they are signing those fake and fraudulent leases and then thinking that they are a legal resident into that home. That is not what this legislation is discussing.
Okay.
This legislation that I'm proposing here is referencing squatters in a home. That's it.
Can I have a quick follow-up, Madam Chair? Thank you. My question, though, is I think you're right, but the CASA at least is presenting your bill as a rush job without due process and different things. So how, in your opinion, would a legitimate tenant have the time to present a lease or get their medications or different things? Because CASA's portraying it as get out without due process, which is probably an unfair characterization, but how do we make sure that it's that people have adequate time to present that documentation or get their meds or different things like that?
Certainly. Thank you for the question. In the normal process of evicting a tenant, that process takes a little bit of time to go through step by step. You have to provide a legal notice to the court system. Notices are posted on the door. So those who are in a home on a legal basis are being notified. There's mailing that goes out to them. There's posting on the door. So they have ample opportunity, in my opinion, to retrieve their medications in this example before they are forced to leave by the sheriff. I'm sorry, and I'm using the example of the sheriff because the sheriff is the one that takes possession of the house in my jurisdiction. Other jurisdictions might be something a little bit different. But in a legal process of being evicted, in most cases, those persons who are in that home do get proper notification, and In some of the court systems, you can also get an attorney to represent you at no cost.
Thank you, Delegate Holmes. I appreciate your expertise, and thank you, Madam Chair.
Thank you. Thank you. Let's move on to Delegate Conaway, and then Delegate Grammer and Cardin.
Thank you, Chair. Thank you, Delegate, for bringing this bill to us. Just for the record, I think we have a rule here, a new rule, maybe you didn't hear about it, that anything that's presented and then becomes property of the committee. So I found that out. To be clear and on the record, we're not talking about people with fraudulent leases or people who have a lease and it expired. We're talking about people that should not be in a property that are commonly known as squatters. Is that correct?
That is 100% accurate.
Okay. When the police came, did they take a police report?
Yes, they did.
Did they provide proof positive of who the people were that they talked to?
They only caught, as I recall, 2 of them, and then they did get the identification of the 2 and were able to assess that they were not legal residents of the home. The other persons had already scattered.
Okay. Was there damage done to the property?
Yes, sir, there was.
Were the 2 responsible for it? Were you able to put responsibility?
I was not able to capture any funds from those 2 persons.
Were you able, you said it took about 60 days to reclaim the property, right?
That's correct.
Were you able to turn off the water during that time?
I did not even attempt to turn off the water because I still had to renovate the property again and needed the water to be left on.
Okay, well, I won't get into those legal questions with you, but I thank you so very much for bringing your bill.
Thank you so much for your legislation as well.
Thank you, Madam Chair. I'm glad you're here because you've touched on some real hot buttons, and I think you'll be able to articulate your way through them. Just to reinforce, this doesn't apply to anyone who has a legitimate lease. Is this correct?
That is correct.
Okay. So I had a situation in my district, small family business renovating a home, put it up for market. They start showing the house, and they found that there were folks that would, during the showing, they would unlatch a window, and later they would open that window and come in and squat in the house. And they tended to have like a scheme for doing this. They found that the folks who were squatting tended to do it over and over and over and over again. And I've noticed that your bill, the criminal penalty, it's kind of aimed at those people who are scheming to do this. What are your thoughts on that?
Yes, indeed. And you are correct. Now, I appreciate the question because in the legislation, it talks about repeat offenders. And what I wanted to have done is that I wanted to make sure we had an opportunity to break the habit of those repeat offenders. Because if we don't show them the ill of their ways, they'll continue to do it over and over again. And I just wanted to make sure I had something to say, you can't keep doing this because it's going to cost you more.
So it's not aimed at like the indigent person who's found a spot. It's the person who's fraudulently for their own benefit doing this over and over.
That's 100% correct.
One final question. This applies to, how long does it take under your bill to remove the squatter?
I don't recall.
Okay.
60 days, I think it is. 30 days. No. I don't recall. I don't recall.
Express to the committee the importance of more expeditiously removing a squatter, because from what I recall, the petition necessary for the court to send out the notification that a squatter must leave, that alone takes 10 days.
Yes.
So the process to hear that it's 30 or 60 days doesn't surprise me at all. For the average family business who's just they're trying to make a little money, they flip one house at a time, bring it up to code, renovate it. Express to the committee why it's important that we have a mechanism that expeditiously deals with these circumstances where a person has fraudulently held a property.
I appreciate that question. And I'll take my business model as an example. The persons that I represent in my property management business, they own 1, maybe 2, or maybe 3 houses. These are not people who are wealthy in any means. They are persons who just try to make a living as best they can with these 1, 2, or 3 houses. Having any one of them out of circulation is a significant depreciation of their income. I had the one that is talked about had a child in college, and we had a date certain when we were going to have a tenant in that home. The tenant was just about ready to move in, and now we had to delay that process, and it caused them harm in their family's financial because, like I said, they had a child that was in college and they had to pay their own bills as well. So it is important that we have this process as expeditiously as possible to get these squatters out. And I will rely on this committee to figure out how best to do that. Thank you for your question.
I think you've done a good job at informing the committee. I'm jealous I'm not going to get to work on this bill, but thank you.
Thank you, Madam Chair. Thanks, and most of my questions were answered, but so if you give a sworn signed affidavit to the sheriff or to the entity that removes people in the jurisdiction that you're in, and then that entity, that sheriff, is required to shall remove the person and return the possession to the owner. So if I sign an affidavit saying that property is mine, those people need to be removed, and they don't have anything that says otherwise, the sheriff is just going to go in and take the property away. Is that my understanding of what the bill does?
That's what I would like to have happen.
Okay. So, and if the people that are residing in there, whether it's legal or illegal, say the magic words, the sheriff is then stopped. They say, magic words, I'm legally allowed to be here. Do they have to show him something? Do they have to provide anything to him?
My understanding is, and that didn't happen in this case, if those persons that are in that home show the sheriff a fraudulent lease, then this whole process terminates.
Okay. But what if they just say, no, this is my house?
Then there's an investigation.
So there has to be an investigation. So they can't remove them without doing there's certain process that has to happen.
That is correct.
Whether it's due process, we're not sure yet, but there's some process.
It's a process that must take place.
Okay, thank you, Madam Chair.
Delegate Conaway.
Thank you, Chair, and thank you again, Delegate, for coming in. As I understand it, if you just call the sheriff, there's not an investigation that you have to file, have to make a court filing to get the sheriffs involved with the situation.
Yeah, the sheriff is an intermediary.
After you make the court filing, is that correct?
That is correct.
Thank you very much.
Thank you. Yeah.
All questions asked? Okay. Thank you, Delegate
Thank you very much, Madam Chair.
Thank you.
And members
Good
of
to
the
see
committee.
you. Come back and see us
I
again.
appreciate you all for being gentle with me. I know it's not your intent.
We're glad you didn't become lunch.
Yes, yes. So now we're going to pull in unfavorable. We're going to pull in on virtually Nika Namdi. And then up front, we're going to have Catherine Davis, if she's here, Jake Kimiak, and Samantha Gowing. Ms. Namdi, whenever you're ready.
Sure. Good afternoon, committee. My name is Nika Namdi. I'm the executive director of the SOS Fund and the founder and chief operating officer of Fight Blight Be More. And we do not support House Bill 560 because we recognize how it could be used by tax lien purchasers and ground rent holders where they have foreclose the right to redeem or foreclose on a property to brand the former owners of the property as squatters and circumvent judicial evictions. We also do not support, we are urging an unfavorable on the bill because in a case where someone would actually be a lawful resident of a property and the sheriff shows up the sheriff is going to have to do an investigation at that time and make a determination to remove that person according to the bill. If it is later found that the person was lawfully a resident of that property, their only recourse is to file an affirmative claim. And most of the folks who may be victim to this will not be able to get access to competent legal counsel that they can afford, because Maryland's pro bono legal services providers are not able to do affirmative claims. And so because for those two reasons, one, we feel like it would become police overreach, and because we believe it circumvents the due process of a judicial eviction, we urge the committee to issue an unfavorable report on House Bill 560. Thank you.
Thank you. We're going to move to Ms. Gowing.
Thank you, Madam Vice Chair and members of the committee. My name is Samantha Gowing. I'm an attorney at the Public Justice Center, which is a member of Renters United Maryland, which strongly opposes this bill. I am frequently representing tenants, lawful tenants who are facing wrongful detainer cases. And although this bill is meant to only apply to squatters, as we've heard, it will bring in lawful tenants because it removes the court process and allows bad actors to lie to the sheriff, which I see bad actors lie to judges. They will lie to sheriffs, and this can result in evictions against lawful tenants. I'm going to give a few examples of who very well could be evicted under this law with no due process rights. First, I had a call from a woman just last week who lived in her family home with her daughter and her husband for 10 years. Her husband was violently abusive towards her, abused her in front of her daughter. He was incarcerated for a short time as a result. And she has a protective order against him saying that she can reside in the property. However, he has filed a wrongful detainer action against her as retaliation. And all he would have to do under this bill is provide a sworn affidavit to the landlord that she's wrongfully detaining, and a sworn affidavit to the sheriff that she's a wrongful detainer, and the sheriff could move forward. What if she's not home when the sheriff comes and changes the locks? She loses all of her belongings. She and her daughter get home. They can't get into the property. The amount of trauma that could come from that sort of consequence, it's not. It shouldn't be acceptable. Another example is I represented 7 tenants who were in a rooming house. The landlord had just acquired the property. When a landlord buys a property, they step into the shoes of the old landlord, but a lot of time landlords don't know that, so they file a wrongful detainer thinking that the tenants, lawful tenants residing there are squatters. That's a legal question, if I may conclude very briefly. That is a legal question that a sheriff is not equipped to make. We have to have a judge make those questions of law, or else lawful tenants and people like the woman I described will be evicted. Thank you very much, and I welcome any questions.
Thank you. Delegate Conaway.
Thank you, members of the panel, for coming in to testify. I just have a question about this process. So when a person, the due process of your legal rights or whatever, when a person is accused of being wrongfully in the dwelling, the person that's accusing them, they don't just go right to the sheriff, they go and fill out a complaint, is that correct?
Currently?
Yes.
Currently, you file a complaint that's served on whoever's residing in the property, and you have a court date.
So you're saying under this bill, they won't have to go and file a complaint?
That's correct. Under this bill, they could go directly to the sheriff, provide the sworn affidavit to the sheriff, and the sheriff would evict on that sworn affidavit alone. So
the sheriff wouldn't have to put up a notice of eviction?
No, sir.
Okay. Well, if that's what that says, then you would like to see that be done, right?
I would like for people to have the due process rights, to notice and an opportunity to be heard.
The due process should be if someone files and says, there's a squatter in my house, but they're not really a squatter, the sheriff shouldn't come and just kick you out and make you lose all your items and all like that. The sheriff should come and put a notice on your house when he plans on evicting you. Is that correct?
A notice and an opportunity to be heard in
Right, well,
court.
if you get a notice that you have, that you're subject to be evicted, you can go right down to court and challenge that. Is that correct?
Not if there's not an existing case. They would have to go to circuit court to file a case that would, do an injunction or something. But a lot of people without an attorney will not have the wherewithal to do that. There simply is not the attorney capacity in Maryland to provide free legal services to the amount of people who would be targeted under this law. That's why currently people are brought in as defendants. They're given a date to go to the judge and they can explain it. That is what due process involves, is people have to, there has to be a case that brings someone to court. They can't be required to know and to have the resources to file a case themselves.
That's just very interesting, but I guess I'll see you on my bills, so thank you.
Thank you.
Get grammar.
Thank you. Ms. Gowing? Gowing, thank you. What if the sworn affidavit was done to a judge and you just had a process that was much more quick? You swear to a judge, you get the order that day, and then they allow the eviction.
There still has to be notice and an opportunity to be heard for the defendant. So the defendant still has to have it can't be one-sided. The defendant still has to be able to come to court and present their evidence.
And this is what we hear year after year, that the problem is, as he's expressed in his situation, as I've expressed in my case in my district, it's due process rights that turn into month-long, protracted issues where eventually the squatter is evicted after 2 or 3 months where they've wrecked your home. And you folks continually come up here and just shoot down every solution we have, and then we have to go back to our districts and say, well, you're up the creek without a paddle. Like, you never offer a kind of fix here. And, this is a case, we're creating due process for people who clearly don't belong there. So is there anything between that you can offer to help us create a process that actually works in the cases where we have individuals who are frankly just running schemes on the entire system without any consequence?
If I may offer 2 points. First, the time between filing and trial, that's very quick. That, in my experience, is 10 to 20 days.
Yeah, 10 to 20 days, that's not quick.
I will say when it becomes a month, that's the sheriff being backed up. And this bill, if it's relying on the sheriff and their resources, that it won't address that. It's only taking away those 10 to 20 days that are essential to providing people due process rights. Perhaps there are ways to make that process more efficient. That would be just a kind of different bill entirely. And then the second thing I wanted to say was lift up the idea of that we need some sort of summer study, some sort of having more data. Right now we're operating in a vacuum of data. How many of these squatters are actually happening versus the people who are getting scammed versus lawful tenants? We really have no idea of the landscape right now, and so we need more data before we can go forward on such an extreme measure like this one is.
Thank you.
Thank you.
Thank you.
That ends the testimony for House Bill 560. We're going to move to Delegate Tolles. And that is House Bill 677. And Delegate Tolles, we have virtually Lauren Eaton and Debbie Feinstein.
And Callie.
Okay, well, we're going to go ahead and start.
Smith.
Callie Smith from the Office of Attorney General.
So Callie Smith is testifying favorable with amendment?
Yes.
And that's fine with you, Delegate Tolles?
Yes,
Okay,
I sent amendments to the committee.
Okay, so
Thank you.
we'll start with you, Delegate Tolles. We'll listen to all the favorable testimony and then move to Ms. Smith.
Okay, thank you so much. Hear me? Okay. Thank you so much, Madam Vice Chair Bartlett, and to all of my colleagues on the Judiciary Committee. Thank you for the opportunity to testify for HB 677. This bill is on behalf of the Office of the Attorney General. HB 677 expands the admissibility of out-of-court statements to vulnerable adults. Currently, Maryland law provides these protections for child victims, allowing their statements to be considered under specific circumstances. HB 677 would allow for the exceptions to extend to vulnerable adults. sorry, I scratched up my notes. So vulnerable adults to individuals who, due to disability, living in nursing homes or other circumstances, may struggle to testify fully and effectively in court. This bill is critical to ensuring that victims who cannot always speak up for themselves are still heard. Too often, cases involving elder abuse, exploitation, or violence against individuals with disabilities fail to move forward because victims are unable to withstand the pressures of traditional courtroom testimony. By aligning the law for vulnerable adults with existing child hearsay protections, as outlined in Criminal Procedure 11304, this bill strengthens our ability to hold offenders accountable while maintaining appropriate legal safeguards. Since its introduction, we have worked to refine the language of the bill, ensuring clarity and consistency with Maryland's established hearsay protections. Amendments have been drafted and sent to all of you to align more closely with the child hearsay law, addressing concerns while maintaining the bill's essential purpose. Today, you will hear from the Office of Attorney General, who can provide further legal insight, as well as from victims and advocates who have experienced firsthand the challenges this bill seeks to address. Their voices underscore why this legislation is so urgently needed. So I'm going to, well, first I want to say in closing, to protect the vulnerable adults, this bill, I'm sorry, let me back up. To protect vulnerable adults who are unable to speak for themselves, I urge the committee to issue a favorable report on HB 677. And now I would like to turn to Callie from the Office of Attorney General, who can go into more detail. Thank you, Mr. Chair.
Thank you. Good afternoon, Mr. Chairman and distinguished members of the committee. My name is Callie Smith. I serve as an Assistant Attorney General with the Medicaid Fraud and Vulnerable Victims Unit in the Office of the Attorney General. I am here today to seek a favorable report with amendments on House Bill 677, bill that would allow out-of-court statements of vulnerable victims in certain cases. The rule against hearsay is a cornerstone of the legal system, but in some cases, allowing this form of evidence to be considered is not just appropriate, it is essential to justice. This bill is modeled on an existing Maryland law that provides such an exception for child victims. House Bill 677 asserts that vulnerable victims also deserve an exception that allows their statements to be heard in court. I am here because vulnerable adults are often targeted by abusers, scammers, and sexual predators due to their disabilities, mental decline, and physical frailties. I am before you today asking you to give power back to these victims and ensure they can participate in the justice process. I am here to talk about Ian and Grace. Ian is a 34-year-old male with an intellectual disability that requires 24-hour residential care. One weekend, Ian was assaulted by a caregiver in his own home. The following weekday, when Ian went to his day program, he was dressed in dirty clothing, had multiple bruises and a swollen ear. Once in a safe place with trusted people, he told his social worker, Lauren, who you are going to hear from, about his injuries. After years of working with him, Lauren knew how to properly communicate with Ian. He was able to articulate what had happened and how he had been hurt and by whom. The police were notified and they opened an investigation. Unfortunately, his abuser was never prosecuted. Ian's communication is limited. He could not give a full narrative of the incident. He could not testify to the full facts. If HB 677 had been law at that time, Lauren would have been able to testify about Ian's statement, and Ian would have had the ability to pursue justice against his abuser. Grace was an 84-year-old wheelchair-bound resident. May I finish, please? Thank you. Was an 84-year-old wheelchair-bound resident of a nursing home. One day, as she was quietly soaking her feet, a medical technician walked into her room to administer her pills. The medical technician became frustrated because Grace was more focused on her feet than taking her medicine. That technician struck Grace in the face, grabbed her hand, shattering the fragile bones in her 84-year-old finger. Doctors said it would require surgery, but Grace was too frail to undergo the procedure. Instead, her hand was left maimed and of limited use for the rest of her life. She lived several more years. Grace provided a statement to police about what happened. That was recorded on body-worn camera. Unfortunately, Grace died before the trial of her abuser. Due to COVID, this took nearly 3 years. Grace was the only witness to what happened that day.
All right.
Although we had her statement on video, that was hearsay. Without Grace and her testimony.
I'm sorry, I'm going to need you to wrap up now,
The
please.
case would not have moved forward. We ask that you give voice to vulnerable victims. And for those reasons, I ask for a favorable report with amendments.
All right. Questions?
Thank you.
Delegate Kaufman.
Delegate Toll's excellent bill, and I'm proud that you have the support of the ARC Maryland. I was just wondering if you had had a chance to review the judiciary's testimony, and if you're amenable to their suggestion that, I think it's on page 2 or something, that you change a shall to a may. I don't remember the specifics.
Yes, I did look at that and had a discussion. I am open to working with the judiciary, of course. If Kylie want to go into further detail about the shall versus may, if I can, Mr. Chair, turn it over to her. But I don't mind working with them, but there is a justified reason why we did the shall versus.
Okay, I'm interested in hearing that. Thank you.
While we respect the judiciary's request to go from shall to may, these are very sensitive cases, and part of this legislation is asking for a hearing within a short amount of time so that we can preserve the statements made by these victims and preserve the due process of our defendants and alleged abusers. In order to do that, having a hearing immediately, shall have a hearing, does impact the nature of the case. If they don't have a hearing, if it's a may and the judge decides not to have a hearing, that evidence doesn't come in if the witness passes away or if their mental decline increases. That's why we have shall, because we want to protect the due process rights of a defendant as well as the dignity and respect of these victims who have gone through such a traumatic experience. So we want a shall so that we can ensure that they have their ability to be heard.
Thank you both. Thank you, Mr. Chair.
Thank you. I missed the 2 people who are testifying virtually in favor, so let's hear from them, and then I'll go to Delegate Eric Hansen. Ms. Eaton, please, for 2 minutes.
Good afternoon, Mr. Chairman and distinguished members of the committee. My name is Lauren Eaton. I'm a licensed behavior analyst, board certified behavior analyst, and senior director of operations for Itinerus, an organization that supports autistic adults. And I'm here in favor of Bill 677, a bill that would allow out-of-court statements of vulnerable victims in certain cases. And I'm here because of Ian. So in August of 2022, we picked up Ian like any other day. He was dressed in unseasonable and dirty clothes. When he arrived, he went to the bathroom to change his clothes, and while changing, he said, ouch. As he was taking off his shirt, we saw bruises on his chest and his arm and a red mark on his back, and he was visibly terrified. We took photos of the bruises for record-keeping purposes. Later in the afternoon, someone from his residential provider that's not affiliated with Itinerus came to question him, and he was visibly fearful. Afterwards, he went into the bathroom to lock himself in and cry, and wouldn't come out until everyone had left and he felt it was safe. He had been in a heightened state of anxiety the rest of the day, and honestly the next few months, filled with anxiety, crying, and dangerous behavior, including self-harm statements. I had been working with Ian since 2012, and this was unlike any other day I observed. I personally sat with Ian to ask him about the bruises, and he was able to share information with me, including where he got them, that it was at home, that it happened at night, that it happened on more than one instance, and he could give me the name of the person who gave him the bruises. Maybe a week later, I was with his team in a meeting, and I remember feeling awestruck because instead of believing Ian and holding the staff accountable, the residential provider was cold, sterile, seemed to be coached by lawyers, were withholding information, and seemed generally less concerned about Ian's pain and trauma than protecting their own people and company. As someone who had known and loved Ian for 13 years, there was no human part of this human service organization. May I continue?
For another 10 seconds.
He was, wasn't able to go to trial because he would have been likely deemed incompetent or incapable, but when asked in the right way, he was able to share that information. Just because he didn't pass the test in court doesn't mean that he couldn't communicate accurately what happened. He did this on July 28th and August 16th. He just needed to be in a safe, familiar environment with safe and familiar people and communicated with in a way that he knows how and that makes sense to him.
Thank you very much. Ms. Feinstein, please.
Thank you. Good afternoon, Chair Clippinger, members of the committee. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I also am the chair of the Elder Vulnerable Adult Abuse Task Force for Montgomery County, which focuses on multidisciplinary conversations to enhance the safety of vulnerable adults and seniors in our community. I'm going to essentially need to, but I'd like to just provide one brief example. We had a case in Montgomery County, and this is just one of many examples. We had a case in Montgomery County where the defendant was charged with sexually abusing her son, a vulnerable adult with intellectual and physical challenges. During the investigation, the victim made statements to social workers, and his statements had 11305 been in existence and had the necessary prerequisites been met, his statements would have come into evidence at trial, and a statement that was made, again, close in time to the event and met the guarantees of trustworthiness outlined very specifically in the statute. This is akin to what we see in child abuse cases that my office routinely and my team routinely prosecute. 11304 has been instrumental to our ability to hold offenders accountable and to provide justice for children who are victims of sexual abuse, who in the same way make that original statement close in time to the time that the offense occurs and in a way that is safe and comfortable for them. I would urge this committee's support of HB 677. Thank you for your time this afternoon.
Now, Delegate Eric, please.
Thank you, Mr. Chair, and thank you guys for being here. So along the lines of my dear colleague, Delegate Kaufman, there's a couple of other opposition testimonies in here, and I just want to give you an opportunity if you wanted to sort of respond. The ACLU brought up the issue of.
Can you speak up?
Oh, sorry. The ACLU brought up the issue of like a potential Sixth Amendment violation, not being able to confront your accuser. So I guess, and I'm trying to think through that in my head. I can see why that would be an issue potentially. Would you be amenable to something like allowing for them to do so via Zoom or remotely? Or is this just your goal is to completely get rid of the option for them to have a back and forth? I mean, cross-examination is important. I think we can all agree that. So would you be open to sort of other options that would still protect the person, keep them off site, but allow them to still have that back and forth?
Well, that's not completely accurate. They still will be able to confront their accuser. You have to do so by law. You cannot confront your accusers. Let me take this off.
Yeah, thanks. Sorry.
Yeah, and I'm going to turn to Callie, but you can confront that confuser, your abuser. So that's not entirely accurate, and I will go turn over to Callie to give more detail.
So this statute does in fact it protects the right to confrontation. This is modeled after 11304, which does give the right to confrontation. And that right to confrontation is specifically in the language where there is a hearing. The court shall hold an evaluation hearing to determine the time content. And at that evaluation hearing, a defense attorney, the defendant, and the victim will be present. There will be an opportunity to cross-examine that witness as to both the witness, the vulnerable victim, as well as the witness giving the testimony of the hearsay exception. There is absolutely an opportunity to confront that witness. What we're asking for is a hearing as early as possible to maintain that statement from the vulnerable victim, as well as to have them available at trial. We are not saying that they would never be able to cross-examine that witness, and we do ask for Zoom testimony. That is also part of the bill.
Okay.
To protect their ability to testify at a nursing home or in a facility if they can't make it to court.
Okay, so you guys feel like you've appropriately addressed the concerns of the ACLU. I'm sure we'll hear from them, but yeah, I'm glad to hear that you guys thought through a lot of that. All right, thank you.
You're welcome.
Okay. Seeing no further questions, thank you all very much. I'm going to go to Vanita Taylor now in opposition for 2 minutes, please. There you are, 2 minutes.
Here I am. Good snowy afternoon, Chairman Clippinger and members of the House Judiciary who are still there. This is Vanita Taylor from the Public Defender's Office. We are requesting an unfavorable report on House Bill 677 for the following reasons. We believe that this does not protect people's rights to a Sixth Amendment right to confrontation. Also, it does not have the necessary due process protections that are available. This bill is akin to the child tender years exception, but it is not. It does not offer the same protections as the tender years exception. It also does not have a list of people who are credible reporters that this information could be given to, like the child tender years exception. It does not allow for an evaluation of the child or the adult regarding their trustworthiness. The evaluation is of the statement that was given to someone who does not have to be an expert or someone with necessary authority. Today you heard testimony from social workers, but this bill does not require those statements to be made to a licensed professional as the child tender years exception does. In addition, what this bill does not do, it does not require any assessment or evaluation of the person. But what it does do is, I will tell you, in 1 year, according to this bill, I will be a vulnerable adult. Just because I'm 68 years old in a year does not mean that I have all of a sudden become a vulnerable adult. It also, it assumes that someone with a disability, physical or mental, does not have the capability or the ability to speak up for themselves and be able to confront their accuser. Please consider the ACLU as well as the public defender's testimony and do not give this bill a favorable report. Justice should not be easier. Justice should be timely and it should be fair, and your due process rights as well as your right to confront your alleged accuser should be maintained.
Thank you. Questions? Delegate Phillips.
So I would like to ask to the Office of the Public Defender, because I do think you raised a good point. The tender years exception, if we had a definition for a vulnerable adult or a vulnerable person, that would equate to, in essence, the way we try to protect those in their tender years, and we applied the same standard, would that be something that OPD would support?
I don't know, Delegate. I have not seen any amendments, but to equate adults to children is very dangerous because adults have their own different issues that children do not. The tender years exception was granted because of the concern that we need to protect children and because of their minority. And we, do that because of children. This is ageism and ableism.
So I have to say this, I'll share this. When I was growing up, we took care of, my parents took in my grandfather, and I would come in from school and he would say something to me that has stuck with me. He said, "Young man, if you live long enough, you're once a man and you're twice a child." And we take care of our children because of their tender years. At some point, if you live long enough, and there's often a chance that you become those tender years again. So it seems to me that maybe this does make sense. Isn't that so?
That may very well be so, but if this bill says at 68 years old, there may be people in this committee that are 68 or almost 68 like me, who do not consider myself a vulnerable adult. And I may at some time need a protection, but I need a protection that is clear that I don't violate the due process rights of someone else.
And I guess what I'm saying is it may not be you or I in our 60s, but there might be persons who are in their 60s who are in the same state as they were in their tender years. And I don't know how we decide that and whether we use an arbitrary age, but shouldn't we be concerned about our persons? And it might not be an age thing, but shouldn't we be concerned about persons who fit into not necessarily the state's definition of vulnerable, but who are vulnerable individuals?
Yes, and those individuals probably should be evaluated to determine if they are in that capacity.
Fair enough.
All right, seeing no further questions here.
Bye.
Water bottle is
Impeding your.
not transparent. Delegate Tolles.
Thank you. Delegate Pasteur is over here assaulting me for this 68 being in the bill. But do you agree that's in current statute, Madam Ms. Taylor, my good friend Vanita Taylor? Do you agree that 68, the age of 68 years of age is automatically, when it comes to protections for our senior population, is already in current statute?
I am unaware of that's currently in statute, that at 68 you become infirm and feeble and a vulnerable
No, that's not what I
adult.
said. I said the age of 68 is already when you talk about senior and other laws around protections. 68 is sort of the starting age based off.
I'm not aware. I'm sorry, but I am not aware of that.
Yeah,
I know
I can
68
show
is when
you.
you can get your Social Security benefits, the most you can receive, but I'm not aware of that anywhere else in the language.
So you gonna start getting Social Security benefits next year?
I very well may, Delegate Tolles. I will be 68.
I don't believe you. So also on page 2, do you not see the definition of vulnerable adult? You said you didn't know what vulnerable adult is. Adult who lacks the physical or mental capacity to provide for the adult's daily needs.
And then it says,
or 68. Right, but I broke it up into 2 parts because that age is something that's already in statute, but also you said you didn't have the definition of vulnerable adult. So I just wanted to point that out. I believe that you have all of your mental capacity. So I definitely don't think you will fall under vulnerable adult. And then we also, I'm not sure if you have the amendment, but I'll be happy to share it with you, where it says a court shall hold an evaluation hearing to determine whether the time, content, and circumstances of an out-of-court statement made by a vulnerable adult victim or witnesses provide particularized guarantees or trustworthiness. Did you not receive that amendment?
I don't have that amendment. However, in the tender years exception, it clearly identifies who these statements can be given to. And the list are all professionals that these statements can be given to. In this bill, these statements could be given to anyone.
Okay, we don't necessarily agree with that, but I will show you the amendment. Thank you. And I want to echo Delegate Phillips' comment that we definitely, his quote, he said it was perfect. Ditto what he said, and I appreciate him for that, but it's totally the case. Isn't that so? Thank you, Mr. Chair.
Are there further questions? All right, seeing none, we thank you very much, and that concludes the testimony on House Bill 677. Now, Delegate Simpson. Delegate Simpson is here. She is not feeling well, but she is going to present her bill. Look at her. Oh. Okay, she's both waving and waving. All right, so we're going to go ahead and hear from her on her bill. What we're going to do, we'll take the people who may or may not be in the room. Christine Obuye. What? Zoom, great. All right, well, I'm just going to go down the list and I'll get to 5 more. I did not pronounce her last name, though, very well. Timothy Bradford. Zoom, not Zoom? Ooh. Jessie Dunleavy, come on up. So she's here. Dan Rabbit, I think I'm gonna, is that you? Okay, that's 2 at the table. Darcy Kerwin Garber, there's 3, here we go. Cola Anderson, come on. Wait, oh, Zoom? It's supposed to be on a Zoom. Okay, those are the last people that I have in person. So what I'm gonna do is I'm going to, okay, and I see Cola there is on there. That's 5. So we're gonna hear from the delegate virtually, then we'll make our way through the people at the table, then the 2 people who are on virtually who are not Delegate Simpson, and we'll go from there, all right? Oh, look, it's even a different picture now. Don't know what to do with ourselves. Delegate Simpson, please, for 3 minutes.
Okay, thank you all for allowing me to present without sharing my germs with you. So we request a favorable report for House Bill 556, the drug paraphernalia decriminalization. This bill, this is the 5th year in a row that it has been introduced. In 2021, this bill was passed by the House and the Senate, but was vetoed, unfortunately, by the governor. So we are very thankful. I am very thankful to Delegate Cardin for passing the torch to me. We want you to vote once again favorable for this, this bill to remove the obstacles to treatment, to stop criminalizing legally purchased items. I understand that the opposition doesn't want to lose any tools in their toolbox, even if for more than 30 years it's not worked. So we hope for a favorable report. Thank you.
Very succinct. We're going to go from my right to the left here in the room, and then we'll take the 2 people who are on virtually other than Delegate Simpson right then. Go right ahead.
There we go. Thank you, Chair. Thank you, committee members. My name is Darcy Kerwin Garber, and I urge a favorable report on House Bill 556. I've been a public health and social service professional for over a decade. That includes local and state health departments, community clinics, homeless shelters, and I currently work at a syringe service program in Baltimore City. So one of the things we're talking about today is a syringe that happens to be one of my personal ones for my diabetes, but is the exact same type, even brand that we have on outreach services for our community members. This sterile syringe is a life-saving tool. It is a life-saving tool for anyone who uses syringes for whatever reason, and it doesn't make sense to criminalize any Marylander for holding it. Now, I have the privilege of engaging with hundreds of your constituents every single week on outreach while we're doing services. These are constituents that are coming, they're showing up for themselves, for their loved ones, making sure that they have sterile supplies like this to reduce the transmission of HIV, AIDS, to reduce bodily wounds, overdose, and death. And to be clear, there is nothing inherent about injecting or smoking drugs to the transmission of HIV and hepatitis C. It is only through the sharing of paraphernalia like this that holds that risk. And so currently, our Maryland laws incentivize this sharing of syringes, and it incentivizes the littering of syringes. Because it makes sense that if this is dangerous, legally dangerous to hold in public, that you might want to share a syringe instead of holding it on your person or having sterile supplies. It also makes sense that you want to get rid of this as soon as possible after you've used it, even if you're in a public space and don't have safe disposal. And the research does confirm this. So currently, Marylanders are forced to choose between what is healthiest and safest for themselves, for the community members, versus what is legal. And so if I have this syringe, and I also happen to be carrying this spoon, now I'm at risk of 4 years of incarceration or a $25,000 fine. Doesn't make sense for a life-saving tool. We have participant cards that protect from some of these legal measures, but these can be easily destroyed, ignored, or lost. So in the support of common sense measures that incentivize health and safety, and for the dignity of our loved ones and your loved ones who use drugs, we urge a favorable report. Open to any questions afterwards. Thank you.
Hi, thank you, Chair Clippinger and committee members for letting me speak in favor of Bill 556. I'm Jessie Dunleavy, a lifelong Marylander, and I have devoted myself to drug policy research since my son died of a fatal overdose in 2017. Thankfully, since that time, we've learned We've learned that we can't conflate addiction with moral deficiency. We've learned that people struggling with addiction are usually victims of misfortune well before their drug use. And we've learned that punitive measures, especially for those who don't violate the rights of others, add disadvantage on top of disadvantage and fail to make a positive change. In essence, there is growing recognition, urged by the American Medical Association and others like them, that saving lives calls for a shift to health and safety and away from punishment. And we have taken health-centered steps. Naloxone's a good example. We don't arrest you for carrying it. We want everybody to carry it. We want it everywhere. It is a life-saving tool. But deaths are still and in fact, it's credited with the recent reduction in overdose deaths. But deaths are still at crisis levels, so we need to take all of the life-saving measures that we have before us. And decades of evidence show us that syringe service programs do just that. They reduce overdose and they reduce the spread of disease. Paraphernalia policy should prioritize health and safety, but restrictions on syringe service programs limit their scope, hamper their success, and work against the spread of disease. I'm sorry. Also important to know that overdose deaths are increasing among Black Americans, and that Blacks and whites use drugs at the same rates, use and sell at the same rates, but Blacks on average are twice as likely to be arrested. Our confusing paraphernalia laws make us vulnerable to structural racism, and confusing laws cause confusions for users and police. It can be simple. Just make paraphernalia laws about safety. You did it before. Please do it again. Thank you very much.
Good evening, Chair, members of the committee. My name is Dan Rabbit. I'm the Policy Director for Behavioral Health System Baltimore. BHSB is the local behavioral health authority in Baltimore City, overseeing the mental health and substance use system there. We're in strong support of HB 556 as a way to take another important step in the direction of putting overdose prevention first. This bill is necessary to make it safer and easier for people who use drugs to participate in syringe service programs. These programs have been shown to reduce the spread of infectious disease, to increase the opportunity to build relationships with people who use drugs, and help them to seek a road to recovery. Ultimately, syringe service programs save lives. But under current law, the criminalization of drug paraphernalia discourages people from engaging in these services, makes people skeptical that they'll be safe and can trust going to syringe service programs. If we were to decriminalize drug paraphernalia, it would have no impact on increasing drug use or maintaining drug use. I believe that it would actually reduce drug use in the medium term, as people would be more willing to engage with providers and have that support necessary to choose recovery. Arrest and criminal justice involvement through possession of drug paraphernalia is not a sound strategy to encourage treatment or recovery. Addiction is powerful, and it is a connection to someone who is compassionate towards you and cares about your situation that can help you break the cycle of addiction, not penalties hanging over your head. That may work for some people, but it leads to fatal overdose for just as many. People who go to jail upon release are 10 times more likely to suffer a fatal overdose. It's a compassionate connection to caring providers like those at syringe service programs that can help people to address addiction and achieve a road to recovery. We urge a favorable report.
Thank you very much. Okay. I'm going to go first to the person from the Baltimore City Health Department, Ms. Ogbue. Maybe?
Yes, the Ogbue. That was good.
All right, good. 2 minutes, please.
All right. Good afternoon, Chair Clippinger and members of the committee. My name is Dr. Christine Ogbue, and I serve as the Assistant Commissioner for the Bureau of Ryan White and Community Risk Reduction Services at the Baltimore City Health Department. I'm here on behalf of the Baltimore City Administration to support this bill. House Bill 556 will lead to more people accessing syringe service programs. And this will echo some of what you've heard before. Syringe service programs are also called SSPs. SSPs provide clients with clean syringes and connect them to health and social services, including addiction treatment. They also provide naloxone and overdose prevention education. SSPs have been legal in Baltimore City since 1994 and statewide since 2016. According to the CDC, SSP participants are 5 times more likely to enter drug treatment and 3.5 times more likely to stop using injection drugs. Let me repeat that. People who use these programs are 5 times more likely to enter treatment and 3.5 times more likely to stop using injection drugs. Even though SSPs are legal, we often hear from our clients that they're afraid to engage with our program due to fear of being stopped by police while in possession of syringes. We need to pass this bill to help more people engage with SSPs. SSPs have other benefits too. They reduce the rates of infection like HIV and save counties money through the ripple effect of the health services they provide and refer clients to. They also reduce syringe litter. In the past 10 years, our clients have returned more than 10 million syringes. Importantly, SSPs do not lead to increased overdoses, criminal activity, or accidental needle sticks among law enforcement. Please note that this bill is about paraphernalia for personal use, not for manufacturing or selling drugs. What it boils down to is that the current laws are not working. The state is still in the throes of an opioid crisis. If there was a time to pass this bill, it is now. I urge you to vote favorably on House Bill 556. Thank you.
All right, thank you very much. We'll hear now from Cola Anderson, please, for 2 minutes.
Hi, my name is Cola Anderson, and I'm reading testimony on behalf of a syringe service program participant who gave me the consent to do so. Dear Chair Clippinger and members of the House Judiciary Committee, my name is Charlene, and I live in Baltimore City. I am a 58-year-old and regular voter. I also use drugs and have been a participant of the Baltimore Harm Reduction Coalition for almost 5 years. I am writing today in support of House Bill 556. I pick up harm reduction supplies from BHRC almost every week, and almost every week I return used syringes, usually hundreds at a time, for safe disposal. I was stuck with a syringe as a child in the 70s. I was lucky I didn't catch any disease like HIV or hepatitis C, but someone else's child may not be as lucky. As a user, it's imperative to get syringes off the streets, especially used syringes. Even as a protected participant of a syringe service program, I'm still a little concerned about being stopped or arrested for carrying syringes with me. I'm very careful to stay away from places that would be problematic, places where I'm more likely to get stopped. When I have to go to those areas, I don't bring syringes or what I need with me. I know other people who are concerned, and they do the same thing. They're limited and isolated in where they can go in the city. I also know people who are harassed and checked on by police on a regular basis. They do not carry new ones, sterile syringes, on them and risk not having what they need when they need it most. I've also seen people pick up syringes off of the ground when they don't have one. They know the risk, but they're too scared to pick up sterile harm reduction supplies. The decriminalization of paraphernalia wouldn't mean that we would use drugs anywhere, but that you could bring syringes anywhere without worry. It would also be make returning syringes a lot better. Fear of being stopped is a big reason why people don't return their syringes. They don't want to get caught with them. I ask the House Judiciary Committee give House Bill 556 a favorable report. Sincerely, Charlene. Thank you.
Thank you. Questions for the panel? All right. Seeing none. Thank you very much, all of you. I'm sorry, what was that? I know, I'm not done yet. We got another group. Oh, wait, they're not on there yet, though. Is it just the one? Who is it? Okay, well, let's hear from them then. Fine. Jeremy Browning, please. There he is. Go ahead.
Hello, Chair Clippinger and the committee. My name is Jeremy Browning. I use he, him pronouns, and I'm the director of the Maryland Commission on LGBTQI+ affairs. The commission was created by the 2021 Maryland General Assembly to assess challenges facing LGBTQI+ communities and to establish recommendations and best practices for inclusion. The commission strongly supports House Bill 556, which would repeal the prohibition against the possession and use of syringes. This critical measure is an overdue step towards advancing public health, reducing harm, and addressing the disproportionate criminalization of marginalized communities, including LGBTQ+ Marylanders. For transgender and gender diverse individuals, particularly those undergoing gender-affirming hormone therapy, access to sterile syringes is a medical necessity. Current laws that classify syringes as drug paraphernalia may result in transgender Marylanders being unjustly targeted. By decriminalizing possession, HB 556 helps ensure that individuals can carry and obtain necessary medical equipment for any reason without fear of legal repercussions. Beyond LGBTQI+ communities, this bill promotes broader public health goals by reducing the risk of syringe sharing and related health complications such as HIV and hepatitis transmission. Criminalizing harm reduction tools only exacerbates public health crises rather than addressing them. So for those reasons, the commission urges a favorable report on HB 556. Thank you.
Now, any questions? Still seeing none. Thank you very much. That concludes the testimony in favor of 556. There was one person signed up in opposition, but she is not there, so that'll conclude the testimony altogether for House Bill 556, and we thank you all very much, and please drive safely. House Bill 544 is next, and if I speak kind of slowly, it'll give Delegate Moon the opportunity to get up there. James Johnston is here. Tom Moronic is here as well to testify. Those are the people I have in writing, but I think Ms. Dufour is here doing the opposite of what everybody is doing today. She was down virtually, but come on up. You're down virtually, but you're here in person, so I don't know what to do. And I see Laura Rhodes, don't know what to do.
I assume that's okay.
I see Laura
People
Rhodes
head straight into the snowstorm.
So this will be everybody. Delegate Moon for 3 minutes, everybody else for 2.
Thank you, Mr. Chair. House Bill 544 is a bit of a potential strange bedfellows bill. This basically is a reform of Maryland's assault law, and it basically is trying to take what is a very broad statute that tries to shunt lots of types of offenses into second-degree assault and to split out a third category of third-degree assault. This was last attempted in 2018 by the previous leadership of the committee, Vice Chair Dumais, Chair Valerio, joined by former Delegate Deb Ray and MSAA in the House of Ruth in 2018. Not all of those folks support this version of the bill, to be clear, but I just want to give you a sense that the broad concept of reforming assault has a history of wide support. So why is this necessary? First degree assault, felony, maximum 25 years. It's causing or attempting to cause serious physical injury or assault with a gun or strangulation. Pretty serious stuff, felony 25 years. Next category goes down to second degree assault, and you get everything else. Any unwanted touching or contact, whether or not it causes injury. And in some of the testimony we've heard today and in other bills, you hear exactly how this can go awry. You have folks who are neurodivergent or have disabilities who may be overcharged. You've got people going to the commissioner alleging on their word that an assault had occurred and all of the serious things that may happen from that. And to be clear, there are obviously some very serious things that happen, but there are also lots of cases that have much smaller incidents where the conduct technically counts as a legal assault. Someone touched me. You might even have a very minor shoving match if people are in a heated dispute. And this, again, puts you suddenly in a category where you're in with other folks who committed very serious crimes up to 10 years. So this bill would create a third degree assault category, it only applies if there's no injury, no risk of serious injury, and the language here specifically excludes domestically related offenses, specifically excludes sex crimes, and certainly won't include assault with firearms. All of those are covered by the more serious categories of assault. And you will hear from some practitioners about how this plays out in the real world.
Yes. Good evening, Chairman Clippinger, Madam Vice Chair, members of this distinguished committee. My name is Christine Dufour, and I'm a lawyer with the law firm of Jessica Moise, but I'm here in my capacity as president of the Maryland Criminal Defense Attorneys Association. We're an association of 400+ attorneys from every county throughout the state, and we consider this bill a priority bill. I can't tell you how many times I've been in court where actually a judge says, I wish I had a lower option for some offenses. In the testimony that was given to you, the written testimony, there's an incident or a case that is referenced, and that was my case. I had an individual who is 30 years old, but with the intellectual IQ of a 6-year-old. He was with his peer support, which is his one-on-one caregiver at his day home at lunch, and she was very frustrated that he went to throw out his lunch again because in the past he complained an hour later of being hungry. He took his clamshell, styrofoam clamshell, and threw it at the peer support. It hit her, did not cause any physical injury. She went to the commissioner and filed second-degree assault charges against him. I can't tell you the level of anxiety that this basically man-child, 6 foot tall, but literally without the capacity of anything beyond a 6-year-old, had every time I visited at his place of the peer support group or at court. The level of anxiety was high. It was months before we were able to get his case dismissed. He was found incompetent. A finding of incompetency is not a quick process. He was not taken into custody, but the stress of facing 10 years in jail, he did understand that concept. And I'm not saying that the peer support, he could still be charged under this bill, but the penalty would be significantly less. Thank you. We urge a favorable report.
Thank you, Mr. Chairman. I am Tom Moronic Jr. I know many of you. I am the senior partner of Moronic Law, LLC. I'm also on the board of the MCDAA. I come to support this bill because it will create a common sense category for a lesser assault. Right now, you have judges, and there are several who have done this, given 10 years on a person with no prior record for an assault. 10 years. That has happened. And the reason that this is so important is it takes away certain kinds of assaults from being in that category. As Delegate Moon, Vice Chairman, so well said, there's a situation where we already have a statute for first-degree assaults. We already have a statute for the most serious. And this bill excludes the type of assaults where you could get a judge who just wants to send a message and punish somebody completely out of the norm for something that doesn't deserve it. So what we're saying is, let's have the discretion. Let's have the discretion by creating a different kind of offense that is a lower category offense, but doesn't cover the swath of up to 10 years and a $2,500 fine for what might be, as Ms. Dufour has testified, just a minor assault. Think about it. Somebody could bump you in the grocery store in the line with their cart, okay? And that's an unwanted touching. That is a second-degree assault where you could get 10 years from a judge who said, I just don't like any kind of offensive touching. This bill creates a new category where the assault where somebody's being pummeled and severely hurt, but not quite enough to be first-degree assault, where this keeps things in line. So I think it's a great bill.
Thank you. Good afternoon, Chair, Vice Chair, members of the committee. My name is James Johnson. I'm also with Maryland Criminal Defense Attorneys Association, attorney in private criminal defense practice. The 2018 bill was a great bill. This is a great bill. There were some things in the opposition materials that I think it's important to touch on. One, the way this bill is written, the way this process is designed, you have assistant state's attorneys in control of charging decisions so that the new offense that's created, third-degree assault, is not a lesser included offense. For example, a person who's on trial for first-degree assault, they are able to be found guilty by a jury of first-degree assault or second-degree assault. That's Maryland law right now. They would not be, unless the prosecutor chose, able to be found guilty by that jury of third-degree assault. It's only if prosecutors want that charge to be there. The carve-outs are important. Domestic violence is carved out, but also the way it's carved out because you see any registrable sex offense, domestic violence is including, in this case, anyone who's eligible for a protective order. So that's also vulnerable adult abuse and the individual who had a sexual relationship within the last year with the person. The way that we charge things now, if you look at second-degree assault, there are forms of second-degree assault on a law enforcement officer, which is felony, within a correctional facility, either against an inmate or against a correctional officer, that have those extra elements. The commissioners are able to issue those charging documents successfully without issue. So I think to the extent that that is in the opposition materials, I think it's been taken care of by the way that the bill is drafted. The last thing I'll say is if we look at some of our surrounding states, we have that maximum penalty of 10 years. Tom talked about that at length. Virginia, for example, class 1 misdemeanor, 1 year for the same sort of conduct. Pennsylvania, 1 year, 2 years, or up to 5 years for the more serious misdemeanor assaults. So I think that's important because it puts in context that we have what is a misdemeanor currently with up to a 10-year penalty. This bill would help resolve cases. I think that's an important point. Thank you.
Ms. Rhodes, please.
Good afternoon, Chair and members. I'm Laura Kelsey Rhodes, a former president of the Maryland Criminal Defense Attorney Association and an active criminal defense attorney and immigration lawyer. I urge a favorable report on HB 544. I want to show you, in line with what Mr. Johnson was saying, what an outlier Maryland is on this statute. I got information from the National Council of State Legislators for this, and Maryland is, according to them, the highest state, that penalty of 10 years, it's the highest in the country for any misdemeanor. They have 24 states who cap it at 1 year. You've got 8 states that cap it at less, 6 months or 90 days or 9 months. The only ones that are other exceptions are what Mr. Johnson just stated, but no one comes close to Maryland. So what's the consequence of this? One of the consequences is that we have categories of people in our state who are like being affected by other harsh consequences because of this 10-year mark. For example, I mean, one of the major groups is immigrants. We know that also hunters have bars against them for getting guns, for hunting, if they have an assault like this under the statute, under Maryland statute. And one reason for that is that the federal law defines a misdemeanor as what we used to learn in law school, under 1 year penalty, that's a misdemeanor. Over a year is a felony, not in Maryland. So the federal law makes this harsh for hunters, and particularly for immigrants. For example, if you have, and the harm to our community is kind of global on this. If a grad student from Belgium comes to get an advanced degree at Maryland, and they have a minor assault, just one more, their student visa could be revoked. Same with DACA and TPS people. Everybody is a risk just for this one offense, depending on their status. Thank you.
Okay. Going to take questions. No, that's Steve Kroll. He's in opposition. Yeah, no, we're not going to hear from him yet. Lots of other people want to be heard, though. And let's start with Delegate Erica, and then we'll go around.
Thank you, Mr. Chair. Thank you, Delegate and the panel members. I just wanted to give you an opportunity, if you wanted to respond to, there's been a lot of unfavorable testimony provided by, victims of domestic violence. I know you did attempt to make a carve out. Would you like to expand on that, Delegate, and to sort of tell us how you tried to address their concerns and if there's any sort of wiggle room that you have on the current posture that you might switch it to address more of them?
I mean, we can talk about additional language. It's trying to be quite explicit that if it's a domestically related offense or a sex offense, it's just simply not going to count for this lower category. I read through all the testimony, and again, I will note, in the 7 years ago, there was a version of this bill that House of Ruth supported. So I do believe there's a road to get to a yes on this. And again, some of the testimony suggests that maybe the state's attorneys are not tagging every case properly as a domestically related case. I don't know that to be the experience, but I guess that was one of the concerns. If that's a concern, certainly we can look at ways of tightening that up. But I will point out one aspect here, which is why I say this is sort of a real policy concept. OPD's not here at the table. I just want to flag that. And at least from some of the discussion I saw, part of the thinking is, well, you might actually have some people who are more likely to actually get convictions under this lower standard who right now the judge is going to say, I'm not going to throw this on someone for that minor offense. So I think it does cut both ways. But again, I'm totally happy to work on the DV issue.
Though one other thing I wanted to mention was in one of these testimonies, I just want to get it wrong. I'm sorry. I'm so sorry. I'm just musing. There was something else. Oh, they said there was some overlapping between second and third degree. I don't know if you had looked into that, but that was their concern, that there was potentially some overlapping on
to split out, like it being a lesser included crime or something. I mean, we can, again, if we need to finesse the language, I'm happy to get there.
Okay. Yeah, I think some of the examples you gave definitely warrant further looking into this.
Mr. Chairman, thank you, delegate and panel, for coming in to testify. Okay, I heard two terms used in the same example. I believe it was stated that a student was here from Belgium and they had a visa, but they were maybe an immigrant. Was that correct?
Yes, that's the example I was giving.
And they were immigrant.
Correct.
So, but their visa was revoked?
They could face revocation.
Yeah, I understand
that.
Is a visa a privilege?
Yes, it is a privilege.
Oh, okay. So it's just like when you drive in your car and it could your license could be revoked because driving is a privilege, right?
Right, and the driving laws are set out very clearly, so we know what they are in advance.
No, I wouldn't agree with that. I would strongly disagree with that. So my second question is, an example, not for you, an example was given where there was a 10-year sentence potentially for one of the patients or something. What was that 10-year sentence for?
So, and I don't like to
let's
call out specific judges.
We can move on.
Well, I'm happy to answer your question.
Okay.
Basically, a judge sentenced someone to 10 years in jail on a second-degree assault, and that's somebody who doesn't have a prior record, and it's a situation where if you hold someone without bond on an appeal, they're sitting in jail. The only way they get out without an appeal bond is by filing a habeas corpus, which is, and I'm pretty sure, delegate, with your family, you know all about those, but basically, I had a few of those. But basically, it's a situation where they're just going to be held unless a judge says holding them without bond is not acceptable, and there was a clearly erroneous decision not to do so.
Well, honestly, without knowing the details of the situation, I don't think that it's really fair to try to color the judge a certain kind of way.
Right.
Yeah, because sometimes some people, maybe more people need to be sent a message.
Well, but see,
what about that?
This is the thing, Judge. This is the thing, delegate. It provides the leeway. It provides the options and the leeway. And I agree with you.
I'm quite sure the judge is aware of that. But anyway, let's move in right into the heart of it. So one example was given when someone is bumped with a cart at a grocery store.
Yeah.
That shouldn't be a 10-year sentence?
In theory, yes. I'm not saying many judges would do that. Probably very few would ever do that. But I'm just saying the law allows that.
Yeah. What's wrong with that?
What's wrong with it?
Sure.
To bump someone with a cart in a grocery store? You're saying there's nothing wrong with giving them a 10-year sentence
There's
for
nothing
that?
wrong with you getting a 20, as far as I'm concerned, because a person might have a bad hip, or you might re-injure their hip. I mean, you don't know if they have a bad back or something like that. You could permanently injure a person with a shopping cart in the supermarket.
Delegate, I just want to clarify, this bill only applies if there's no physical injury
Well, I'm
and
just going
no
off of
risk
what
of
he
physical
said.
injury.
I'm going off of
Okay.
what the witness stated. So you should have corrected him and said, don't make those statements if he doesn't want me to.
No, I think that's why there's the carve-outs, Delegate. I think
Okay,
that's
thank you
why
very much.
they are carved out.
Thank you.
Yes, and I thank I know the hour's late, but I do have a question. And that is, Mr. Majority Leader, you indicated that some people who are charged with second-degree assaults are in with people who committed much more egregious crimes. And can you give some examples of some of the more egregious crimes these individuals are lumped in with?
Well, I guess right now, there's no distinction for the types of offenses we're talking about. Once you get past the, first degree felony and second degree felony, which all involve strangulation, a gun, or you committed the offense on a law enforcement officer, again, after that, it's everything together. It's the spitting or a shoulder check of someone as you're passing them on the street, all the way up to a full-blown bar fight with injuries. So again, the range of behavior that's being captured in second-degree assault up to 10-year penalty, it's a pretty harsh frame to cast certain behaviors in. And again, I think the result is you get some counterintuitive activity where maybe some people who probably they did do something, not warranting a 10-year assault conviction, might actually get off instead of having a much smaller penalty. There's other things that I would point to too, sentencing guidelines, immigration consequences, the firearms. Again, not every one of the small offenses is going to fall in a category where I think you ought to trigger those collateral consequences.
Thank you, Mr. Majority Leader. Thank you, Mr. Chair.
Delegate Valentine.
Thank you, Mr. Chair, and thank you, Delegate, and thank you, panel, and thank you for bringing this bill. I for one, have thought for years there was something missing in the assault charging language. I did have one question about page 2, down on lines 22 through 24, where you talk about a person may not engage in conduct intending to put another in fear of offensive conduct or contact. My question is, are we saying that we could actually charge someone, a victim could pursue charges against someone because they feared or have fear of a contact?
Yes?
Yeah.
Yes, that's existing. This, again, you can charge someone under existing law for threatening to beat the heck out of someone and cause that injury. And again, that would be replicated here, but without the injury component. So again, it's just splitting this out.
Yeah, Delegate, that's under the Maryland assault statute now encompasses the different theories. So, I'm sorry. I'm sorry. It encompasses several theories. That's from the common law. So it's assault, battery, and then assault with intent to frighten. So that's in the statute, or at least in the law at this point today. So to your point, though, I think an individual could, at least in theory, receive a 10-year prison sentence for that sort of conduct where no one's injured, no one's even really attempted to cause that injury. And I think that's something that we're looking at here as a positive with this bill.
Not letting Delegate Conway back, let me ask the question. I'm sorry, Mr. Moronic, but I would ask you to provide to the committee, please, the name of the defendant, the judge, that went so far outside the sentencing guide. I mean, I'm presuming it's a circuit court judge?
District.
It's a district court judge? Okay. I don't for a minute believe that it has never happened. I think that it has happened. I don't think that someone gets 10 years for a second-degree assault unless there's something else there. There's something on their record, or it's possibly a first-degree assault that's getting pled down to a second. But I digress. I guess one of the questions that popped into my mind, I I saw the 90-day penalty, and it kind of made me wonder, okay, but what if you see this behavior over and over again? What if, is there a door open for some kind of subsequent offender here or something like that for that?
If I could answer that, Chair, I think the beauty of it is because the prosecutors control, because it's not a lesser included, then in this circumstance, you're in Anne Arundel County, you file a CI, it's now a 10-year penalty, and you've made that decision as the ASA who took a look at the case. And there's no out. I can't now plead to third-degree assault. I can't now try it and hope for the second or the third-degree assault, but you really control that penalty. So it's got, in a sense, because of that overlap that I think Delegate Erican mentioned, it's got that built-in ability to then allow for a higher penalty if appropriate.
All right.
And I'll just, Mr. Chair, I'll just say it's I hadn't thought of, so I haven't spoken to the folks up here who requested this bill about this, but certainly movement on the 90 days and discussion about what if you have a repeat offender seems like entirely worthy topics to consider.
Okay. The other question, going back to the domestically related crime, you don't really know whether it's going to be tagged a domestically related crime until after. It's not until after the fact, unless,
If I can respond to that?
Yes.
That may be true that it might not be formally domestically tagged, but you and I both know that oftentimes when someone's going to a commissioner or going to seek charges for assault second, they're also looking for the protective order. So the judges are routinely, at least in my county where it's a small county and where I practice on the Eastern Shore, the judges know that two things are riding parallel to each other. So they already know it's domestic in some sense.
So it's more like the prosecutor and everybody, we know that it's likely to be a domestically related crime at the end. I guess I just sort of wonder, I think the language is important because it's trying to send the signal to the world that this is not meant for DV.
Exactly.
But at the same time, it's a little disingenuous because you can't, it's using the magic words in such a way that makes you think that there's something going in that, and I remember this committee dealing with that issue more than 10 years ago when dinosaurs roamed the earth. So I'm not going to get more into that.
But Mr. Chair, if I may as well expound, I think that goes to the prosecutor in charging it. And there's ways to handle that often in the charging. And as Ms. Dufour stated, the nature of the case, the nature of the offense, I think it provides a lot of discretion for prosecutors who know the facts better than anyone.
My issue isn't that. My issue is more that I think it says to the world that there is some kind of charge for a domestically related crime, which was an issue that we dealt with more than 10 years ago, when that doesn't exist. There's not a crime for, there's not a domestically related assault until you go through the whole process and pop out the other side. So I'm not necessarily quibbling. I understand why it's there. That's fine. And I'll say one more time about the 10-year thing. I get the point of the bill, and I get the point of trying to distinguish in the areas of the law between second-degree assaults that are more serious and not. So my point about asking for the specifics is more to say, okay, well, what is at the top end that justifies a 10-year sentence with no priors and no anything else? There has to be something more serious there than not. And I'm going to stop now. Delegate Conway is going for a second bite of the apple and will be relatively brief.
Thank you, Chairman. I'll do my job the best that I can. Delegate Moon, thank you again, panel. So Delegate Moon, you did state spitting. It would be a terrible 10-year penalty for spitting on someone. Is that correct?
No. I'm saying there might be circumstances in a spitting case that won't be warranting 10 years. Could you conjure a fact pattern that might sound like a 10-year? I'm certain that's possible.
No, I wouldn't conjure one. I was going to ask you about, suppose a person has active hepatitis, COVID, or active untreated HIV. So I've known people who said that they've intentionally done things like that. So I was just wondering if you wanted to respond to that.
Again, it's just the range of behaviors. You might have a very harmless spitting, you might have a very harmful spitting, but all of it's getting shunted into the same category.
The judge will be able to determine that, right?
I guess, but again, when you look at case search, when you look at some of the consequences, the conviction for that might have a lot more serious collateral consequences than one had intended for a pretty minor offense.
Well, I would hope you support my bills to teach these type of things, the collateral consequences of a criminal conviction to our people.
I'll read them
Thank
again,
you
I
very
promise.
much. Appreciate you.
Yep.
Okay, that's this panel, and those are the people in favor. Thank you all very much. We're going to go to those people opposed now, and I am going to find the sheet of paper that I'm supposed to look at. Steve Kroll, Bill Katzif.
Mr. Chairman, members of the committee.
Yes, hello. I'm sorry, and I think there's one more. Is it Joanna? Oh, there's Joanna. Okay, I see you. All right, I see all three of you. We'll go in that order. Mr. Kroll, if you've got your, yeah, okay, we're good. Mr. Kroll, Mr. Katzif, and Ms. Mupanduki. I'm not doing well with names today. Mr. Kroll, please, for 2 minutes.
Thank you, Mr. Chair. Mr. Chairman, members of the committee, good afternoon. I am Stephen Kroll, the Executive Director of the Maryland States Attorneys Association, and I've been prosecuting cases for over 40 years. Here on House Bill 544 and asking for an unfavorable report. Third-degree assault, a brief legislative history. It starts with HB 488 in 2018. Prior to the 2018 session, Joe Valerio, then chair of the committee and noted criminal defense attorney, wanted a crime third-degree assault and tasked the vice chair of this committee, Kathleen Dumais, as negotiator and sponsor of the bill. After long and difficult negotiations, it was agreed upon that third-degree assault would be supported only if second-degree assault is included in the crime of violence. Joe Valerio, chair and criminal defense attorney, agreed to co-sponsor the bill. Second-degree assault is a crime of violence under Public Safety Article 5-101C3. Now, the criminal law article 14101 is not included. This bill would bring uniformity to both selections. The bill would mean less jury trials with more district court appeals, more discovery for state's attorneys. The bill does have problems, and it does have a problem with the rule of lenity. Chair Valerio put the bill in the drawer, and the bill has not been brought forward for 7 years. The MSA does not agree with any part of the bill. It does not include any part of the bill we could agree upon. For those reasons, HB 544 is asked for an unfavorable report, and I'm happy to answer any questions.
Mr. Katzif.
No. Can you hear me now?
Yes.
Okay. Mr. Chairman, members of the committee, my name is William Katzif. I'm an assistant state's attorney from Anne Arundel County here on behalf of the Maryland States Attorneys Association. On behalf of the States Attorneys Association, we're obviously in opposition to House Bill 544. Let me first of all indicate that it's unnecessary, and I think the current law is working fine. The current law has essentially been in effect since 1996 when the General Assembly revised the assault law from the crimes and punishment under Article 27 to the criminal law article. It essentially created two levels of assault. First degree assault being the felony assault for the most serious assault, one that it evidences an intent to cause serious physical injury as it's defined in the statute, which means that it essentially adopts the old maiming law, and also those situations where a firearm is used. And the second degree assault, the misdemeanor assault, included everything else. Now, including everything else means that a judge can sentence somebody to anywhere from probation before judgment up to 10 years. Depending upon the facts of the case, the background of the offender should determine whether or not the defendant gets a sentence on the higher side or on the lower side. Let me say one other thing. I screen cases. That's what my responsibility is. Commissioner charges, say first degree assault. I review the facts and I determine what the appropriate charge ought to be. Most of the time, or at least a good percentage of the time, I will reduce the charges and send it back to district court because I don't think it quite reaches the level of a first degree assault. I don't think there's a need for a third degree assault. And I would also there's the issue is, if there was that opportunity, should I include that? Because if I didn't include it, that's not an option for the judge or for the jury. And the issue is, should the judge or jury have every available option? I could take that away from them if I wanted to. For that reason, I and others, I would urge the committee to give the bill an unfavorable report.
All right, Joanna.
Thank you, Chair and members of the Judiciary Committee. My name is Joanna Mupenduki. I'm an attorney and currently serving as the Deputy Director of the Maryland Crime Victims Resource Center. I would strongly oppose House Bill 544. In my 17 years in the legal field, many of those also as a prosecutor, I've seen the impact of our legal decisions on the victims of crime. First and foremost, I think it's essential to recognize that the individuals we represent at MCVRC are looking for justice and protection. They do not view the option of a lesser assault charge as beneficial. Rather, they deserve the strongest protections available under the law. The existing framework for assault already encompasses the behavior described under the proposed third-degree assault bill. By adding a third-degree classification, we risk diluting these protections and making it harder for these victims to achieve justice. Moreover, we know that the current system does not effectively carry out the necessary convictions as it stands. While second-degree assault can carry a serious penalty of up to 10 years in prison, the vast majority of those cases actually end up languishing on stet dockets. They leave victims without resolutions and potentially vulnerable to further violence. Rather than creating a new and more convoluted classification of third-degree assault, we should focus on enforcing existing laws to ensure that offenders are held accountable. When looking at other states that do have lesser degrees of assault, there's actually multiple levels of assault, typically 4 different levels, with first, second, and third generally being felonies and being multiple levels. And in the vast majority of those, the lowest level, 4th degree assault, is a 1 year amount. So 90 days is incredibly lenient and should not be considered. I would urge this committee to have an unfavorable report. Thank you for your time.
Thank you, Mr. Chair. Thank you guys for being here virtually. Mr. Kroll, you know how much I just adore you, but I love your testimony basically just said Joe didn't like it, so we shouldn't like it either. So I'm just wondering, you know, we heard, I don't want to mess up your last name, Mapenduki's testimony, you know, about other states. Is there some kind of splitting the baby that can be done here where we can come up with something? I mean, obviously 90 days is maybe a little light per other states, but is there no chance that y'all would come to some kind of kumbaya moment? Because some of the stories, I mean, spitting on somebody, should they be looking at 10 years? I mean, have you ever charged somebody for spitting on somebody with, you know, trying to get the maximum 10 years out of that? Have you ever done that? It seems a little
And as far as getting hit by a cart, it's got to be an intentional act. So just bumping somebody is not a 10-year penalty. So now that my script is off, let me just tell you what I really think. Number one.
Yes, good.
I don't have to read from anything anymore. I was just part of the reading part. But this is what I really feel. Number one is we don't need this penalty like Mr. Katz has said. Number two, I'm willing to talk to Delegate Moon, but nobody talked to me prior to filing this bill. And I repeat, nobody. But I'm always available to talk to Delegate Moon or any of the parties involved. Can we split something? I'm not sure about that, but I'm willing to talk to them about it. Is there room for another bill and room for compromise? Always. So that's me not reading a script anymore, me telling you from me to you. I hate reading scripts. You know that. It's not me.
I know. I wanted to give you an opportunity to not read the script, just tell us from the heart how you really felt.
Well, that's how I really feel. We don't need this law, but I'm willing to talk to everybody.
Okay, thank you.
She hasn't asked a question today. Delegate Avery.
There we go.
All right. Thank you, Chair. Breaking my streak. But I just want to make sure that I understand crystal clear from the prosecutors. Is it your position that even if prosecutors charge only second-degree assault, and also given the language, the lesser included language in the statute, is it your position that the rule of lenity would apply even if third-degree assault was not charged?
I think it's a question we have to consider. I think we need an AG opinion on it, my personal opinion. I'm worried about it, very worried.
Okay, I appreciate it. Thank you. Thank you, Chair.
Oh, maybe we should get that AG opinion. Hi, Mr. Kroll. Good to see you. We haven't seen you all year. I don't know what to do with myself. But I guess my question was kind of along the same lines of Delegate Erican. I mean, there's lots of states that have third-degree assault, and the sky hasn't fallen in those states. And so I'm trying to figure out, like, is there some, like Delegate Erican said, is there some type of middle ground where we can find? Because there's lots of states that do have third-degree assault, and crime isn't necessarily, you know, astronomical more there than it is here. So how would this, like, just, I don't know, cause the sky to fall? I'm just trying to figure this out.
First, how are you, Delegate Williams? It's nice to see you. And second of all, here's my problem with the bill. You've got inexperienced, overburdened, and underpaid prosecutors that would plead anything down to third-degree assault if they could, just to move the docket. And then you get the defense bar saying you're discriminating against some people because they're getting a third-degree plea, and we're not getting the third-degree plea. So I'm worried about that, the rule of lenity, altogether when it comes to third-degree assault. So that's my honest opinion with it, and that's why I think we need a new bill, but that's my concern.
Okay. All right, thank you.
And Delegate Williams, I'm not going to read from the script again, I promise you.
You can stay on script. I'm okay with you staying on script.
Mr. Kroll, so your concern is both that there might be a lenity problem, but also that prosecutors would be criticized for using one as opposed to another and using it too much?
I'm sorry, Mr. Chair, I didn't hear you.
You just said that you're worried that prosecutors might be criticized for using third-degree assault too much as opposed to, or too little. Okay, and then you also have a concern, a lenity concern as well.
Yes.
Okay, I guess. All right, I have questions that have popped into my head that I didn't think I was going to have, but I guess I'm kind of wondering whether there is some room for some discussion here about this. In that I wonder. It has been 30 years since we've had a real discussion about this, and maybe we need to have a real discussion about this. I will say the previous panel, you know, saying that people got 10 years fresh out of the gate. Again, with respect, I feel like there's got to be something else to that story there. The flip side of it is, having seen plenty of these second-degree assault cases, I guess my question comes back to there are some times that it's a second-degree assault and sometimes that it's not. And we have a lot of those cases where people are just, you know, kind of fighting each other and engaged in mutual affray. Everybody's a victim, and what are we really doing here? So I guess my question, you said you don't agree with any part of this bill at all?
Not with my concerns.
The effective date? You're against the effective date? Or, I mean, any part of this?
I'm keeping an open mind, Mr. Chair, and I have to go back to my committee, but at this point in time, I don't agree with the date that the bill was enacted, no.
All right.
I just don't think we need a third-degree assault. I just don't think we need the bill. Second-degree assault, if you could show me 10 years, more than once, twice, I'd like to see that. But again, when Mr. Moronic says you bump somebody, that's not an intentional act. That's not 10 years. Judges aren't giving 10 years. Most people are getting probation for judgment or stets. They're just not getting 10 years.
I guess my other question would be, and I'm going to leave it at this, but are you concerned because second-degree assault shows up in other parts of the code as being a crime of violence, and that it has an impact on other parts of the code? Is that part of the concern here, that it impacts like the public safety article's definition, or?
Well, in my written script, which I didn't like reading, basically it says it's in the public safety article, but not in the criminal law article. And the reason the last bill failed was Chairman Valerio didn't like the idea of putting it in the criminal law article, even though he agreed to it and consented to be a co-sponsor to the bill. My point being is, that's one of the reasons we agreed to settle. So the last time I came to the table with Dorothy Lenig, with now all the people involved who've written to you, and we all agreed upon second-degree assault comes in as a crime of violence, and we welcome third-degree assault. Then nothing happened for 8 years. So we put a lot of time and effort to cross the aisle, to reach an agreement, and it went nowhere. A lot of time, a lot of effort. With the vice chair, with the chair, all went for nothing.
Well, that was 7 years ago, so maybe we'll think about it a little more. Are there any questions? Seeing none, thank you all. Oh, I'm sorry, Delegate Conaway, go ahead.
Thank you very much, Mr. Chair. Thank you, panel, for coming in to testify. I know that bumping is a very light situation to some people, but in certain communities, bumping or spitting on someone can directly lead to extreme levels of violence. So I didn't hear anyone speak on that, but I just wanted to make that point known to you. So thank you very much. If you had any comment, I'd be glad to hear it.
I thank you for bringing it to our attention. Thank you, Delegate, for doing that.
Thank you.
Anyone else? Seeing none. Thank you very much. That concludes the testimony on House Bill 544. The vice chair has been sitting at the other end of the room where it is presumably warmer. And we're now going to hear House Bill 675, although she hasn't taken off her jacket. Lisa Jordan and Laura Jessic are supposed to be virtual, and they're here. We have Andrea Mansfield is favorable with amendments. Do you want to share the table with Andrea Mansfield? Oh, dear. Oh, dear. All right, and let's bring on Carissa Hatfield as well. If they're here virtually, we'll start to, what I'm going to do is hear from the people who are here to testify favorably. Then we'll hear from the two people who are favorable with amendments. Then we'll take questions. The vice chair for 3 minutes.
Thank you, Mr. Chair. I am bringing this bill on behalf of Chairman Valerio. No, I'm just joking. Do you want me to press the button? Okay, there we go. And I'll also let you know that there were several windows that were cracked, so that's why it was so, yes, that's why it was so cold in here. Okay, let's move favorable. No, okay. So, okay, thank you so much, Mr. Chair, and thanks for a little bit of lightheartedness. We're actually going to talk about something that is not lighthearted, and that is rape kit testing. But we're going to talk about the fund so that individuals can actually get their kits tested. So we, Sandy Bartlett for the record from Anne Arundel County, and I'm here to present House Bill 675. We urge a favorable vote on this bill because what House Bill 675 will do is expand the purpose of the rape kit testing fund. So that's already been in existence. We receive federal funds, we receive state funds. We're going to talk about the state funds, also known as SOC-T. You may hear that acronym. So what this bill will do is expand the purpose of that grant fund to allow the Office of the Attorney General to assist law enforcement. Currently, law enforcement can receive funds to do investigations of crimes and also other things that are listed in the bill. But what we want to do is be able to allow the Office of the Attorney General to assist law enforcement in the investigations of crimes involving sexual assault evidence collection kits that were collected before 2020 but have not been tested. Additionally, the bill will enable MCASA, the federally recognized state sexual assault coalition, to provide victim notification and support services, which is crucial. And finally, it provides support to the peer-to-peer telehealth program that we passed last year. This is a non-lapsing fund, and it's not intended to support the sexual assault evidence tracking system because that receives funds under another mechanism. So there's still an enormous amount of work that needs to be done. This is very meticulous work. It takes time, it takes collaboration, and it takes compassion. So this rape kit testing fund is essential in keeping the promises we made to survivors, and we must ensure that we continue to provide the funding needed to complete this assignment. For these reasons, I urge a favorable vote. Thank you.
Sure. Good afternoon, Chair Clippinger, members of the committee. My name is Jane Krinke. I'm here on behalf of the Maryland Hospital Association in strong support of House Bill 675. We want to thank Delegate Bartlett for bringing it forward. Hospital-based sexual assault forensic exam programs, or SAFE programs, employ forensic nurse examiners who are specially trained registered nurses who care for survivors of various forms of violence. Many of the hospital-based SAFE programs rely on grant funding to support their staffing and infrastructure costs. And as a result, these programs can face challenges with staffing, especially providing 24/7 coverage. In rural and less populated areas, it's even more challenging. As required by state law, all hospitals have a protocol in place to ensure survivors of sexual assault have timely access to an exam. However, this can result in survivors being transferred to another hospital to receive an exam. House Bill 675 expands the eligible uses of the Rape Kit Testing Grant Fund to include support for peer-to-peer telehealth. Allowing hospitals to tap into this fund for workforce and infrastructure needs to support the establishment of these peer-to-peer telehealth services can help support the existing forensic nursing workforce and expand access to care. Telesafe services can be helpful during case consultations, supporting during the exam, as well as training and simulation. It's a valuable resource for supporting, again, access to care and serving survivors. Many Maryland hospitals rely on federal funding to support their workforce and infrastructure needs. As you know, there's a lot of questions around sustained federal funding, and so having access to state funds is more important than ever. And for all those reasons, we ask for a favorable report. Thank you.
I'm support with amendments. Do you want me to go next or wait till after? Okay.
Let's hear from the other people virtually who are testifying in favor. We'll hear from Laura Jessic first, and then we'll hear from Lisa Jordan.
Good evening, Mr. Chair and members of the committee. I'm Laura Jessic, the Sexual Assault Kit Initiative Manager at the Maryland Coalition Against Sexual Assault. CASA is the coalition of the rape crisis centers across the state of Maryland, and our office includes the Sexual Assault Legal Institute, where we provide direct representation to survivors of sexual assault in Maryland. We're here in support of House Bill 675. Without CASA's victim notification program, thousands of survivors would not be informed of the status of their rape kit. Every day, our team reviews cases and contacts survivors that have been left without information about their kit in their case for years or even decades. In one case, a survivor that was raped by a stranger in 1998 was informed in 2023 that her kit was finally tested and her rapist was identified as a serial offender. In early 2024, she was asked to report to the local sheriff's office for an interview and to relive everything that happened to her. The detectives told her that their next step was to interview the perpetrator, and they gave her hope for justice. Recently, she asked me what she did wrong, because to this day, the perpetrator has not been interviewed and her case has gone nowhere. I've reached out to the Office of the Attorney General to request that their cold case investigators take on this case, and it is my hope and the survivor's hope that with the support of the OAG, she will finally see progress. And this is just one of almost 500 cases that the OAG investigators have received. CASA's work goes beyond notifying survivors. It includes advocating for each survivor's right to be treated with respect and dignity, because Maryland's law enforcement agencies continue to drop the ball. In 2 of our cases, survivors raped in the 80s contacted CASA's opt-in line in April 2024 to learn about the status of their evidence. One survivor waited 8 months to learn that her perpetrator was a serial rapist and murderer that had confessed to raping her. The other continues to wait for answers. By allocating some of these funds to the Victim Notification and Office of the Attorney General cold case investigators, CASA can continue to provide survivors with the information they deserve, and investigators can work to hold offenders accountable. For these reasons, CASA urges you to report favorably on House Bill 675.
Lisa Jordan, please.
Thank you, Mr. Chair, Madam Vice Chair. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault here in strong support of House Bill 675. Madam Vice Chair, thank you for your leadership in this area and for letting us stay out of the snow. As you've already heard, this is both to support peer-to-peer telesafe, but it's also what I would call a backup plan to finish the job that Maryland has already started. Test, investigate, and notify victims about the rape kit backlog. Federal money has been paying for Maryland to address over 6,000 untested rape kits in the state. The federal grant runs out in September, and we are hoping for more funds. But Maryland has really struggled to spend that money, and we've been informed that if we return any money this time, we're not going to get more. Plus, you may have noticed that there are some issues in Washington. So what House Bill 675 says is if we don't get any more federal money, if there is still a backlog, and if the state of Maryland puts money in the rape kit testing fund, then and only then the state must use money from the rape kit testing fund to continue the backlog project that we've already started. As you've heard, there are 3 parts to the project: testing, which is already supported by the fund, support for victims, and investigators at the OAG to assist with investigations. All 3 of these are currently part of the project and paid for with federal money. One of the reasons that this bill requires funding off the top is that Maryland is currently delaying some work on the kits. They're testing things now. They're going to do some of the work on the kits after the test has happened. And they're doing this so they expend the federal funding. It's a good decision. But the thing is there's going to be all of this stuff that we still need to do, and we can't do unless there's funding. If there's not money, we're going to trade our untested kit backlog for a backlog of tested kits that victims don't know about and that aren't investigated. And for those reasons, we ask for a favorable report on House Bill 675.
All right, we will stay virtual for the next person who's favorable with amendments, and then we'll switch back to Ms. Banfield. So from the Attorney General's office, please.
Yes, good evening. Thank you so much, everyone, for your patience. My name is Carissa Hatfield. I am counsel to the Sexual Assault Evidence Kit Policy and Funding Committee, here in support of House Bill 675 with any sponsor amendments provided. That's why we are favorable with amendment today. We obviously are very happy about this bill. I'm also here and privileged to be here in my capacity as a co-supervisor of the Sexual Assault Kit Initiative Cold Case Investigation Team at my office. The team was created in 2023 as a result of demand from local law enforcement agencies who told us that they simply did not have the capacity to investigate their current cases and to investigate these 6,000 plus cases that Lisa Jordan just referenced. These agencies were desperate for help, and they reached out to us looking for that investigative support. We have a team of 4, small but mighty, and the 4 of us are responsible for meeting with law enforcement agencies, determining case eligibility, and deciding what cases go to the lab and what cases are investigated when they return from the lab with CODIS hits. As of Friday, my team has met with 24 law enforcement agencies and has picked up 436 cases from those agencies. That doesn't even include the 267 cases that they will pick up over the next 2 weeks. And 95 cases from Prince George's County where investigative support has been requested. If even 20% of those cases are eligible for testing, that's a caseload of over 80 cases per investigator, which is far and above any standard that would be requested at any law enforcement agency across the country. Our team's work is essential, and right now it's entirely funded by a SACI grant. If that grant goes away, these investigators' work ends, and those victims who need justice go without justice. That is why we are asking for a favorable report with the sponsor amendments on HB 675. Thank you.
Mansfield, please.
Great. Thank you, Mr. Chair. Members of the committee, Andrea Mansfield representing the... Press the button on. Oh. Now telling you. Okay. It says, please do not press the button. I'm confused now. Like, what should I do now? Okay. All right. Again, Andrea Mansfield, representing the Maryland Police Chiefs and Sheriffs Association. And I'm sorry, these are totally new, and I need to wear them, and I'm kind of very embarrassed about it, no. But anyway, here supporting House Bill 675 with amendments. And we have been talking with the sponsor and other stakeholders about those amendments. But I will say that chiefs and sheriffs appreciate the grant funding that was provided to them a couple of years ago, and they fully understand the importance of testing these rape kits. They are not concerned about or they don't dispute incorporating the additional purposes for the funding, but they are concerned that the additional responsibilities could divert money from the original intent of the fund, and they do want to ensure that dollars are available to continue testing the rape kits at the forensic labs. There's also language in the bill that removes a phrase that funds in the grant fund can be used for equipment, supplies, personnel, and outsourcing necessary for the testing, and they really do need those resources in order to test these kits and want to ensure that the funding can still be used for that purpose. So with that, we have been talking, as I said, with the sponsor as well as the stakeholders about that language. We had a conversation, I guess it was the end of last week, and we still are having conversations on those amendments. So with that, we hope to resolve all the issues with the legislation, and hopefully we can get to a supporting position. But for that reason, we're supporting with amendments. Thank you.
All right, any questions? Delegate Kaufman.
Yes, Madam Vice Chair. Have you read GOCAP's letter of information, and do you care to comment on it?
Oh, can you ask me a specific question about it? Because I know some of their concerns, but I would like to address specific concerns if you could.
I was just giving you the opportunity to address any concern you would like, but.
Oh, okay. I will say that when Ms. Mansfield mentioned about meetings with me and the stakeholders, GOCAP was present as well. And so we are all, collectively trying to work together. One thing that I would like to state is the amendment is on page 3. You don't actually have it yet, but would be page 3. And we would remove those brackets that were mentioned at G1. So the brackets where we are taking out equipment, supplies, personnel, et cetera, we would be putting that back. And we would state that the purposes are of Section C, and we are going to ask for this to be a multi-year grant so that the awardees don't have to ask each year. Perhaps they could have 36 months. So those are some of the changes that we have talked about. With respect to the role of GOCAP, they are the administrator of the fund. They will continue to be the administrator of the fund. And other than the requirements that are placed in this particular bill with adding OAG and adding MCASA and adding the peer-to-peer telehealth, those are the only true kind of mandates that we're placing. And as far as the procedures of distributing the fund otherwise would be up to GOCAP. The other requirements that are on page 2, if you want to look at it, under 2D, those would still be up to GOCAP. As Lisa Jordan testified, it is important that we make sure that we have sort of like the state funds as I'm going to say backup in case we do not receive the federal money. And we want to make sure that we use all the money that we can. And under 5, on page 3, under 5, section 1 and 2, that's why we state at 2, unless the appropriation to the fund is reduced or funding has been awarded from the national, by that national, we're talking about the federal fund, then we want to make sure that GOCAP ensures that the funds are distributed under this fund and not less than the prior fiscal year, so that it'll be a continuation and we can continue doing the work and not be subjected to the federal money if we can help it.
Thank you very much, Mr. Chair, Madam Vice Chair. Thank you for your thorough response.
Thank you, Mr. Chair. So just to make it absolutely clear, is it the intent of this bill to reduce any of the funding, current funding for rape kit testing?
Absolutely not.
Thank you very much.
Thank you.
Delegate Sample Hughes.
Thank you, Mr. Chair, and thank you, Delegate, for the bill and your continued work on this effort. I often go out and talk about the bill you worked on last year of how, it's really making access available to persons. I did want to get clarity on something. This is based on a couple emails that I received. Is there a proposed reduction to the Victim Services Fund and that $4 million of that would affect this?
Yes, and well, it wouldn't affect this, but I would let Lisa Jordan, if you don't mind answering that question, if you feel comfortable.
Yeah,
If you heard it.
thank you so much, Delegate, for that question. There is, in the proposed BRFA that will be heard later this month, there is a proposal to reduce some of the funding in the rape kit testing fund. But I think what's important is that the question between Delegate Crutchfield and Vice Chair Bartlett is that there's enough money in the fund right now to fully fund what has already been requested by local law enforcement. They have unexpended money in the fund at the end of fiscal year 24. If you look in the fiscal note, they said $3,975 and change was unexpended. So that's unexpended built up money. And then there's another $3.5 million that is added into the budget. And then there seems to be an attempt by the governor to take some of that money back. Right. And that I think that is still subject to the negotiation between the Budget and Tax and Appropriation Committees. So I suppose it's possible that Governor Moore intended to completely wipe out the fund and have no rape kits tested. But I hope that that's not the case. And I suspect that the legislature would weigh in on that. But let's pretend that does happen and there is $0 in the rape kit testing fund. That would mean that Ms. Mansfield's clients wouldn't have anything. That would mean that the OAG wouldn't have anything. That would mean the victim notification would not continue. So there's no actual mandate that you put the money in there. What this bill does is it says, if Maryland puts money in the rape kit testing fund and the feds don't come through with more money and there's still untested rape kits, then GOCAP must continue to fund the OAG's office and the victim notification office. And if they do that, for context, that's $430,000 a year of a fund that has 3.9, almost $4 million of unexpended money and another 3.5 allocated to it. So this is a really very small but important piece of what is currently being done and saying, let's keep this going. And I suppose, yes, you as the legislature could choose to completely wipe out the fund, but I suspect that that's not going to happen. And you've got 3.5 in this year's budget and 3.9 in unexpended money to play around with there. So that's certainly much more than what the governor is proposing of pulling the $4 million out of the fund. I hope that was clear. I know between the BRFA and the budget, it's not the part of the pool we usually play in the Judiciary Committee, but I'm certainly happy to answer questions if I can.
Sure. Thank you for that explanation, because the average citizen would not have, or they don't see it like that. You know what I mean? Talking about what's existing and what may be able to be used, et cetera, et cetera. So I just wanted to make sure I was answering these concerns properly through the emails. My last question for you is, with the money that is there and monies that we may be able to use next year, is there a specific number of kits that are able to be tested based on that amount of money? Meaning, like, I was just listening to the testimony where, and I forget your name, I'm sorry, but you indicated that you picked up 236 kits and you're gonna possibly pick up a certain number or more. Is there a certain number that they're able to be tested based on the budgeted amount? Does that make sense? Of you're only able to do 100 kits at $3 million?
Right. So with the even with the number of kits that we have in our possession right now, if all of those kits, say we pick up we have the 703 and every single one is eligible for testing, $3 million is way more than enough to test 703 kids.
Way more, okay. Okay, all right. Thank you very much.
Thank you, panel, for coming in, delegate, for coming in to testify. So in my opinion, there's some bashing of the governor. If you have $3.9 million and you have, 6,000 kits that have not been tested, why are they not being tested? Why will somebody choose which kits are being tested and which kits are not, versus just blanket test all the kits?
Delegate, that is a good question, and that was one of my first questions when I first came to the Sexual Assault Evidence Kit Committee. I just thought, why not test them all and just be done with it? But the committee actually, I've come to understand that the reason why we don't just test them all is because, and I'm gonna let Jane.
Now, I would like for you to finish because you're not working.
No, the reason why I said that is because I didn't want to get into we don't have our forensic nurse here today, and I didn't want to get into the science of it all, but that's the reason why we don't. Some is because we already know we may or may not know who the perpetrator is. So if we know who the perpetrator is, I think in those instances, they go in one category. If we don't know who the perpetrator is, then they go in another category. If we need to, if there's, if sometimes we've gotten the kit, but the victim says, I don't want it to be tested, that goes in another category. So it's not a simple answer as just test them all, because I thought the same thing. Just test them all, not lock everybody up, but kinda, but go after everybody and be done with it. But it has taken years because it's not always, the evidence is not always readily available to test in the way that we would be able to put it in CODIS and get a hit, et cetera, et cetera. I did a horrible job of explaining that, and I told you I would, but I did my best. If anybody else wants to explain the science of it all, then feel free.
Okay, well, since you said that, Ms. Jordan, how many kits do you think legitimately need to be tested?
I think that's really been one of the frustrations we've had in Maryland, Delegate, is that the General Assembly required a tracking kit. It was paid for by or a tracking system that was paid for under the 2018 grant, but the system is not yet up and running. So we actually don't know the full number of kits that are left to be tested. We started at 6,000. We had additional kits found at the Department of Public Safety, and between 800 and 900 kits have been tested. So in my view, it's very likely there are still thousands of kits left to be tested. And it's important, Delegate, I'm sorry, I don't mean to interrupt you, but I do want to make sure that you understand that it's not just the testing. So that kind of was my first thought also, that, hey, it's a box, you send it into the lab, you get it back. But it's finding the survivor, if they had consensual partners, it's finding, it's making sure that we're testing the right contents. It's doing an investigation. It's finding out if someone signed a waiver, do they still want to have things tested? And then, as Ms. Hatfield described, you have the investigators at the Office of the Attorney General also working on this, because, the goal is not to test kits. The goal is to find perpetrators and prosecute them and follow the desires of survivors. So although we say test the kits a lot, it's actually a much more involved process.
Okay, well, I would disagree with you, because I think some of the victims want their kits tested. So my question is, if a person feels that they're a victim and they want their kit tested and they want it tested now, this year, I've been working on this for 10 years? Mm-hmm. So I'm familiar with it. Can that person pay to have their kit tested?
They cannot pay to have their kit tested, sir. And I know you and I have talked about this before. However, there is a victim notification hotline and there's a victim notification email. And if they reach out and they contact Ms. Jezik and her notification team, then their kit will kind of move to the top of the line and will make efforts to make sure it's tested in a way that can be used in court, because that's what we want to do, is make sure that people have options.
Well, that's what you want to do, but the one of the members on your panel said that they choose which kits are going to be tested and which ones don't. And if it's one victim that wants their kit tested, I think they should be able to have their kit tested. So I thank you very much.
Further questions?
I think Ms. Hatfield wanted to say something.
Yeah, I just wanted to clarify in terms of what our team does in relation to screening kits for eligibility for testing. This isn't them making decisions based on their whims or any other situation. There are statutory exceptions to testing that exist in Maryland. So they review each kit to determine if it meets a statutory exception as defined by the statute. And then that is the reason a kit is sent or not sent for testing. We are not just picking and choosing which kits to send.
I take that back. I misunderstood. So therefore, all the kits that Ms. Jordan is describing are, I guess, not eligible for being tested. So
that's not at all. So these
not
kits,
true
we
either,
still have to go through. There are cases that have never been reviewed by the local agency. There are agencies that are not currently engaged with us, or our investigators are not reviewing those cases at this time, but we look to engage those agencies in the future. And so those cases may just not have been reviewed yet. It doesn't mean they won't ever be tested.
Sure. I don't think that's fair to the victims, but I thank you.
Further questions? Seeing none, thank you all very much. That concludes the testimony on House Bill 675. Last two, everybody. House Bill 591. Delegate Embry with Franz Schneiderman and Thomas Webb from the city.
He's online.
All right, and I know that Mr. Wiggins is in the back there waiting to testify in opposition.
He is.
We'll leave him right there for now. Lurking. Right. Delegate Embry, please, 3 minutes.
Thank you, Chair, Vice Chair. Oh, no, Vice Chair. Well, thank you, everyone else, for. Oh, Vice Chair. And thank you all. It's nice to be in a warmer part of the room. It is actually warmer. So I just want to say, to start off, this is a bill that passed identical to what passed unanimously out of this committee and out of the House last year. It did not move in the Senate. So this applies to consumer protection actions brought by localities. Baltimore City, Howard County, and Montgomery County currently have local laws and assigned lawyers who can bring these actions, similar to what the Attorney General's office does at the state level. But their default statute of limitations is 1 year. And so this bill would increase it from 1 year to 3 years so that they would have time in complex cases to do a full investigation and not be limited in what they can bring forward. I just want to talk, the opposition is centered on just a phrasing within the bill, not the entirety of the bill. I think that's a fair statement. And so I just want to explain the reason for the language. So it says the consumer protection suit shall be instituted within 3 years after local authorities knew or reasonably should have known of the violation. And that's the point of contention, and Mr. Webb from the City Law Department can speak more to this, but this language tracks the language for civil actions generally and consumer protection actions in case law. It's also codified for environmental actions brought by the Department of the Environment. It's also in Delegate Hutchinson's bill, which was, we heard earlier, HB 616. And the reason for it is the state is not the victim in these consumer protection actions, usually. I mean, they could be, I guess, as well. So they can't know about it unless they're told. So this language is necessary, that they knew or reasonably should have known, because it's consumers that are hurt typically in these actions, and the state has to be notified by them. So I think the language is really important, although I certainly respect the opposition for their concerns. So with that, I will stop speaking and turn it over to the panel.
I guess the panel is me. Hi.
There's one more.
Oh, I'm sorry. Hi. Hi, I'm Franz Schneiderman, Consumer Auto Maryland. We work with I'm a consumer advocate, work with a nonprofit that's dedicated to transparency and protection for Maryland drivers and Maryland consumers. Here in strong support of the bill because we think it gives, the consumer protection groups that we have in various counties in Baltimore City just a fairer and more appropriate chance to enforce the law and to protect consumers. The 1-year statute of limitations, it just isn't a very long time. Often it takes a while for fact patterns to emerge. There are complicated issues involving a number of plaintiffs or a number of consumers affected, so it can take a while to mount litigation for the fact pattern to become clear. 3 years gives people a much more adequate opportunity to mount the kind of litigation needed to protect consumers. I'd also say, I know there's been some concern that this creates a long period of time. 3 years is the standard statute of limitations for recovery in consumer litigation cases in general in the state, so it seems fair to apply the same standard to the consumer protection units, and it's certainly not an endless, an endless statute of limitations that makes people liable forever. So support the bill. Hope you'll give it a favorable report. Happy to respond to any questions. Thank you.
Mr. Webb, please.
Good evening, all. Tom Webb, Chief Solicitor from the Baltimore City Law Department and head of our Consumer Protection Division. Thank you all for staying late in the snow to hear a bill that is really, really important to us and important to our work. The city passed a local consumer protection law late in 2023. And just for a bit of background, what that law does and what all consumer protection law does, it allows us to bring enforcement actions against unfair, deceptive, or abusive trade practices that harm Baltimore City citizens. As Delegate Embry and others have said, what this bill does is it just brings the statute of limitations for those actions in line with what we already have for private civil actions under the Maryland Consumer Protection Act, and also for government enforcement actions in other areas in Maryland law. As Delegate Embry said, we have already, the Maryland Department of Environment has 3 years from when they knew or should have known of the date of the violation to bring their actions, and we're just trying to make this consistent. And I think it is really, really important here to have that discovery rule language, which is, again, already what's found in Maryland common law. A plaintiff has 3 years in a civil action from when they knew or should have known, and it's kind of doubly important for our work. If there's a citizen out there who is harmed by an unlicensed home contractor, we don't know about it. Right? We rely on citizens' complaints. We don't know about these things unless we're told about them. And sometimes private citizens also don't know about the resources we offer until they're told by a neighbor or a friend that they can come to us for help. So what this law does and what the discovery rule language does in particular, it means that we are not handicapped when we don't know. That when a private citizen comes to us more than a year after or even more than a few years after, we can still bring those actions to protect them and to enforce our bill. And it really just brings us consistent with the rest of the law in this really, really important area. Thank you, and I urge your support.
Questions for the panel? Delegate Williams.
Thank you, Mr. Chair, and thank you, Delegate Embry, for bringing this bill. I don't know if Mr. Webb was finished with his comment, but my question kind of sort of touched on kind of the end of what he was speaking about the, oh my goodness, knew or reasonably should have known. I see the written testimony from the opposition seeking, I guess, to replace that or amend that with after the offense was committed. And I don't know if you have a comment with regards to kind of the suggestion of changing that nomenclature to after the offense was committed versus what you have currently in the bill with regards to knew or reasonably should have known.
Thank you for the question. Right. It just isn't practicable because whenever the state is bringing an action on behalf of others, they can't know it until they're told. And so the offense, when the offense happened, may have no relation to when government is actually able to take action. And as Mr. Webb said, sometimes even the person who's affected by it might not know. They might not have understood the contract that has subjected them to some unlawful deceptive practice. So it may not even be immediate that they realize that they've been harmed, which is why, again, even in tort claims law, it recognizes that the person impacted can argue that they actually couldn't have known when it happened. And that's not even putting, that's not even when we're talking about government having to bring the action. And there's another layer where, again, they literally could not know until they're told. So this, as Mr. Webb said, this brings us in line with what is already law for consumer protection actions at the state level and what is the general rule for a discovery in civil actions.
Mm-hmm. And Mr. Webb, I didn't know if you had anything you wanted to add because you were.
No, I think Delegate Embry got it exactly right. The only thing I would add there is this isn't carte blanche either, right? I mean, if the government is told about a violation, then we have 3 years from that date. If something is, it still leaves an opportunity to someone who is the target of an enforcement action to argue that we reasonably should have known, right? There's a reason why that language is in there. And again, it applies to private plaintiffs and government enforcement bodies. So it's not simply carte blanche. We would need to show that we either didn't know or we need to demonstrate that we reasonably really could not have known. But there is always an opportunity for a target to come forward and make the argument that we either did or we should have known as well. So I don't want this to seem like it's kind of carte blanche to bring these actions whenever we like. It just kind of gives us, I think, that reasonable protection in instances where we truly could not have known an action, that a violation had occurred. We really don't want to be hamstrung in those situations, and that this protects us there.
Okay, thank you.
Seeing no further questions for this panel, thank you all very much. We'll go to the one person testifying in opposition, Grayson Wiggins, who will come up. We'll hear from him for 2 minutes. Mr. Wiggins, please.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. It's getting late and the snow's getting deeper, so I'll be quick. So I think that I do want to thank the sponsor for meeting with us prior to the hearing. We would like to continue to try and work on this. The primary issue here for us is, and one thing that wasn't really talked about previously, is the criminal aspect of this. So Baltimore City has criminal provisions in their consumer protection statute that was enacted about less than a year and a half ago. And so there's concern that, as Mr. Webb stated, an individual could be aware of something that allegedly occurred, and that multiple years, I think his quote was even more than a few years after that, they could then report it to the city, and the city could then bring criminal charges against a business or an individual working for a business. And so that's where I think the rubber hits the road, so to speak. I would also just note that yes, this is delineated in the environment statute, but the only reference that we could find to it being ceded to a local jurisdiction is for certain environmental violations in the Chesapeake Bay critical zone of Talbot County. And so otherwise in the statute, there are significant references to the statute of limitations beginning when the offense is committed. And additionally, I think Mr. Webb touched on this as well, that under the current civil side of the issue, the statute of limitations begins to run when the plaintiff knew or reasonably should have known, and not this third-party law enforcement entity that would be the city in this case. So given the criminal penalties, given the very limited reference to this for a local jurisdiction, and the fact that there's a plaintiff and a third-party aspect here, that's where the concern's coming from. Thank you.
All right, I don't see any questions for you, so thank you very much.
Thank you, Mr. Chair.
That concludes the testimony on House Bill 591. The last bill of the evening. Last bill. No bills after this one.
Is this the last?
This is the last bill. Just her. Just her, but I thought she was bringing somebody else that we could torture.
So,
No?
all those folks are
They
no
took
longer
off?
available.
Oh.
Yeah, I had my intern was originally going to present this bill because it's a simple bill. And
leave her at
she
that
had
point.
to leave.
Start the clock.
Yeah, you can start the clock. My intern had to leave on the 2 o'clock last shuttle back to University of Maryland because of snow. And Joshua Hatch, who is the chair of the task force, had to leave as well. He waited around till 6 o'clock. So anyway, he's gone. But good afternoon, Chair Clippinger, and the best committee
Ever
in the entire world. For the record, my name is Delegate Kim Taylor, representing Prince George's County's District 23. As you remember, during the 2024 General Assembly session, House Bill 1037 established a task force that examines reentry services in the state and the feasibility of creating a division of returning citizens within the Department of Public Safety and Correctional Services. Well, the task force began its work in October of 2024, and it quickly became evident that the scope and amount of work needed to adequately address the needs of Maryland's returning citizens will require time beyond the report due date. I come before you today presenting House Bill 646, which simply requests an extension on the original submission deadline of the task force report from December 31st, 2025 to October 31st, 2026. This extension will allow for a comprehensive assessment and thorough report from the task force regarding the governor's commitment on successful reentry and reduced recidivism. Thank you so much for your time.
Anyone have any excruciatingly 14-part questions for this witness? All right. Yay. Seeing none, thank you very much.